Fresh matter for tomorrow, my lord. Family court matter.
My lords, may I make a mention, my lord?
Yes.
Serial number 57, my lord. It's a case while I have been convicted under section 302, my lords, for life imprisonment till my rest of my life. Kindly, a date may be given after 10th, my lord, and it may be listed at 230 list, my lord. And another two matters of the same nature, my lord. It may be tagged along with this matter, my lord.
230 angalam kodakkagagodilla. Serial number 57.
Yes. For life imprisonment, for up to end of life, it has been awarded, man. Under 302, man.
For final hearing,
Yes, my lords. So that I can appear physically and argue before my lords.
Serial number 57.
And another two matters of the same nature, my lord. My colleague is standing before my lords, I think, my lord, of the same nature.
ಎಲ್ಲ ಒಂದೇ ಸರಿ ಎಲ್ರಿ ಆಗುತ್ತೆ, ಸುಮ್ಮನೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಪ್ರಯೋಜನ ಇಲ್ಲ. ನೀವು ಒಂದು ರೀಚ್ ಆದ್ರೆ ಅದನ್ನ ಏರ್ ಮಾಡೋದೇ ಕಷ್ಟ. ನೀವು ಮೂರ್ ಹತ್ತಿ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ಸ್ ಸಾಧ್ಯನಾ?
ಅಲ್ಲ, it has been
not possible, sir.
Same order by this honorable court, my lord, and it has been
at the request of learned counsel for the appellant, release this matter on. When do you want?
So after 10th, at any date, my lord, kindly may be had at 230 list, please.
After 10th?
Yes.
ಆಯ್ತು, 11th of December.
230 list, please.
230 ಆಗಲ್ಲ. Yes.
One matter for end of the list, your lordship. Honorable learned single judge has dismissed the writ petition. I am for the petitioner. Your lordship, direction has been given to the Registrar General to register a criminal complaint, and 1 lakh cost has been imposed, your lordship. 1 lakh cost has been imposed, and Registrar against the petitioner, your lordship. And Registrar General has been directed to your lordship to register a criminal complaint against the petitioner also.
Why?
Your lordships, on the basis that the document, it is a matter with regard to demolition of a structure, your lordships. We are petitioner has produced a document of acknowledgement, your lordships, of the municipality for seeking application for construction permission, your lordships. They have produced the inward register on the day, your lordships, saying that the inward register number and the acknowledgement number mentioned in the acknowledgement is not matching. On the basis of that, your lordships, they are not disputing the sale, your lordships. Now, on the basis of that, your lordships, criminal complaint has been directed to be, your lordships, registered against the petitioners.
Tomorrow. Yes.
Serial number
56,
Yes.
my lord. Serial number 56. I inquired in the office, my lord. They are telling that paper books are not there for me. Complainant has taken one paper book and the state has collected one paper book. I need the paper book in the directions may be issued. I've inquired in the office, my lord. No paper book has been. Complainant, my lord. I'm for the accused in this matter, my lord.
Accused, appellant or respondent?
I'm respondent, my lord.
Respondent.
Respondent.
Learned
State
counsel
appeal.
for the appellant is Mr. Santosh Patil.
Connected case.
State.
State appeal also.
56 state appeal.
State appeal.
56.1.
I have to collect
Not
paper.
possible now, we'll see, man. Yes.
Serial number 54 on behalf of respondent.
ಅವ್ರು ಬಂದ್ಮೇಲೆ you are request him, and if he gives, please collect it. Yes.
Serial number 54.
I
am for respondent on behalf of Shivanam Patil, sir. He is not came today, my lord. Kindly day after tomorrow. 54, my lord. I am for respondent, my lord, on behalf of Shivanam Patil. 54, my lord. Final hearing. I go for respondent number 5.
ಮೂರ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
ಅದೇ day after tomorrow ಇವತ್ತು ಶಿವಾನಂದ್ ಪಾಟೀಲ್ ಸರ್ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ day after tomorrow.
ಯಾರು ಬಂದಿಲ್ಲ?
ಶಿವಾನಂದ್ ಪಾಟೀಲ್. Day after tomorrow.
Yes, what do you say? Serial number 54. At the request of learned counsel, Shri Shivanand Patil,
Respond number 1, 2, 3 first.
release this matter
Day after tomorrow.
on 27th.
Lord, serial number 58 minutes. 58, sir.
Ah,
1 week time, my lords.
serial number 58 at the request of learned counsel for the appellant, release this matter on 2nd of December.
Bless.
Yes.
My lord, serial number 37. AAC will argue the matter, my lord, it will be taken.
I am the contesting
Next week.
respondent in
Hmm.
2 matters.
Ah,
Last occasion lordship date fixed this day. They have taken 2 times, each time they are saying AAG has to come.
so you have come from Bangalore all the
Yes,
way for that?
yes.
Not possible. Yes. Please ask him to come. Yes.
Non-compliance of office objections for 6 times. CL number 1, Chaitanya Kumar Chandriki.
6th time.
2 days, my lord.
Huh?
Copy to be served, other side. Kindly, 2 days.
Finally, a week's time is granted at the request of learned counsel for the appellant for complaints of office objections. Yes.
Order CL number 2, Basappa K. Bhavshakti.
Yes.
Case, my lord, the first respondent has to file, my lord, the wakalat.
Huh?
First respondent, respondent 1 LRs, my lord, the,
Non-filing of wakalat for respondent for 1A and
since
R1C.
the advocate appointed now designated senior counsel, my lord, therefore wakalat.
Yaru? ಏನು? Huh? ಅವ್ರ colleague ಹೆಸರೇನು?
Ganesh.
Office is directed to show the name of learned counsel Shri Ganesh Subhash Chandra Kalaburagi for response number R1A and
C.
C. Release this matter on 2nd of December. ಏನಕ್ಕೆ ಬರ್ಬೇಕಿದು? Final hearing.
For admission, will not.
For admission, 2017 matter.
Please, my lord. Steps serve ಆಗಿರ್ಲಿಲ್ಲ. Meanwhile, your lordship may kindly call for records, my lord, the partition suit, this is.
R4. R4 against dismiss ಆಗಿದೆಯಲ್ರಿ?
Please, my lord.
Application ಹಾಕಿಲ್ಲ.
Application of party ಬರ್ಲಿಲ್ಲ, therefore.
ಮತ್ತೆ what is the use then?
He is also one of the
How
brother.
can you continue the appeal only against the other suit of partition?
He is also one of the brother, my lord, the all.
So we will dismiss the appeal itself. You have not even taken steps to bring him on record now.
He is a age-old person, my lord. He is residing in, my lord.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ sir? What can we do for that? Can we go on with the matter like this? Huh?
Against R4 dismiss, my lord, other.
Suit for partition, sir. What will happen?
Meanwhile, second,
ಆಯ್ತು, second ಹಾಕೊಂಡಿದೀವಿ. If you don't answer properly, we will dismiss the appeal.
please, ma'am.
Yes.
CL number 3, Sandan Basu of D party.
Yes.
I beg to appear for the,
Kindly pass over, my lord.
my learned friend,
Pass over. Pass over.
will appear for Mr. Ravi Patil.
Ah.
It may kindly pass over, my lords, after the preliminary hearing matters subject to the court's convenience, to make submissions for the final disposal.
ಮತ್ತೆ ಪಾಸ್ ಓವರ್ ಆದ್ರೆ ಆಮೇಲೆ ಮತ್ತೆ ಬರುತ್ತೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ.
ನಮ್ದು ಅಡ್ಮಿಷನ್ ಸ್ಟೇಜ್ ಆದ್ಮೇಲೆ ಅಡ್ಮಿಷನ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ
ಏನಾಗ್ಬೇಕಾಗಿದೆ ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ?
ಈಗ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಮಾಡೋದು, ಯಾಕಂತಂದ್ರೆ ಒಂದು custody of the minor girl child is refused by the family court and mother is in appeal. And the husband's petition for divorce is dismissed and the husband is in appeal in the corrected appeal. And from 2019, the husband and wife are living separately.
ಪಾಸ್ ಓವರ್
Expect after the premise, subject to the court's convenience.
Serial number 4, KM got it.
Respondent number 2, 3 and 4. First occasion, my lord, your speech
Respondent
directed.
5 and 6, my lord, they have not submitted proposal till today. Last time it was very strictly order. They have to file the affidavit.
Lords, we have given on 12th of November. ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಅಂತ ಲೆಟರ್ ಕೊಟ್ಟಿದ್ವಿ ಆತ.
ಅದಾಯ್ತು. What happened? The government
But
advocate.
he has to send the proposal. Kindly see para 2, my lord, on the order dated 16/10/2024. my lord. Second para, my lord. Accordingly, learned counsel for the respondent 5 and 6 today filed a memo along with their survey report showing the extent of land utilized for purpose formation of road. Learned counsel would however submit that the assistant commissioner with the district will have to be determine the compensation payable. Then, my lord, this is important. If that be so, respondent number 5 and 6 are required to immediately forward the report along with request from the respondent number 5 and 6 to the assistant commissioner. They not send the request to us, my lord.
ಅಲ್ಲ ಕೊಟ್ಟಿದೀವಿ 12th ಕೊಟ್ಟಿದೀವಿ. They have issued.
Determination that request ಕೊಡಬೇಕು.
They have issued it, seal ಇದೆ.
Officer is also here, my lord. Internal communication, my lord, by the department only. That is, the officer is also here only.
Assistant executive engineer has sent it to the executive engineer.
ಅಲ್ಲ ರಿಸೀವ್ ಕಾಪಿ is received by the IC office.
Copy ಅಂತಂದ್ರೆ-
ಕಾಪಿ ಟು ಅಂತ ಹಾಕಿ ರಿಸೀವ್ ಮಾಡಿದ್ರೆ IC office ಮಾಡಿದ್ರೆ.
ಅಂದ್ರೆ
ಅಲ್ಲ ದಟ್ ಇಸ್ agreement.
that is why he is saying there is no communication.
ಅಲ್ಲ ಬಟ್ ರಿಸೀವ್ ಮಾಡಿರೋದು ಆಫೀಸ್ ಸೀಲ್ ಇರೋದು.
ಹೌದ್ರಿ, it is a communication, only copy you have sent.
Yes, sir.
Where is the request for determination of compensation?
That is not there. ಅಷ್ಟು ಮಾಡಿದ್ರೆ.
Huh?
I agree, my lord.
Then what did he say last time? What did he say? Why are you wasting time like this?
By today itself we will give my lords to the agent. ಇವತ್ತೇ ಕೊಡ್ತೀವಿ.
We also have said your response is already lacking. But still you do the same thing. Learned government advocate submits while referring to our previous order dated 16/10/2024 that response number 5 and 6 were directed to make a request to the assistant commissioner for determination of compensation. Full stop. However, respondents number 5 and 6 have not sent any such request to the assistant commissioner. Full stop. Next para. Learned counsel for respondent number 5 and 6 submits that a request will be sent to the Assistant Commissioner either by today or tomorrow. Full stop. Release this matter on 2nd of December.
Please.
Yes.
CL number 5, government advocate.
Yes.
Kindly pass over, my lord, this. I
They are
will
not
forward the
served
copy to
next
the other side, my lord.
Hmm?
Otherwise, your lordship, I have tomorrow, my lord.
Yenidu?
Urban Development Authority, that scheme itself is lapsed, my lord.
Huh?
Scheme itself is lapsed
Yen scheme?
for,
50-50 scheme anti 2010 ನಲ್ಲಿ it was introduced by the state government and we also introduced. I appear for the Urban Development Authority Vijayapura. And the scheme under 27 and the 36 of the Lord, the act, within 5 years it is to be implemented. If not implemented, the scheme gets left. In view of that, we used to issue endorsement saying that any conversion the orders comes from the deputy commissioner, we used to refuse the approval of that on the ground that it is included. Therefore, the orders are passed quashing that endorsement and we were directed to reconsider it and if otherwise they are eligible, it is to be approved. Then, my lord, there was a direction by the learned single judge to the state government directing to inform all the urban development authorities wherever such schemes have lapsed, ask them not to issue such endorsement. That was the direction. That also direction has been now challenged.
Status
House.
filed this appeal.
state filed.
Huh.
And subsequently, my lord, the another thing has happened is that the scheme itself has been passed on the ground that it was only preliminary notification, no final notification was passed under 18 of the Urban Development Authorities Act. Delay control next week for admission.
What is the ground on which you have filed the appeal?
Kindly missing, my lord. Kindly pass over, my lord. Otherwise, tomorrow, my lord, serve the copy. Even I not serve the copy to the. Sorry.
Huh?
I not serve the copy, my lord.
Sorry. What is the ground on which you have filed the appeal?
File misplaced again, sir. That is the problem. Handicap.
Explain more of you. ಈ ಡೈರೆಕ್ಷನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಇವು ಹಲವು ಆಗಿದ್ದಾವೆ. ಈ ಲ್ಯಾಬ್ಸ್ ಆಗಿ 50-50 ಅದನ್ನು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿ ಎಲ್ಲರಿಗೂ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Court has directed the secretary to issue on the concern. Okay, scheme itself has been lapsed. Scheme lapse of the.
We'll have this day after tomorrow.
Please.
Either you come prepared or you get the learned AIG to argue the matter.
Please.
We will consider and dispose of this appeal.
Please.
At the request of the learned government advocate, release this matter on 27th of November.
CL number 6, Deepak V. Barat.
Contempt has been filed, not the.
Huh?
Contempt petition is filed for disobedience of.
They have filed writ appeal.
Yes.
So we'll take up the writ appeal. Where is Mr. Shivkumar Tingli?
Shivkumar Tangli, writ appellant.
He continues as a government advocate?
But
Illa.
is the private.
Allah sari, he continues as a government
Yes,
advocate?
yes, Lord, you continue.
ಮತ್ತೆ ಯಾರೋ ಏನೋ ಬೇರೆ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಹಾ? Ask him to come.
Please.
Pass over.
Seven, additional government advocate.
This matter.
Yes.
My lord, one compliance is pending because affidavit is filed, annexures are not sealed and not signed, and
Ah.
kindly grant 2 days time will make necessary.
ಏನ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಹಿಂಗೆ ಟೈಮ್ ತಗೊಳ್ರಿ.
ಇಲ್ಲ, 2 days time may be granted.
Ah.
Within 2 days I will comply.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಅಫಿಡೇಟ್ ಮಾಡಿದವರು ದಟ್ ಟರ್ಮ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ಓವರ್. ದಟ್ ನೋಟ್ರಿ ವಿಟ್ ವಾಸ್ ಅಟ್ಯಾಚ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ, ದಟ್ ಟರ್ಮ್ ಇಟ್ಸ್ ಇಸ್ ಓವರ್. ನಾವು ಮಾಡಿ ಹ್ಯಾವ್ ಟು ಫೈಲ್ ದಿ ಫ್ರೆಶ್ ಅಫಿಡೇಟ್, ದೆನ್ ಓನ್ಲಿ he will attach the documents ಅಂತ that is the information.
Finally, a week's time is granted at the request of learned government advocate for complaints of office objection.
My lord, date may be fixed, compulsory retirement.
If office objections are complied, list this matter for admission.
Serial number 8, Mahesh Patil.
Kindly pass over, madam.
Yes.
Senior counsel is on the line, madam. Wait.
Hmm?
Kindly pass
You
on.
know?
But in this matter, my lord, we filed the, my lord, appeal.
Yes. We have noticed your submission last time.
Yes, my lord, that is stepdaughter, my lord.
Stepdaughter, yes.
She is not entitled, but in the provision, my lord, daughter anta ಹೇಳ್ತಾರೆ. That is the, there is a provision, my lord, only daughter is, my lord, entitled.
We had asked both of you to prepare and come.
ಹೌದು.
Huh?
ಹೌದು ಸರ್, ಸೀನಿಯರ್ ಅನದರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
Pass over ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಹೌದು ಸರ್.
Pass over.
Day after tomorrow, you ask. Day after tomorrow, my lord. This
Yeah.
one also. Adra ಇದರಲ್ಲಿ that provisions also there, and also, my lord, there are
Correct.
supporting
That is why
judgments.
we said, we have noticed this is the contention, so please come prepared for argument.
Yes,
Ah.
ಅದರಲ್ಲಿ ಓನ್ಲಿ ಕ್ವಶನ್ ಇಸ್ ಸ್ಟೆಪ್ ಅಂತ, ಸ್ಟೆಪ್ ಬಗ್ಗೆ ಇಲ್ಲ.
ಅದೇನೆ.
That is a-
ಅದೇನೆ.
ಅದು ನಮ್ ಇದ್ರಲ್ಲಿ ಇತ್ತಂದ್ರೆ we have to.
He has come prepared with judgments, let us see.
ಹೌದು ಸರ್. Kindly to
Pass over.
Serial number 9, Ravi B. Patil.
9, my lords, I am appearing for the learned government advocate for the accused here. My lords had heard my preliminary submissions and had now passed an order directing us to file our statement on our reply affidavit. We have, my lords, I have instructions to submit that. The reply affidavit is almost ready, my lords. We have to secure few more instructions to finalize it. If your lordship should grant us a little more time, we will file the reply affidavit and also matter could be proceeded. There is a pending writ petition in which an interim order is passed, staying the issuance of a notice to the complainant. And the documents are produced to show that before the interim order was passed, there was a final order already passed by the authorities, which is also now challenged by the very same complainant in the pending writ petition by way of an amendment. Now, my lords, some documents are also filed by my friend, and a reply affidavit is filed by him. Counter to the affidavit is filed by him. We have received the counter. Nonetheless, my lords, probably there is some miscommunication. Government advocate, I was not able to secure the documents which are sent by the complainant to the government advocate's office. I will also look into them and the counter which they have served it on 8th of November. And thereafter, my lords, the reply is to be finalized and filed.
The senior counsel, Shri Amit Kumar Deshpande, appearing on behalf of the respondents, submit that the affidavit as directed by this court is ready, but there are a few documents which are to be filed along with the affidavit. And the respondents would require 2 or 3 days time to secure the same and file the affidavit. Full stop. Next para. Release this matter on 2nd of December.
I'm grateful.
Please.
Serial number 10, GG CH-2.
Yes, I appear for respondent number 2. I seek for a week's accommodation to file my reply to the contempt petition, my lord.
Reply.
Yes, my lord.
This person's house was demolished by the.
I will file reply to that, my lord. We have not demolished that house. We'll file reply along with all the documents.
I have produced the copy, but reply.
A week's time is granted at the request of learned counsel for the contesting respondent to file
Necessary objections, my lord.
objections to the petition.
Please.
Release this matter on 2nd of December.
Please.
Serial number 11, GG CH.
ಎರಡು same, huh?
Both are
Same,
same, my
same.
lord.
10,
Same.
11.
My reply is ready, my lord. I will be filing in the.
ಮಾಡ್ಬಿಡಿ.
Serial number 12, Ravi B. Patil.
This matter, my lord, we filed the writ appeal, my lord, that is writ appeal number 2,268 of 2024, man. This is the Inam land, my lord.
Learned government advocate submits that the respondents have filed a writ appeal.
2,268 of 2024, man, FR number
200
268 of 2024.
268
Please,
of 2024.
24, FR number.
Similar writ appeals, my lord, being disposed of, your lordship. The deemed conversion and similar writ appeals. which are-
This is Inam land, my lord, not Waqf board. It is Inam land.
Ah.
My learned friend is saying that,
Really?
my lord, it is a my
Be
lord
on time.
Waqf property, that is, my lord, finality before the Supreme Court. This is the Inam land.
Hmm.
That's why, my lord, we filed the appeal, my lord. That you will also post this matter along with the writ appeal, my lord.
How is his name entered in the RTC?
That's why, my lord, that we explain all those things, my lord, that is the, even though, my lord, that is without noticing that one, my lord, that one, within the time we are not rejected that, after that, my lord, we rejected that. Now, my lord, taking deemed provision, my lord, directed us to issue the conversion. That is not permissible. Even, my lord, website that, even computerized also, my lord, they will not accept that one also because it is a Inam land. That is a problem.
How can you now contend, sir? It is Inam land. You have not taken steps to see that his name is removed first from the RTC.
That is, my lord, explain, my lord, writ appeal, you also direct the office to post up that writ appeal also.
List WA number so and so along with this matter on 2nd of December.
Please. Serial number 13 is parallelly.
Yes.
I have instructions to undertake to file power on behalf of accused number 2 and 3, my lords.
Learned counsel
Manvendra Reddy.
Manavendra Reddy,
Please.
undertakes to appear for
Accused number 2 and 3, my lords.
respondents number 2 and
2
3.
and 3. It could be fixed, my
So
lords.
direction to initiate the issue an appointment order as assistant professor in the community medicine. So far, they have not taken any steps to issue appointment order.
I'll get
And
instructions.
the writ appeal file details also came to be dismissed and confirmed the order of the Lawrence.
Writ appeal also dismissed.
Yes, ma'am.
Matte?
And the specific direction of last, it is needless to mention that the responsive shall take immediate steps for issuing an appointment order.
Writ appeal.
Lord, page 39. Lord. Operative portion at page 56.
A week's time is granted
Please.
for filing wakalat.
Please.
Full stop. Release this matter on 2nd of December.
Please, my lords. Oblige.
Serial number 14, Mahantesh Patil.
Lords 14, I beg to appear for the impleading applicants. Lords, I am duty bound to bring to your lordship's kind notice that in respect of, my lords, the same or identical case at orders, where, my lords, the direction issued by learned single judge has been followed, the writ appeals, my lords, and connected writ petitions are part heard before the principal bench in Bangalore, in fact, are listed today. I am also appearing in that matter for the candidates. That is writ appeal 1218 of 2023 and connected writ petitions, my lords, listed at 2:30 today. Since that matter, my lords, is at some advanced stage of hearing, I felt duty bound to bring to your lordship's attention that it's an identical issue.
Senior counsel Shri Aditya Sondi appearing in on
I appear for the appellant.
impleading
There
applicant.
are two cases of teachers also which are in the batch in Bangalore pertaining to teachers also. I got it. It is that teachers appointment, Hyderabad area, 370
teachers.
There are two cases of same claim as made in the present petitions in the Bangalore bench matter also.
They have been listed today.
They have been listed today. I'm told, my lord, senior counsel Mr. Rajgopal argued the matter in one of the teachers' matter, and his argument is over. And it is posted today. I don't know, probably my learned friend here, Mr. Sondi or someone else is to argue.
I think, my lords, the state will be replying first, my lords, and then we will be arguing for the candidates.
In that one, notice is not yet ordered. ಆಗಿದೆಯಾ? ಅಷ್ಟೇ.
Private ಇರ್ಬೋದು.
ಏನ್ ಹೇಳ್ದಮ್ಮ? In IA number 3 of 2024 submits that similar matters are pending before the principal bench in writ appeal number 1218 of 2023, and the matter has been listed today. Full stop. Learned senior counsel Shri Jaikumar S. Patil submits that there are a few more writ appeals pending consideration before the principal bench, and those matters are also listed today. Full stop. Next para. Release this matter on 2nd of December. Let us see what happens.
Please, we will update your lordships on the second. Grateful.
Serial number 38 ಅಲ್ಲಿ list this matter along with ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಇದ್ರ ಹಾಕ್ಬಿಟ್ಟು.
My impleading application, lordships will consider at later, my lords. Very
Yes.
grateful. Grateful.
Serial number 15. 15. Mahesh Patil.
Challenging not the order, which is at page 297. The KC2. Challenging the order not of the KCT, page 297. Insofar as not sustaining the order of punishment of compulsory retirement passed by the disciplinary authority against me. The petitioner is working as first divisional assistant. He had another 2 years of service left. Now this order of this compulsory retirement has been.
When is it passed?
It is issued. On 23/8/2023.
Correct?
Yes, 23/8/2023.
Lord,
Here, the allegation against the petitioner is that he has created false document insofar as his father's certificate is concerned.
what certificate?
It is said that his father's name is Ramachandrappa, and it is also called as Yenkappa, both alias Yenkappa. Now on a complaint on some individual person, after 27 years of service, now he makes an allegation saying as to these two persons are different and is not the son of Ramachandrappa at all. But I was able to show by way of material that the Ramachandrappa and Yenkappa are the same persons. But the prosecution was not able to point out even a single material document evidence whatsoever showing as to those two persons are different. And there is Yenkappa is there should be some the record of Yenkappa that he should also some place where he's residing. Nothing as of that sort has come. And I was able to show that Ramachandrappa and Yenkappa were the same person. Now this has become at the fag end of my service. Now I have been compulsory retired from service. And there were two punishments imposed by the disciplinary authority. One of compulsory retirement.
Let us see the report.
Please.
Report of the inquiry officer.
Please.
Workout ಆಗ್ತಾ ಇದೆ.
Page 119. Page 119, annexure A15. Lengthy report, my lord, wherein relevant page 183.
Reasons, no. Page 127.
Yes.
Huh? What is the reasoning?
At the outset, the purpose of clarity, it is necessary to mention that two separate allegations are made against the DGO and articles of charge. One is relating to allegation the DGO secured job on compassion by bringing false statements as well as documents stating that he is the son of deceased government servant late Sri Ramchandra Yankappa. The
What
second,
is this paragraph number 12 in the cross examination of PWI1? Following points are elicited and admissions are made. Yeah, no?
the following points are elicited, admissions are just mentioned. He had 5 children and out of them DGO is 1.
He has 5 children and out of them DGO is 1.
And he has
Service register idea.
service register.
Tande service register
And my lord, 1971, my lord, he died. He was working as a bullock man.
Compassionate appointment.
Compassionate appointment. 1971, my lord, he was working as a bullock man. And my lord, he died. And thereafter, my lord, I was appointed on compassionate grounds. Now, my lord, they dispute the, my lord.
So your mother was given the family pension.
Yes, my lord. And even today she is.
So what is the reasoning then?
No, my lord, that's, my lord, no reasoning as said, my lord, on the assumptions. That is my precise contention. Only on assumptions, and there being not even a single material, my lord, they can point out.
It is significant to mention paragraph number 13. that nothing has been whispered in the entire body of Exhibit P5 Service Register of deceased Ramachandra, son of Lingaya, about his children. As a matter of fact, in the nomination form, which forms part of a service register, name of Srimati Buddhamma is mentioned as wife of Ramachandra. This entry, as could be seen from Exhibit P5, was made way back on 23/9/1965. Even then, a suggestion was made to PW1 that, as mentioned in Exhibit P5, Ramachandra had 5 children, and out of them DGO is 1. But nothing has been mentioned in Exhibit P5, the service register extract of this, about his children. On the other hand, alone is mentioned, is shown as Uppara.
It is not disputed, my lord, that I am the, my lord, my mother is Buddham.
This extract of Pugunappa, Pugantappa.
Paguntap.
Huh?
The name of the
Your
petitioner
brother.
is Paguntappa.
Your brother.
I am Paguntappa.
You are Paguntappa.
It is not disputed, my lord, that I am son of Buddhamma. And it is not disputed, my lord, that Buddhamma is the wife of late Ramchandra.
Then what is the reasoning then?
My lord, only on assumptions, my lord, and my lord, even my lord, the Tashildar was asked to verify. The Tashildar, my lord, he went to the village, my lord, and with all the officials and other, my lord, elders of the village, Donguru, my lord, Sarsi. My lord, it was elicited from all the elders, my lord, of the village, saying as to, my lord, the Ramchandra was in fact, my lord, the father of the petitioner. And ignoring all those facts, my lord.
Exhibit P4A. What is that P4A?
P4A.
Exhibit.
Service.
Exhibit P4
Service
consists of 132 sheets containing applications filed under RTI Act by the complainant. P4A, no?
Service register.
Service
part.
register.
Huh?
P4 service register.
In service register, only the name of the wife is.
Yes.
So.
P4. Para 16, my lord.
Lord, if this matter could be taken up, my lord, on some date is fixed.
P4A is a affidavit sworn by the mother man.
Yenanta. Both are same.
Same.
Exhibit
Date
P4A
and date
and exhibit D12
yes.
are same documents.
Same document.
Coming up for admission, is it?
Yes, yes,
Huh?
yes.
You had the benefit of interim orders.
My lord,
before the
there was an
tribunal.
order of status quo, my lord, but by the time, my lord, I was relieved, my lord, I didn't get that benefit also. There was an order of status quo before the tribunal. By that time, my lord, I was relieved. My lord, I didn't get the benefit of my lord, the interim order.
ಮತ್ತೆ?
If it could be, my lord, taken up, my lord, any other day, my lord, or some date.
Huh? Legible copy of page number 52 to 57.
52, my lord. 52, my lord.
52 to 57.
57. They're legible, my lord. Type ಮಾಡಿ. The type copy.
Good. Better copy ಸಾಕು
Please.
by next week.
Please.
Huh?
Right.
Release this matter on 2nd of December. Stop in the meanwhile. A better copy of annexure A4
Page 52 to 57.
page 52 to 57 shall be filed.
Please.
Yes.
Or notice.
Learned government advocate takes notice for all the respondents.
My lord, 2 is Upalokai.
One and 3. Learned counsel Shri Subhash Mallapur is requested to take notice for respondent number 2. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned counsel for the respondents.
Please.
Seal number 16, Harshvardhan R. Malipati.
After appearing a detailed order was passed directing the government to secure instructions. This is with
Can
regard to
respond it.
imposition of lake regionalization, my lord.
Yes, yes, yes.
Last date your lordship had passed, my lord, a detailed order.
Yes.
They were directed to secure the instructions, my lord.
Second respondent has to not provide the information.
Principal secretary.
ಬಂದಿದ್ದಾರಾ?
No, no, that is only to enable you to
Get the
make your submissions because on fact, this is what is submitted. Huh?
kindly pass over my lord. ಟೆಂಗ್ಳೆ ಅವರು ಬಂದಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಸುಕುಮಾರ್ ಟೆಂಗ್ಳೆ my lord is not. He is appearing for the respondent 2 my lord. He said that he will get the information from the principal secretary.
Huh. 2015 writ appeals.
That's why my lord, last occasion my lord.
Hmm.
Tengli sir made the submission my lord that similar matter is pending before the principal bench. I'll collect all the writ appeal papers and writ petition papers, documents and make the submission before lordship. But that is the reason my lord, the matter is posted today.
Occasion, my lord, your lordship passed an order saying that, my lord, certain.
I have noticed your contention that even as per the master plan, there is only one lake.
And the amendment now which has brought in, Lord, that entitled us for.
That benefit also, they are entitled.
So, my lord, we suggested that, my lord, if that is refunded, we will give up the claim and.
ಅದೇ.
ಅದಕ್ಕೆ ತಾವು ಅವರಿಗೆ.
ನಾನೆಲ್ಲ ಡೀಟೇಲ್ ಆರ್ಡರ್ ಬರ್ದ್ರು ನೀವು ನೋಡಿ ನೀವು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಳ ಅಂದ್ರೆ ಏನ್ರಿ ಮಾಡೋದು?
ತೆಂಗಳವರು ಅವ್ರು ತಗೋತೀನಿ ಅಂತ.
No. It is for you, government.
ಅವರು ಈಸ್ ಆಲ್ಸೋ ಅಪೇರಿಂಗ್ ಫಾರ್ ದಿ ಮಲಾಡ್ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಲಾಡ್, ಬಟ್ ಈ ವಿಲ್ ರೈಟ್ ದಿ ಲೆಟರ್ ಟು ದಿ ಅಂತ ಅವ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರು. ದಟ್ಸ್ ವೈ ನಾಟ್ formal letter is written to the principal secretary, my lord, but he will say that he will get the information. But that is the reason, my lord.
ಬಂದಿದ್ದಾರೆ ತಾನೆ ಇವತ್ತು ಅವರು ತೆಂಗ್ಲಿ ಅವರು
ಬೆಳಗ್ಗೆ
ಬೆಳಿಗ್ಗೆ some other court, isn't it?
He is in portal number 4, my lord. Today is
Portal number?
ಇವತ್ತು ಬೆಳಗ್ಗೆ ಬಂದಂಗಿಲ್ಲ. We have not seen him.
Portal number 4 ಅಲ್ಲಿ ಇಲ್ವಾ?
4 ಅಲ್ಲಂತೂ ಇಲ್ಲ.
ಇಲ್ವಾ?
Just attended, my lord.
ಇಲ್ಲ
Not in.
There is my daughter's marriage is, my lord, performing next week, my lord. For there is a reason. Maybe he is busy.
No, but the direction was to you only.
ಅವ್ರು
Learned
ತಗೋತೀನಿ.
government advocate is hereby directed to secure instructions from the principal secretary, urban development authority, having regard to the contentions made by the appellants.
ಅವ್ರು ತಗೋತೀನಿ ಅಂದ್ರೆ you will also private next week, my lord. I will get the information. I will take information. ಅವ್ರು ತಗೋತೀನಿ ಅಂತ ಅದಕ್ಕೆ ನಾನು
ನಾವು ನಿಮಗ್ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿರುವಾಗ ನೀವು ಅವ್ರ ಮೇಲೆ ಹೇಳಿದ್ರೆ ಹೆಂಗ್ರಿ?
ಅವ್ರು ನಾನ್ ತಗೋತೀನಿ ಅಂತ ಅಂದದಕ್ಕೆ
ಯಾವತ್ತಿದೆ ಮದ್ವೆ ಅದು?
ಫಸ್ಟ್ ವೀಕ್
11th ಗ
also private in first week, my lord.
Though we had passed a detailed order on 11/11/2024 and had directed the learned government advocate to secure instructions from the principal secretary, urban development department, having regard to the contentions made on behalf of the appellants, learned government advocate has not secured instructions. Full stop. Next para. Release this matter on 2nd of December to enable the learned government advocate to secure instructions and make submissions. Stop. The state government, the principal secretary, urban development department is required to take note of the contentions made on behalf of the appellants, which have been noted in detail in our order. Full stop. The appellants are therefore contending that they would be satisfied if the government would accept the fee at the rate of rupees 60,000 per acre and adjust the fee already paid by the appellants. Full stop. If no instructions are received by the next date of hearing, this court will proceed to hear the matter and dispose of the same.
Must grant 2 weeks time, my lord.
Will be excess amount. For adjustment also, there will be an excess.
Just
Grant
or
2 weeks, my
refund
lord. Then, my lord. 2 weeks will also finally also grant.
Second, let us see what information they'll give.
Please.
Yes.
Seal number 17, Manu K. Pasagar Patil.
My lord, in this, I seek for a week's accommodation, my lord. In some of the cases, the claimants are dead. I have to take steps, my lord, and in some cases, notice have not been served. I'll pay fresh process, my lord. In respect of 17.4, 17.5.
These arise from the old act or the new act?
Old act, my lord. Lordship had disposed of the matters in respect, last week regarding that, in national highway matters, my lord. These are the connected matters where state had preferred an appeal. These are all old matters, old, under the old act, my lord.
So this will continue.
Yes, my lord, this will continue, my lord.
This have to be heard on merits now.
Yes, my lord. In 17.
Why you not got the delay condoned?
My lord, notices were issued, my lord, notices were issued on
They
the
they are
both
coming up
applications.
for the first time after my lord issuance of notice.
Notice. In 17.4 and 17.5, I have to take fresh, I have to pay fresh process, my lord. In 17.6, I have to take steps for disease R1. All will be done a week's, if lordship grants a week's time, my lord. Around in 8 matters that notice have to be served.
Notice?
Have to be served in another, in totally 8 cases in pending in this total list, my lord.
Learned Counsel Shri Kripa Sagar Patil, appearing on behalf of the appellants, submits that in some of the matters that are listed, steps are required to be taken. And the same will be done within a week
Week's
from
time.
today. Full stop. If steps are taken, notice is directed to be issued in all these matters where steps are required to be taken.
Please.
Yes.
File number 18. Arun Kumar Amargondappa.
Yes.
Statement ಹಾಕಂದ್ರೆ last time date we have filed.
Huh?
Last time this court had directed.
Yes, yes.
Kindly pass over.
ಇಲ್ಲ ಅವರು ಬಂದಿಲ್ಲ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್
Yes,
ಬರ್ತಾರಾ?
I'll just get the instructions. My counsel is there in another court.
Where is the senior advocate?
Kindly pass over. I'll get the instructions.
Pass over.
Serial number 19, additional SPP.
ಮಾಡ್ತೀರಾ?
There are two appeals, one by the state and one by the original complainant against the order of acquittal. Last time the appeal filed by the complainant was placed before your lordships. Now it was connected with the state appeal. Delay ಇದೆ.
ಬಂದಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ.
498A and 307 are the offences alleged.
Mr. Sanjay, you are.
I appear.
Who is appearing for the accused?
I appear for the accused.
Complainant ಅಂದ್ರೆ
ಅಲ್ಲ point 1 ನಲ್ಲಿ connected ಇದೆ.
One is a state appeal, my lords.
ಎರಡರಲ್ಲೂ appear ಆಗಿದ್ದೀನಿ. There is some delay by the
State.
That may be.
Victims appeal.
19.1 is filed by the complainant.
Yes.
ಅದ್ರಲ್ಲಿ delay ಇದೆ. Admit ಆಗಿದೆ. Not delay may be condoned and posted for admission. Anyway, trial court records are before.
Why complainant has filed?
Our state ಅವ್ರು ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿ ಫಸ್ಟ್ ಅವ್ರ ಅಪೀಲ್ ಹಾಕ್ಬಿಟ್ಟು. Thereafter, in the year 22, thereafter appeal is filed by the state in the year 23.
Appeal against acquittal.
Yes.
The trial court records ಬಂದಿದೆ.
ಬಂದಿದೆ.
If you are ready, we will hear and dispose of.
First, the delay may be condoned. Delay may be condoned.
We will consider that one when we hear the matter on appeal.
Check on submission. 19.1 is filed by me. So some additional documents have to be filed. Kindly give some time.
19.1.
Yes, sir.
That is connected.
Complainant. So kindly give some time. Some
Or?
additional have to be filed, your lordship. Additional documents have to be filed. So 1 week time we granted.
In appeal.
ಅಪೀಲ್ ಅಲ್ಲಿ
Yes.
ಬರೋಲ್ಲ ಅಪೀಲ್
Appeal
ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್
additional documents. Criminal appeal ಅಲ್ಲಿ.
Some documents have to be filed, Your Lordship.
Documents.
Kindly, some time to be given.
ಹಾಕಿದ್ದೀರಾ ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
He'll
You
have
want to file?
Yes, yes.
ಕೊಡ್ರಿ ನೋಡೋಣ ಅದು. ಅಲ್ಲ ಇದು CRP. Old.
An appeal under 372 filed by this complainant, therein 319 would not be applicable. Any document not at the stage of an appeal after acquittal,
319.
ಅದು ಒಂದೇ ಪ್ರಾವಿಷನ್ ಇವಾಗ ಅವ್ರು ಹಾಕ್ಬೇಕು.
19.
391.
ಹಾ. Learned counsel for the appellant in the connected matter seeks for a short accommodation to file an interlocutory application. Bring on record additional evidence. So. Release this matter on 2nd of December. Please. ಮುಂಚೆನೆ ಇವರು ಅಪೀಲ್ ಹಾಕಿದ್ರು. So we can condone delay. ಇದರಲ್ಲಿ main matter ಅಲ್ಲಿ order on IA number 1 of 2023. Delay of 379 days in filing the appeal at the hands of the state is condoned, having regard to the fact that an appeal was already preferred by the complainant. Please. In criminal appeal number 200254 of 2022. Yes. IA number 1 of 2023 is accordingly disposed of. Much.
Serial number 20, Mahantesh Patil.
Number 20 on behalf of respondent on behalf of Sivanam Patil, kindly day after tomorrow, my lord, in this matter also. Both Abdullah,
Maintainability. The appeal. Huh? ಅವ್ರೇನು ಟೈಮ್ ಕೇಳ್ತದ್ರಲ್ಲ ಅದ್ರ
ಅದೇ day after tomorrow it is. Sir ಬಂದಿಲ್ಲ ಇವತ್ತು, senior ಬಂದಿಲ್ಲ.
at the request of learned counsel for the respondent, release this matter on 27th of November.
Serial number 21, Mahantesh Patil.
This matter, my lord, take notice for respondent 192, my lord. Also private next week, my lord.
Learned government advocate undertakes to appear for response number 1 and 2.
Please. Also private next week, my lord.
At the request of the learned government advocate, release this matter on 2nd of December.
Please.
Serial number 22, AM Nagral.
And for the respondent. Yes. Cooperative society now. Paragraph number 2 odi. Paragraph number 2. So all these procedures are not followed on. Yes. Yes. Where do you get that? I'll read chronology of events. Dates and events. Huh? Calendar of events. Huh? Huh. 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 Hmm. Hmm. Huh. More than 3,000 of them have been declared ineligible, and only 40 or 50 of them are eligible, and you want to proceed. Yes. Hmm. What happened after the orders are passed by the learned single judge?
That's now.
What happened after that?
I'm told that.
What was the direction?
I'm told that
The order
now.
was passed on 22nd of August 2024.
I'm told that in pursuance to the order of this honorable court, the society sought for approval of a government,
Huh?
sought for approval of a government, in regard to preparation of a voter list.
Government agree ಬರ್ತದೆ picture ಅಲ್ಲಿ.
The rule 13, the
Huh?
13 contemplates for approval of the election authority, in other words.
What is it? Rules, rules.
Rules. 13 capital D.
Rule 13.
Capital D.
I think I've recently written one judgment as to what is the procedure. Do you have a copy of that? Illa. I will get it. I will get it.
Rejection of nomination,
Yes.
Rejection of nomination.
I have detailed with all full detail. I have considered all these provisions. We will get that order.
The electoral roll list, it's held that it's a part of election process. It's the stage of intermediate stage. Therefore, it's a subject matter of section 70. The apex court held, wherein
Yes, what do you say?
What's the, out of 300 and 200 not voters, only 144 voters.
ಗೊತ್ತಾಯ್ತು, ನಾನೇ ಹೇಳಿದ್ನಲ್ಲ ಅವಾಗ್ಲೇ. There are
ಅದಕ್ಕೆ
only about
ಅಲ್ಲ
40 or 50 who are left.
ಅದರಲ್ಲಿ 140 ಎಲಿಜಿಬಲ್ ಮಾಡಿದ್ರಲ್ಲಿ 50 ಜನ 50 ವೋಟರ್ಸ್ ಆರ್ ಮಲಾಟ್ಸ್ ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ ಮಾನ್ವಿ ಟೌನ್ ಇಟ್ ಸೆಲ್ಫ್.
ಹೌದ್ರಿ, but
ಅಲ್ಲ ಐ ವಿಲ್ ಮಲಾಟ್ಸ್ ಐ ಆಮ್ ನಾಟ್
court says
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್
that
ತಗೊಂಡು
can be challenged only by way of an election petition. Writ petition will not lie.
I will not give me a 2 days time. I will because I didn't have instructions because of the reason that notes I have intimated to my client also. ಅವ್ರು ಬರ್ತೀವಿ ಅಂತ ಹೇಳ್ಯಾರ ನಾಳೆ. I will get the notes. I will even regarding notes in respect of the violation of this procedure for preparing the election rules. The officer was present notes at that time on the before the learned single judge. He himself has not admitted that there was no procedure was followed. The because the 3,250 voters ಅಲ್ಲಿ the procedure your lordship 13D procedure contemplates several aspects. And this is also one of the instructions is that lords, especially this cooperative society, last 20-25 years the management is found by the only the persons who are not residing at Manvi only, because the several villages are having voters.
Is there a, I don't see that a special provision is made for filing election petition.
Section
Under
70.
the cooperative,
Section 70.
It is a provision for raising a dispute.
Lords, even election petition, my lords, your lords.
Sir, that is what we are generally saying that you can file a dispute on. Here they have mentioned the rule 81D. So therefore I am asking you whether there is a specific provision to file an election petition. No.
Lords,
ನಮ್ಮ cooperative society ಅಲ್ಲಿ ಇಲ್ಲ. ಅಲ್ಲಿ rule 81D of the rules makes provision for election petition. ಹೌದು.
ನಮ್ ಕೋರ್ಟ್ನವ್ರು
ನಾವು ಜನರಲ್ ಆಗಿ that is
ನಮ್ ಕೋರ್ಟ್
there is a provision under section 70. That is not a specific provision for filing election petition.
ಅಲ್ಲಿ results were announced not what the writ petition.
May I request your lordship to see the section 70, my lords, subsection 2, clause C, my lords. Section 70, subsection 2, clause C, my lords.
70
subsection 2, clause C, my lords. Any, my lords got it, my lords. May I read? Any dispute arising in connection with election of a president, vice president, or any office bearer or member of a board of a society. It's in the instant case, my lords, it's an election of a board of directors. And as we members of a board of the society, it's an election of a board of members. Or members of a board of society, the last words, my lords. Members of a board of society, my lords. In the instant case, my lords,
or any office bearer.
Office bearer, my lords, once the board of members were elected, my lords, then after the returning officer issues a notice, my lords, then the office bearers were elected.
Anyway, you please will get a copy of my order. Learned counsel for the appellant. Contents that the Honorable Supreme Court, in many cases including Shri Sant Sadguru Janardhan Swami versus State of Maharashtra, AAR 2001 SC 3982 has held that from the scheme of the Act and rules, it is clear that the preparation of voters list is a part of the election process for constituting managing committee of a cooperative society. And therefore, a writ petition challenging the order declaring the election schedule on ground of illegality in preparation of voters list would therefore be not maintainable. Full stop. Learned counsel for the contesting respondents, however, seeks for a short accommodation to go through the said judgment and make his submissions. Full stop. Release this matter on 2nd of December. Yes. Let us see. Yes.
CL number 23, Indudar Pandurang Jadhav.
Old Act, huh? Notice is not filed. I mean, sorry, notice is not ordered. Huh? Learned government advocate takes notice for response number 2 and 3. Issue notice to respond number 1. Huh? Delay is 821 days. No, let us see. Emergent notice to respond number 1. Returnable by 9th of December.
CL number 24, Santosh Kumar B. Biradar.
Huh? Dissolved. Issue notice to the respondent. Full stop. In the meanwhile, the respondent is directed not to contract any other marriage, pending disposal of this appeal. Yes. Adike delay but it will not serve the purpose if you don't direct him. So that is why you are directing. Huh? Right, let us see.
CL number 25, preliminary matters, Siddharth
I am
B.
for-
Pujari.
I am for respondent, my lord, in this case. Senior cousin brother is dead. Day after tomorrow, my lord. Have it on. Senior, we are sorry. Cousin brother death, my lord. Have it on 27, my lord. 27, day after tomorrow. ಇಲ್ಲ ಅವರು ಹೇಳಿದ್ರು my lord, reach ಆಗಿಲ್ಲ ಅಂತ. Senior counsel ಅವರು ಹೇಳಿದ್ರು my lord, reach ಆಗಿತ್ತು. ಅವ್ರ colleagues ಹೇಳಿದ್ರು.
Learned counsel for the contesting respondent. Learned government advocate takes notice for response number 1 and learned counsel Shri V.R. Sarathi has entered appearance for
Response number 3, my lord.
ನಿಮ್ದು ಲೋಕಲ್ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದಾರನ್ರಿ?
ಹಾ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್, ನಾನು ಆನ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ ಮೇಡಮ್,
ಇದೆಯಾ?
ಇದೆಯಾ ಮೇಡಮ್, ಅದಕ್ಕೆ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Learned counsel for the petitioner is directed to serve copies of the writ petition along with annexures on the learned government advocate. Full stop. At the request of learned counsel for respond number 3,
Yes, ma'am.
release this matter on 27th.
Obliged.
Seal number 26, K. Ravindra.
I appear for the advocate for the petitioner.
I appear for the respondent state in this matter, my lords.
I appear for the second respondent. 27.
Where the that page number 58 and 59.
My lord, I'm appearing for one of the petitioner, my lord. Kindly pass over the matter to 2:30, my lord. Senior is going to one of my colleague marriage, my lord. He is on the way. Kindly have it on 2:30, my lord. I request, my lord.
Sorry, my friend might be confused, my lord. I am engaged by Mr. Ravindra to argue.
Serial number 20.
Please ನೋಡಿ ಯಾವ್ದು ನೋಡ್ಕೊಂಡು ಸಬ್ಮಿಷನ್ ಮಾಡ್ರಿ.
Apologize.
Yes.
For respondent
My
number
lords,
2,
will
Harmony,
see
sir.
the orders at annex,
Two
orders at
Harmony,
annexure
sir.
A3 and A4 at page 58 and 59, which have to be read along with annexure R3, which is at page 74.
The assistant commissioner.
Yes, yes.
Yes, yes.
If I may, my lord, state this. Petitioner was posted at Raichur
He was
on
sent on election duty.
yes, my lord, and
Then
then
she came back, she reported, and thereafter this order has been passed.
yes, yes. On the
On the ground that,
assumption,
respond number 3 is being appointed for the first time.
Yes,
Chetana idu?
yes, ma'am.
yes, yes, my lord.
Yes.
Is appointed for the first time after finishing
My
this
lord.
case.
Yes.
My lords will see Rule 5 or Clause 5 of the transfer guidelines dated 25th of June 2024, which I have appended at page number 86 onwards at annexure E.
Yes.
The relevant rule Clause 5 is at page 88. And my lords, my submission.
When direct recruits are to be posted on their first appointment, that is one clause, and whether clause 6
My submission
has to be fulfilled. The
Yes, ma'am.
requirement of clause 6, even in case of invocation of this provision in clause 5.
grateful, my lord. My
That is your
submission.
submission.
Yes, my lord. Clause 5 is only the power of the government to make transfers beyond the general transfer period, whereas the manner in which such transfer has to happen
What
by
disturbing,
exception
what
is
disturbing you,
clause 7.
even if it is a case of appointment of a direct recruit for the first time, still the requirement of clause 6 has to be fulfilled.
Clause 6 and clause 7 has to be fulfilled.
Yes.
These
that
are,
is
my
your
lord, yes, my lord, the corresponding provisions in the earlier transfer guidelines were clause number 7 and clause number 8 and 9. Clause 5 here was
ಯಾವ
the
page number?
ಇಲ್ಲ ಅದು file ಮಾಡಿಲ್ಲ because that would not be relevant now, just for the purpose.
All right. No, if there were similar provisions earlier also, and this aspect of the matter has fallen for consideration in some judgment, you could have pointed out.
My lords, the generally, my lord, the law is well settled saying that clause 9 earlier, which is almost equivalent to clause 7, there is some, it's not completely in perimeter, therefore I cannot place reliance. Certain change.
No other judgment, my lord, on this issue.
So clause 9 has been held to be mandatory. Clause 9, which is now equivalent to clause 7, I can say.
Yes, yes.
Held to be mandatory by a catena of judgments.
Yes. Yes.
My lords will see in page number 90, clause number 7 is there.
Yes.
It says the minimum period of service which a government servant may render at a place may be extended or reduced in the following circumstances. One, a government servant who has completed the maximum period of stay at a place and due for transfer has less than 2 years of service for retirement.
Yes.
A government servant possesses special technical qualification or experience and no suitable government servant is immediately available for being appointed to such a specific post to replace him. C, when an employee is working in a central government project or a flagship project implementation of which is at an important stage and withdrawal of his services is likely to seriously stall timely completion of that project. D, where both the spouses are government servants, and if one of the spouses is transferred, then the other spouse may also be transferred to the same place or nearby place subject to availability of vacancy, even if one of them has not completed the minimum period of stay. I may pause here, my lords. They tried to argue that this is a case of the spouses also. This is not a case of spouses. Page 58 and 59 do not rely upon this clause to say that somebody is to be transferred from one place because of the case of spouse.
Yes.
E, if a government servant is an office bearer of the Karnataka State Government Employees Association, he shall not be transferred until the completion of his term as that office bearer. F, if a government servant or his or her spouse or children are suffering from serious or terminal ailments and the facility of medical treatment is available at a place and he produces a certificate in that regard issued by the medical board. These are the only grounds on which the reduction of the minimum tenure protected under clause 5, 6 of this transfer guidelines can be made. Now, clause 6 would say, my lords, no government servant shall ordinarily be transferred, deployed if he has not completed period of service at a place as stipulated below. And for group A post, it is 2 years. In addition to that, my lords, in fact, it is the All India Administrative Services recruitment rules 1954 that might be applicable to the respond number 2. However, that is not relevant for the purpose of transfers here. In the statement of objections of the state,
that provision empowering the chief minister
yes,
to pass
yes,
orders.
Yes.
Where
that
is
is that provision is, my lords, here. Actually, my lords, rule the
subclause 3 of clause 5, my lords.
Though it is subclause 3, my lords will see. The rule itself says who is competent officer, and my lords, rule 4, clause 4 will, your lordships will see clause 4, subclause 1 says ministers in charge of the respective departments are delegated the power to make general transfers.
Allala, clause 5 alli.
Clause 5.
Subclause 3.
Clause 3. Subclause 3 says the number of transfers to be made, which is at page 89, my lords will get it.
Yes, yes.
Number of transfers to be made due to special or exceptional reasons shall be limited to the minimum extent. And in case transfer is considered necessary in specific cases, such cases shall be submitted to the Honorable Chief Minister without fail and transfer made after obtaining his approval.
Yes.
That is at Annexure R3. Annexure R3. Nonetheless, my lords, this is clause 3 again. I may reiterate my submission on the entire clause 5. Clause 5, including subrule 3 of clause 5, is only empowering the government to do something. And this has to be read along with clause 6 and clause 7. It cannot stand alone. Annexure R3, which the state has produced at page 79, my lords, is the R3, 71. Annexure R3 at page 74. This is the approval of the Chief Minister. However, no reason specifically for this particular case are given. It only narrates that this is the power under the transfer guidelines. And the only reason is ಸಾರ್ವಜನಿಕ ಮತ್ತು ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟಿಯಿಂದ. Page 74, serial number 3 is relevant for this purpose. Serial number 3 says, ಸರ್ಕಾರಿ ನೌಕರರ ವರ್ಗಾವಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 25/6/2024 ಸರ್ಕಾರಿ ಆದೇಶದಲ್ಲಿ ವಿಸ್ತೃತವಾದ ಮಾರ್ಗಸೂಚನೆಗಳನ್ನು ಹೊರಡಿಸಲಾಗಿದೆ. ಈ ವರ್ಗಾವಣಾ ಮಾರ್ಗಸೂಚನೆಗಳ ಖಂಡಿಕೆ 5 ಈ ಕೆಳಕಂಡಂತಿದೆ. 5 and then subclause 5, ಹೊಸ ಕಚೇರಿ ಅಥವಾ ಹುದ್ದೆಗಳನ್ನು ಸೃಜಿಸಿದಾಗ ಅಥವಾ ನಿವೃತ್ತಿ, ಬಡ್ತಿ, ರಾಜೀನಾಮೆ, ಹಿಂಬಡ್ತಿ ವಜಾಗೊಳಿಸಿರುವುದರಿಂದ, ಮರಣದಿಂದ, ಕಡ್ಡಾಯ ನಿವೃತ್ತಿ ಕಾರಣದಿಂದ ಹುದ್ದೆಗಳ ತೆರವಾದಾಗ ಅಥವಾ ನೇರ ನೇಮಕಾತಿ ಹೊಂದಿದವರನ್ನು ಮೊದಲು ನೇಮಿಸುವಾಗ ಅಥವಾ ಬಡ್ತಿ ಹೊಂದಿದವರನ್ನು ನೇಮಿಸುವಾಗ ಅಥವಾ ಯಾವುದೇ ಅನಿರೀಕ್ಷಿತ ಪರಿಸ್ಥಿತಿಯಿಂದ ಉದ್ಭವವಾದ ಹುದ್ದೆಗಳ ತಕ್ಷಣ ತುಂಬಬೇಕಾದಾಗ. ದೆನ್ ನಂಬರ್ 4, ಮೇಲೆ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ಕೆಂಡ IAS 2002 ಹಾಗೂ KS ಅಧಿಕಾರಿಗಳನ್ನು ಸಾರ್ವಜನಿಕ ಮತ್ತು ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ. Now, this is not the reason. ಸಾರ್ವಜನಿಕ ಮತ್ತು ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟಿ is not the reason which falls under clause 5 or under clause 5 subrule 3.
Yes.
Clause 5 would only say that there is a placement for the first time of a person who is directly recruited. Actually also, my lords, this is not a case. Kindly come to page number 63, my lords. This is paragraph number 6 of the statement of objections filed by the state. Page 63, para 6.
Yes.
Para 6 reads thus. It is submitted that the respondent number 2 is not a probationer. He is an officer of Indian Administrative Service of 2022 batch. The officer was given posting as Assistant Secretary in the Ministry of Micro, Small and Medium Enterprises, Government of India in New Delhi from 25/2024 to 12/7/2024. After the completion of the central service, officer has reported to the state government for posting on 5/9/2024. Respondent number 2 is very much eligible to hold the post. I will pause here, my lords. Not the relevant clause 5 does not say that posting in the state of Karnataka for the first time. The posting of a person who is directly recruited should be for the first time. It is not that it should be for the first time in Karnataka. The very person might be, my lord, serving elsewhere also initially. And he may now, my lords, for the first time be appointed in Karnataka. That would not come within the realm of that clause 5. It says posting of that person's posting should be the first posting.
Yes.
So the argument which was canvassed was that this becomes his first posting in the state of Karnataka. That's not the tenor or language of clause 5. And therefore, my lords, it is before 2024 May, where the respondent number 2 is appointed as Assistant Secretary in MSME Government of India, New Delhi. He was, my lords, in the state of Karnataka for a larger period of duration where there was some training or something going on. That is available on the net also. So thereafter, my lords, from 2022 to 2023, he is serving in Karnataka and he is given certain training, at which period also it was permissible for the state to have given him some charge along with an officer who is working for the purpose of the ensuring, my lords, that he would understand how the actual work happens on the spot. Thereafter, now he is appointed in the year 2024 for 2 months in the MSME New Delhi. The reasoning at annexure R3, page 74 would not show that there is this clause invoked, or rather this reason that he is being posted for the first time as an employee. Nonetheless, my lords, the transfer or posting of this person at annexure respondent number 2, even assuming can be made under clause 5, the premature transfer of this petitioner cannot be made under clause 5. This is a case where there are two different persons, where if they want to argue that clause 5 stands alone without reference to 6 and 7, then once they cannot apply clause 5 for transferring the petitioner from the post of Assistant Commissioner from Raichur.
Yes.
And my lords, the clause 5 and clause 7, what is used in clause 6 and clause 7, the words, they are consciously absent in clause 5. The legislature is, my lords, assumed to have this knowledge because it's an expert body. And if they are omitting certain words specifically, which they employ in other clauses of the same guidelines, then, my lords, it cannot be understood that we can supply those words which are absent in clause 5. So my respectful submission is clause 6 and clause 7 are mandatory clauses. Clause 6 is the general rule. Clause 7 is an exception to the general rule of clause 6. And clause 5 itself is in the nature of an exception to the general rule that transfers generally cannot happen beyond a particular period in the year. And entire clause 5 is an exception. Clause 5 is empowering power, whereas clause 7 is the manner or method in which clause 5 and clause 6 can be utilized by the government.
Yes.
Well, after the other side argues, my lords, I will supply those judgments also. My friend, Mr. Ravindra, has certain judgments. One is a judgment of His Lordship, the Chief Justice, where clause 6 and 7 have been taken note of in the context of the definition of deployment and transfer under these very guidelines. I had submitted that judgment on the last occasion. My lords will have it.
Yes, you can point out from that because the other side will have to say something on that also.
Yes, my lords. The other side was actually given this copy of, in fact, my friend had that judgment with him, my lords, on the last occasion. My lords will find the relevant portion of this judgment at paragraph numbers 18, my lords will see.
Ah.
18. Clause 6 of the guidelines provides for a minimum tenure of posting to a government servant at a place. The minimum period of tenure varies to differ of officers. This court is concerned with Group B officers. Minimum tenure period of tenure at a place for Group B officers is 2 years. Clause 7 of the transfer guidelines 2024 enables premature or delayed transfer. In other words, clause 7 would be an exception to clause 6. Clause 7 empowers the government to extend or reduce the period of posting at a place to the government servant, however, in the circumstances provided therein. I would stop here, my lord. Though clause 5, there is no reference to clause 5 because the facts were different there. 6 becomes a mandatory provision. Clause 7 becomes only an exception to clause 6. And clause 5 cannot stand alone contrary to the wordings in clause 6 and 7. So this judgment can be utilized to persuade your lordships that clause 5 also is only an empowering provision like clause 7, both of which are an exception to clause 6.
I appear for the second respondent.
For the respondent state.
Yeah, you learned AIG or reality.
Please, my lords. In this case, my lords, the challenge is to annexure A2 and A3, my lords. A3 and A4, which are the transfer orders. My lords, firstly, my lords, I'd like to draw my lords' kind attention to the training program. The case of the petitioner before this honorable court, though it was not their case before the tribunal, that first posting, the posting given to the respondent number 2 is not the first posting. Earlier he was posted elsewhere. And now this is not his first posting. So it will not come within the purview of subclause 3 of rule clause 5. My lords, the training program, my lords, as soon as successful candidates who secured, who passed the interview, the written exam and interview, they are sent for training, induction training program in Lal Bahadur Shastri National Academy for Administration. Well, the induction program has 4 phases. First is they're given a theoretical foundation course training, my lords. Then there is a phase 1 training, which is again within the campus. Then third comes the district training, where they're sent back to the states from the cadres which they have opted for, which they're allotted to. In the district training, what happens, my lords? It is not, they're made to go through all, they're made to serve as even village accountants or even forest guards, all positions. None of them are considered postings. That is for purpose of training them so that they get first-hand experience as to how the administration is run. After that, my lords, they're taken back to the assistant secretaryship under the Union of India. That is started from 2015. So 2015, my lords, this assistant secretarial tenure was also introduced and by the central government, and it's not a posting because he's still considered a probationer. May I draw my lord's kind attention to office memorandum dated 23/4/2024, my lords.
Where
Has
is
it been?
Where is it?
I request my learned friend, government advocate, to place it on record. It's there.
Dated.
Please, my lords, I'll furnish it. I'll furnish it. Be that as it may be, my lords. We were under the presumption that that the fact that it is the first posting was not disputed, but now that it is disputed, we'll place it on record if the matter is taken up at 2:30. Further, my lords, on the argument that my learned friend has canvassed before my lords, that the approval of the chief minister, there are no reasons assigned. May I draw my lord's kind attention to Rule 5(3), lords.
Yes.
Please, my lord. It is extracted on page 8. In fact, the writ petition served by my learned friend, some of the pages are missing. In fact, page 7 of the writ petition is not available. Please, page number 8. The transfer should not be made beyond the period of general transfer, except in the following. Page number 8 of his writ petition, my lords. Please. Transfer should not be made beyond the period of general transfer, except in the following circumstances.
Yes.
1 is not relevant, my lords. 2 has been extracted, where new offices, posts are created, or posts have become vacant due to retirement, promotion, resignation, reversion, dismissal, death, or compulsory retirement, or when direct recruits are to be posted on their first appointment, or promotees are to be posted on promotion or due to any unforeseen circumstances, and when the posts are required to be filled immediately. My lords might have observed, there is one of the class of cases which this particular provision refers to is also when direct recruits are to be posted on their first appointment. It is clearly the case of the state government and the correspondent that this is his first appointment, because after his training program, which concludes after the secretarial posting before the Union of Government, he is sent to the state cadre. In the state cadre, the first post which is usually given to an IAS officer is a subdivisional magistrate post, which is called state of, which is referred to as Assistant Commissioner's position in the state of Karnataka. And this is his first posting. And I am not making
one correction. After the assistant secretary's program, we go back to Masuri Institute. Thereafter, we come back.
The report, please. Thereafter, we are, yes, they are allotted to the state cadres to report to duty.
Yes.
Please, I stand corrected, my lords. Please. My lords, my humble submission is, this is his first, posting, and we have stated so on our affidavit itself. It's not a casual submission made in the court, my lords. With all due responsibility, and we have stated it on an affidavit. This is the first posting, and petitioner, apart from stating that it is not the first posting, is not placed any material on record to show that this particular person was posted by the state after he has assumed the position of an IAS officer in any other department or position elsewhere in the state. So, my lords, that is our submission with regard to the first posting.
He is pointing out to the statement made in your statement of objections.
Alala, posting another, see that I understand.
Statement of the objections, this is what you have said, and it is pointed out.
The posted Andre, he has been appointed there. What happens is, my lords, as I already made submission, that first is they are sent for training. There's an induction program. After the induction program, my lords, they sent to the state cadres to have district level, at the district level, so that they have some rudimentary experience, first-hand experience. In that first-hand experience, there is no posting. They undergo training, further training, where they are made to do various tasks, like even including one of the lowest in the revenue department or in the forest department or any other department. After that, they are again sent back to the central government, where they undergo the assistant secretarial tenure. Then they are sent back to Mussoorie for training, further training, and after that, after completion of that particular process, my lord, then they are allotted back to the cadres, where they go as IAS officers for the first time to that particular state, to which they are allotted. And the state government for the first time will allot a position of subdivisional magistrate or assistant commissioner in the places where it's available. But the difficulty here is, my lord, there is no assistant commissioner.
Yeah. Of this posting and training, my lords, will see there is a confusion being created that the training will be by the central government or by the state government at Mussoorie. That's not so, mal. Though he is an IAS officer, the training is given by the state of Karnataka, and my lords will find that there is a civil list of IAS of 2024 compiled by the Department of Personal and Administrative Reforms, Services 1 from Bengaluru. And my lords, this is the list of postings as on 1/1/2024. The name of the respondent number 2 is shown that he is appointed on, that he is taken on this service from 29/8/2022, where he joins on 10/7/2023 on functional district training program, Gulbarga. And he also paid the salary 57,800. Thereafter, year 2022, posting as assistant secretary in MSME New Delhi is not a part of his training here.
Well, still a trainee. Still a trainee.
He is not a
I
professional.
think my learned friend has misread the provision, my lords, and the literature related to the training program. My lord, he is still considered a trainee till he is posted, till he is placed under the Union of India, under the Government of India, where he has to complete his assistant secretarial tenure. Then he is sent back to Mussoorie, where
beyond para 6 of the pleading, my lords, that is what I wanted to point out.
Para 6, I will be able to clarify. I have not said that I have posted. I have not posted him.
Yes.
I cannot post him under the Government of India. It's not under my orders. Please, my lords.
Word posting is wrongly used. Word posting
is wrongly used, and the state of Karnataka does not even have power to post him under the Government of India. It's the Government of India which takes him under their assistant secretarial tenure.
When you are making statements, you have to be very clear.
Please.
You have created confusion for yourself.
Please. I bow to my lords. Error, yes, lapse in their mind.
That could have been state of Karnataka or within state of Karnataka.
Yes.
Posting of that person for the first time should not be.
No. I cannot, my lord. This posting is about state government posting its IAS officer who belongs to its cadre to a particular position. His first posting. My posting is what is in question. I cannot post someone to some other state or to the central government. So that does not come at all. I will be able, my lord, it may be taken up at 2:30. I'll place the training program manual, the relevant portion, and I'll also produce the office memorandum where it clearly states that under the order which has taken him into assistant secretarial training.
Actually,
so that will clarify what little doubt is there also.
I have a copy of it. I can just read it for the court's reference. The order by which he is posted is, the undersigned is directed to refer to subject matter. On completion of district training of Lal Bahadur Shastri National Academy of Administration, Mussoorie, IAS officer trainees of 2022 batch will be attached as assistant secretary, not posted, attached as assistant secretaries in the ministries and departments of Government of India for a period of 8 weeks, 25/2024 to 12/7/2024. By this order, nearly several persons, nearly 181 persons are posted for this, not posted, attached as assistant secretaries for 8 weeks period. Now, after the completion of this part of the training, they go and report back to the Mussoorie, to the order. Thereafter, they come for posting. In fact, the order also says waiting for posting. In fact, the order of transfer, which is challenged here, also shows that if my learned friend completes, I can also submit my argument.
All right. Really.
Please, my lords. Lords, further, it's our case, my lords, that there is no reasons need to be assigned because it's an administrative order which approval granted by the Chief Minister is an administrative order. It's an administrative in nature. It is not a quasi-judicial order that he passes, that he has to hear somebody, he has to hear the affected party and give a detailed order. My lords, may I draw my lords' attention to the judgment of the Honorable Supreme Court in National Highways Authority versus Madhukar Kumar. I'd request the learned advocate, government advocate to hand over a copy to my lords. This case, my lords, the issue that came up was whether statutory authorities are always duty bound to give reasons. After going through a catena of authorities, my lords, the Honorable Supreme Court, commencing from paragraph number 49, where it has been titled duty to give reasons. The discussion commences from there, my lords, paragraph 49.
Yes.
Please, my lords. To save time, my lords, may I draw my lords' kind attention to the conclusion, which commences at 69. Para 69 at page 697.
Yes.
Please, my lord. We would hold that as noticed by the bench of 3 judges in Mahabir Jute Mills Limited, there is no general duty when an administrative decision is taken to give reasons. A statute may, however, explicitly provide that the executive authority must provide reasons and it must be recorded in writing. A case in point is the first proviso to Rule 8 of the rules itself. The desirability of a general duty in case of administrative action to support decisions with reason is open to question. One of the most important reasons is the burden it would put on the administration. It is apposite at this juncture to notice that the administrative decisions are made in wide spectrum of situation and context. The executive power of the Union and the states are provided in Article 73 and 162 of the Constitution of India, respectively. Undoubtedly, in India, every state action must be fair, failing which it will fall foul of the mandate of Article 14. It is at this juncture we may also notice that the duty to give reasons would arise even in case of administrative action where legal rights are at stake and administrative action adversely affects legal rights. There may be something in the nature of the context under which the administrative action is taken, which may necessitate the authority being forthcoming with rational reasons. There are other decisions which essentially belong more to the realm of executive policy making, which ordinarily may not require furnishing of reasons. The advantages undoubtedly of introducing the reasons-driven regime are as follows. Persons who may have a right or an interest would know what are the reasons which impelled the administrator to take a particular decision. Judicial review in India, which encompasses the wide contours of public interest litigation as well, would receive immeasurable assistance if the reasons for particular decisions are articulated to the extent possible. The giving of reasons also has a disciplining effect on administrator. This is for the reason that the reasons would capture the thought process which culminated in the decision, and it would help the administrator steer clear of the vices of illegality, irrationality, and also disproportionality. Reasons could help establish the application of mind. Conversely, the absence of reasons may unerringly point to a non-application of mind. The duty to act fairly may require reasons to be recorded, but the said duty, though there is a general duty on all state players to act fairly, may have its underpinning ultimately in legal rights. It is one thing to say there should be reasons which persuaded the administrator to take a particular decision, and a different thing to find that the reasons must be incorporated in a decision. The question relating to duty to communicate such a decision would arise to be considered in a different situation, having regard to the impact which it in law produces. In fact, the second proviso to rule so and so provides that not only for there being reasons, but the reasons for refusal to permit barricades must be communicated. If the law provides for a duty to record reasons in writing, undoubtedly it must be followed, and it would amount to violation of the statute if it were not followed. Even if there is no duty to record reasons or support or other reasons, there cannot be any doubt for every decision there would be and there must be a reason. The Constitution does not contemplate any public authority exercising power with caprice or without any rationale. But here again, in the absence of the duty to record reasons, the court is not to be clothed with the power to strike down administrative action for the mere reason that no reasons are to be found recorded. My lords may kindly mark this portion, lords. In certain situations, the reason for a particular decision may be gleaned from the pleadings of the authority when the matter is tested in a court. From the materials, including file notings, which are made available, the court may conclude that there were reasons and the action was not illegal or arbitrary. From admitted facts, the court may conclude that there was sufficient justification and the mere absence of reasons would not be sufficient to invalidate the action of the public authority. Thus, reasons may, in certain situations, have to be recorded in the order. In other contexts, it would suffice that reasons are to be found in the files. The court may, when there is no duty to record reasons, support an administrative decision with reference to the pleadings aided by the materials. My humble submission here, my lords, here is an approval granted by the Honorable Chief Minister after going through the material placed before him by the department in the particular case, and after having considered all the aspects of the matter, has accorded his approval. So in my humble submission, my lords, there can be no fault can be found with the approval granted by the Honorable Chief Minister, merely because he is affixed his signature and by clearly stating that the said transfer order is in public interest. To write detailed order, there is no, it was not a quasi-judicial proceeding, so it wasn't necessary, my lords. Further, my lords, confusion is sought to be created by stating that Rule 5, the clause 5, subclause 3 has to be read in context with the Rule 6 and 7, my lords. My humble submission, I'd like to draw my lord's kind attention again to the said clause, my lord, clause 5. The heading itself, my lords, clause 5, page 8, my lords.
Yes.
Please. Please. 5, clause 5. Transfer should not be made beyond a period of general transfer. Lords, till there, it is in line with what the learned senior counsel has submitted for so far. But after that, what is written is, except in the following circumstances. So, an exception is clearly carved out, like as in the proviso, and it states that in clause 2, that where direct recruits are to be posted on their first appointment, then the general rules which are there in the rest of the guidelines will not apply. May I draw my lord's kind attention to the judgment of the Honorable Apex Court, my lords, with regard to, my lords, as my lords are aware, an exception, my lords, an exception clause in a statute, my lord, is created to ensure that the general rigor of the statute or the provisions to which it is carved out as a proviso or an exception would not apply. It creates a separate class of cases, circumstances, where the general rule will not apply. And this is one such case. So my humble submission is, my lords, there are many cases, I beg for my lord's forgiveness because of paucity of time, I could not place. But the first case in this regard is Ram Narayan Sons versus Assistant Commissioner of Sales Tax. And of course, the other one would be Ali versus State of Kerala, my lords, 1955 Supreme Court. My lord, I will be able to place it by 2:30 minutes. In all these cases, my lord, consistent stand of the Apex Court is, while interpreting statutes, especially exception clauses and provisos, it has to be understood that it is there for a particular purpose. And if that purpose of the proviso or the exception is not given effect to, then it would not be harmonious construction, and it would render that very particular clause nugatory. It would negate the purpose for which that clause is there. And such a reading is impermissible in statutory interpretation. That is the ratio laid down in all these cases, my lord. So my humble submission is, my lords, 5 clause 3, if it has to be operative, it has to be read as an exception. If it were not to be read as an exception, then it would be rendered odious. The very provision itself would be incapable of implementation. And such a reading, my lord, as my lords are aware, is impermissible in statutory interpretation. Lastly, my lords, my humble submission is, my lords, nowhere in their pleadings in the tribunal have they said that this is not their first posting. One, my lord. Second submission that I would like to make, my lords, which was considered by the tribunal, was the forum before which they could institute the particular case. Lord, it was our clear case that, my lords, the appropriate forum where that particular transfer order could be challenged is because the officer in question was an IAS officer, was in the Central Administrative Tribunal by reading of section 14 and 15 of the Administrative Tribunals Act. So my humble submission, my lord, that also could be taken into consideration with regard to whether the tribunal itself had subject matter, state tribunal itself had subject matter jurisdiction to look into this aspect and pass orders. Please. Much obliged.
The appellant, the petitioner, writ petitioner is a KS officer.
KS officer, junior scale KS officer.
That's why she has gone before the Karnataka administrative.
Please. That aspect, my lords, we had made a submission that because section 14, which precedes section 15, section 14 confers jurisdiction on the Central Administrative Tribunals, my lord. And it clearly says any matters relating to
that may be.
But anyway, that may not be relevant in now considering the fact that.
Yes. Yes, Mr.
Yes, Lord. Now, with regard to this posting, Lord, the order itself says he is waiting for posting. Kindly see the order at page 59. Which is the order dated 13/9/24. Mukul Jain waiting for posting is posted. Sahitya Aladkatti waiting for posting is posted. Gajanan Bale, who is the second respondent, waiting for posting is posted. And the order of the Chief Minister proceeding, which is at page 74. That also says at page 74. The top first para there. 2022ನೇ ಸಾಲಿನ ಭಾಷೆ ಅಧಿಕಾರಿಗಳು ಫೌಂಡೇಶನ್ ಕೋರ್ಸ್ IAS ಪ್ರೊಫೆಷನಲ್ ಕೋರ್ಸ್ phase 1 district training assistant secretaries program. It's a program. ಹಾಗೂ IAS ಪ್ರೊಫೆಷನಲ್ ಕೋರ್ಸ್ phase 2. ಈ ಅಸಿಸ್ಟೆಂಟ್ ಸೆಕ್ರೆಟರಿ ಪ್ರೋಗ್ರಾಮ್ ಆದಮೇಲೆ ಐ ಹ್ಯಾವ್ ಟು ಕಂಪ್ಲೀಟ್ IAS ಪ್ರೊಫೆಷನಲ್ ಕೋರ್ಸ್ phase 2. ತರಬೇತಿಯನ್ನು ಮುಗಿಸಿ these are all training program. ದಿನಾಂಕ 5/9/2024 ಮಾತ್ರ ರಾಜ್ಯ ವೃಂದಕ್ಕೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಲು ವರದಿ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ. So now posting has to be given to them for the first time by the state government. These are all a part of the training. In fact, the training itself consists of different courses. Now it says there are different types of training. That is, one is called as a foundation course. Then there is a phase 1 course. Then district training also is done. Phase 2 course, assistant secretaryship. Then he will have to complete phase 2 course, go back to the institute, then come back for reporting to the state government. They will have to report to the state government and then get a posting. This cannot be disputed at all. There is no difficulty about it. In fact, there is an order dated, I think Kashapur has a copy, 23/4/24, sending them to assistant secretaryship program. If the councillor record, I think he has it, he can produce it before the court.
So even in case of Mukul Jain, same thing has been done.
Yes, same thing has been done. This is not done, my lord, in respect of one officer. This is done in respect of all 3 officers. It is done. In fact, this is.
ಎರಡನೇದ್ರಲ್ಲಿ I think there was a vacant post.
There was vacant post.
There was no difficulty there.
Correct.
I think Mukul Jain and this Gajanan Bale.
Yes, yes.
These 2 were posted in a place where persons were already officiating.
Now, if the interpretation is otherwise, my lord.
Even Prakash Kudre also transferred, my lord.
Alri Kumari Sahitya M Aladakatti. ಅವ್ರದ್ದು ಒಂದು ಮಾತ್ರ ಇಲ್ಲ.
Yes. Really, the entire interpretation has to be done having regard to the reason why this provision is introduced. It is not a semantic interpretation. Now, suppose a person comes for reporting for the first time. He has to be given a posting. He cannot wait for some person to complete 3 years and then to be given a posting. Whereas, this rule, if you look at the rule, now that provision with regard to this guideline, this rule 5 deals with transfer should not be made beyond the period of general transfer. Now, general transfer also, this premature delayed transfer also, that has to be done during the time of general transfer. Now, while doing general transfer also, these criteria will have to be kept in mind. This section 5 is an exception because somebody comes for posting. Now, the government will not, suppose nobody has completed 3 years, he cannot wait, he cannot just lie, he cannot be kept somewhere else. So, therefore, this is treated as an exception that if he has to be given as a first posting, then, my lord, all these regulations will not arise. Otherwise, now, if my learned friend's interpretation is accepted, suppose a person finishes IAS training, nobody has completed, no vacant post is available. Then he will have to wait, my lord. This entire thing puts the administration into a difficult situation. So, therefore, my lord, the scope of judicial review in such matters is, now whether this is a case, my lord, it is done. It is not a done, my lord. Somebody goes to the chief minister with an influential letter, with a letter of recommendation, gets it done. Now, in a matter where the lordships are examining it, the ultimate, the effect of this order, my lord, will have to be seen. In fact, the scope of judicial review, suppose, my lord, even in a given case, now, apart from all these cases, there is a chief minister's order. Chief minister also has power to reduce the tenure. But this kind of a posting where the chief minister passes an order stands on a different footing as compared to a case, my lord, where the term is reduced due to some reason. And this is a case where somebody has to be given a posting immediately. That means, so, my lord, this concept of judicial review cannot be kindly note that this cannot be extended to cover a situation where for the reasons of administration. Now, my lord, your lordships are well aware, my lord, of how things happen in the government level. In government, my lord, there are several push and pulls. And if somebody does it mala fide for political reasons, those are cases, my lord, the court will have to examine it, consider it. There is one judgment of Justice Division Bench of our Honorable Court, my lord, that is in the case of C. Manjunath. I request Kasham Court to hand over a copy of that judgment. There, my lord, kindly go to para 25 at page 19 of the judgment. At page 19, bottom. Honorable Apex Court, in the case of Mohammed Masood Ahmad versus State of UP and another, has held the scope of judicial review in the matter of transfer is limited. It further held in State of Punjab versus Joinder Singh Dhatt. This court observed, we have heard the learned Contempt. This court has time and again expressed its disapproval of the courts below interfering with the order of transfer of public servant from one place to another. It is entirely for the employer to decide when, where, at what point of time a public servant is transferred from his present posting. Ordinarily, the courts have no jurisdiction to interfere with the order of transfer. High Court grossly erred in quashing the order of transfer of the respondent from Hoshiarpur to Sangrup. The High Court was not justified in extending its jurisdiction under Article 226. There will be last para in that same page. The scope of judicial review of transfer under Article 226 of the Constitution has been settled by the Supreme Court in Rajendra Rao versus Union of India, National Hydroelectric Power Corporation, State Bank of India versus so and so. No doubt, these are all cases which are where the guidelines are not involved, but this particular case guideline, para 27, I'll skip some of the paras, para 27 at page 21. It is clearly evident from the records in hand, and in particular Annexure R1 appended to the statement of objections of the respondent state, that order of transfer has been effected with prior approval of the Chief Minister. Thus, prior approval as contemplated under clause 9b of the guidelines dated 7/6/2013 has been obtained, and as such it cannot be again said by the petitioner that impugned order of transfer is in violation of transfer guidelines. Petitioner has not made out any good ground of mala fide exercise of power, either by the respondent state or by the Chief Minister. When the state government has produced the Annexure R1, there being no dispute by the petitioner, the order of transfer having been made for administrative exigencies in public interest, contention of the petitioner that the said order of transfer is made without assigning any reason does not hold water. We do not agree with the such proposition, as no judicial review would be available to the petitioner when there is compliance of clause 9b of the transfer guidelines. Ultimately, the court says that this is not a case of judicial review because there is no mala fide exercise of power. Therefore, the question of this applying this premature tenure and say that even for a first posting, he will have to find only a posting where he is an IAS officer and who is displaced is a KS officer. So he will have to wait for completion of 3 years, would not be a correct interpretation of these rules. Otherwise, this entire provision of 5(2) would be put to, it becomes inoperable, would be my submission. All right. There are few more judgments on the transfer guidelines. I don't want to repeat. There is that posting of this assistant secretaries. If my Kashap can forward a copy of that posting, there is that this 8 weeks posting as assistant secretary. This is the attachment of IAS officer trainees of 2022 batch as assistant secretaries in Government of India. The undersigned is directed to refer to subject matter and to say, on completion of district training of Lal Bahadur Shastri National Academy of Administration, Mussoorie, the IAS officer trainee of 2022 batch will be attached as assistant secretaries in the Ministries Department of Government of India for a period of 8 weeks from 25/24 to 12/7/24. In that, my lord, serial number 56 is the second respondent.
Yes.
So therefore, after finishing this training, they will report to the state of Karnataka for the first time. They need to be given a posting, and that has been done, my lord. It does not call for any interference, in my humble submission.
Yes. Yes, Mr. Amit Kumar.
My lords, now the argument which is tried to be canvassed is that the statement of objections in writing, where they both state as well as the respondent number 2 has specifically and categorically stated that he was posted, is now tried to be converted into an argument saying that it is not posting, though they have used the word. My lords, I had pointed out to your lordships page number 63, which is the part of the statement of the state. Kindly see page number 77, which is the statement of objections filed before the tribunal by the respondent number 2 herein.
Yes.
This starts at para 5, the end of page 77. It is submitted that the second respondent is not a probationer. He is an IAS officer. He is an officer of Indian Administrative Service, IAS of 2022 batch. Officer was given posting as Assistant Secretary in the Ministry of Micro, Small and Medium Enterprise.
ಅದೇ repeat ಮಾಡಿದ್ದಾರೆ.
They repeat ಮಾಡಿದ್ದಾರೆ. Exactly. They have not explained anywhere earlier that no, this is not posting or this is only an attachment, and attachment is something different from posting. Now, my lords will see what has been stated by the tribunal in paragraph number 12 of its judgment at page 26. The reasoning start from page 26.
Yes. Yes.
If your lordships come to page number 29, para 13, even the tribunal was made to believe that this is his first posting itself. In the facts and page 29, para 13. In the facts and circumstances of the case, we hold the view that transfer of applicant has been done by following transfer guidelines and orders are issued with prior approval of the Honorable Chief Minister as per guidelines and in accordance with law. Respondent number 2 has been posted in place of applicant as it is his first posting, and transfer guidelines allow such posting. In the entire arguments which are recorded on behalf of the state as well as the respondent number 2, it is not recorded that this was argued. It was argued that the earlier posting was an attachment to a particular office and not a posting. So what was argued was this amounts to a posting only. In the teeth of the very categorical statement in page 63 and page 77 of the respondents respectively, that he was posted earlier at some place, my lords will see how they can overcome the rigor of Rule 5.1, Rule 5 subclause, Clause 5 subclause 2. I will read this, lords, how it is stated in English, page 88 and page 89. I will read the relevant portion of clause 2 of clause 5, page 88. At page 89, my lords will find or the relevant portion at page 89.
Yes.
Or when direct recruits are to be posted on their first appointment.
Correct.
It is not the state government appointing a particular person for the first time under its employment. So, my lords, this would not, this is one aspect of the matter. Secondly, my lords, I want to again reiterate with the permission of this honorable court, my lords, rule clause 5, if there was no clause 5, my lords, what would have happened as under clause 7 or the earlier guidelines? Transfers have to be made between the duration from the month of June or July. That is called the general transfer duration. Now, it's beyond June and July, there is no transfer permissible at all.
Yes.
If now, my lords, by virtue of clause 5, the general rule which says that all transfers have to happen between a particular duration in the year, that is now relaxed, saying that all right, after the month of June and July also, a transfer is permissible. Now, they cannot say, my lords, that this power under clause 5, that a transfer is permissible after the month of June or July, is to be understood dehors all other provisions and the guidelines. Now, they say that there is a different class of or category of employees which are referred in clause 5, and clause 6 and 7 refers to different category of or class of employees. That is not the purport of the very guidelines itself. The guidelines are made for the purpose of ensuring that all the classes of employees, all the classes of government servants are treated equally. The very purpose and object of the guidelines is to ensure that there is no discriminatory or unfair transfers of people or servants at the whims and fancies of the authorized person there, the competent authority. Now, not if it want, it is now argued saying that no, class 5 creates a different class. That is not even an argument which is permissible on the part of the state. They cannot, my lords, create classes who stand on the same footing. And a direct recruitee or a person who or a servant who did not have a posting earlier, or a person who is waiting for a posting, all of them do not fall in a different class altogether. There are different circumstances. There are only different circumstances under which these three kind of government servants can be transferred based upon the circumstances which are available. They cannot be treated as different class. The interpretation saying that under clause 5 anything can happen, kindly see what will your lordships will visualize how this will be operated if your lordships accept the argument of the learned additional advocate general. It says the under clause 5, where new posts are created. Now let me assume that it is a case of a spouse or a case where I am on a particular project where my expertise requires me to be continued there for the entire tenure of 2 years. And the new post is created there. Despite my requirement, because of my technical expertise there, would the government see that I am expelled from that post because another new post is created there and place somebody else there? Or due to retirement, promotion, resignation, this is a case also where this very officer, respond number 2, was waiting for 2.5 years. It is not a case of an exigency where without his services immediately something would not, the machinery would not run. He was, my lords, in service at Delhi just 1 month before this period. There is no extreme emergency that this respond number 2 has to be placed at my place by displacing me. So this interpretation of clause 5 as tried to be made by the learned additional advocate general may not be proper and may not be suitable also, my lords, for the case and the kind of activities that happen here in such kind of transfer cases. So far as, my lords, the judgment in the case of C. Manjunath, which is referee respond number 2, kindly see what is the judgment, my lords, that paragraph number 32, even in para 27 at the end and in para 32. Firstly, kindly see the end of para 28. The argument sought was that in such cases, there should not be a judicial review at all. May I read the last 4 lines of para 28, last few lines of para 28, last sentence. It says, we do not agree with such proposition, as no judicial review would be available for the petitioner when there is compliance of clause 9B of the transfer guidelines dated 7/6/2013. Clause B of 2013 guidelines are almost equivalent and perimeteria with clause 7 of the present guidelines. Then, my lords, will come to para 32 again. Therefore, we are of the view that transfer order passed by the respondent state is well within the bounds of transfer guidelines and in compliance with the requirement of clause 9B of the transfer guidelines dated 7/6/2013. Wherever, my lord, there is no infraction of the mandate under clause 9 there or clause 7 here, then, my lord, judicial review is not permissible, is what this court has held. But, my lords, here before your lordships, the case is whether there is an infraction of the present clause 7 or not. I am able to show to your lordships, and also the facts are clear. Independently, if the petitioner's tenure is seen, the petitioner has hardly worked for 7.5 months, or I may say about 6 months, excluding the period when she has worked as the election during the election period. So within 6 months, this is not permissible under 7. Now, lords, 5 would not override the provisions of 7 because just because there is a direct recruitee, it is nowhere stated in 5 that clause 7 can be given a go by. And the entire clause 5 is not applicable to the transfer of this petitioner, which is at page 58. One is at page 59, where the new recruitee is coming to be appointed. the reasons, so far as the argument, my lords, that reasons are not required to be given. I am not submitting, my lords, that this is a case where the Honorable Chief Minister had to assign reasons and the reasons are to be recorded. I am stating that for an approval to be obtained from the Honorable Chief Minister, the approval is required for the reasons which are available under clause 5. And my lords, if whether reasons are assigned or not assigned, this very document at annexure R3, page 74, is not saying that this is the first posting and therefore the approval is given. It specifically gives, though there was no requirement for assigning and recording reasons, the Honorable Chief Minister says for
Yes.
it is for Adalit, for public and administrative reasons only. So even the case that he is being posted here for the first time, or that the tenure of this petitioner is still up there, protected under clause 6, that is also not brought to the notice of the Honorable Chief Minister.
All right. Can we proceed?
Great.
Yes, please take down.
My lord, clarify only one submission. First posting and mention agide, Chief Minister.
Yes.
Para number 2 ali.
And my lords, pray for a moment's indulgence. The section reads direct recruit, my lords. It's direct recruits first posting, not trainees. He doesn't become a recruit till the day he finishes his training program and is issued.
You are right. You are
orders.
right in your submission.
Please.
See, the postings given there in the by the UPSC for the trainees.
Please.
It is a process of the training.
Please. About
Part of the training process.
Please.
Where they are required to go and officiate in a particular post.
Please.
All that confusion was created by you by stating posting was given.
Posting was given. Yes, my lord.
In both your statement of objections, you have used the word and they are taking advantage of that.
Please. About my lord, please.
Okay. The petitioner is aggrieved of the impugned order passed by the Karnataka State Administrative Tribunal at Kalaburagi in application number 21427 of 2024. Full stop. The petitioner, who was working as Assistant Commissioner, Raichur Subdivision, was transferred by order dated page number 74, annexure R3.
This 74 is signed on the 12th of September, whereas transfer order is is dated 13th of 13/9/2024.
Page number 59.
58 and 59.
58. By notification dated 13/9/2024. And posted as Assistant Commissioner, Karnataka State Highways Development Project, bracketally K-ship, Bangalore, in a vacant post. Full stop. The petitioner approached the Karnataka State Administrative Tribunal, filing an application while while contending that the transfer of the petitioner was in violation of the transfer guidelines that is the government order bearing number DPAR 33 STR 2024 Bengaluru dated 25/6/2024. Full stop. It was contended the respondent state and the contesting respondent have clearly stated in their objections that the second respondent herein is not a probationer. Full stop. He was posted as assistant secretary in the Ministry of Micro, Small and Medium Enterprises, Government of India in New Delhi from 25/2024 to 12/7/2024. Full stop. After the completion of the central services, the second respondent reported to the state government for posting on 5/9/2024. Full stop. It was therefore contended that the invocation of subclause 3 of clause 5 of the transfer guidelines insofar as respondent number 2 is concerned, was not available. Full stop. It was contended that subclause 3 of clause 5, no doubt makes provision that whenever a direct recruit is to be posted on his or her first appointment, such transfer would be permissible as an exceptional circumstance. Full stop. However, since the second respondent was not being appointed for the first time, the said clause could not have been invoked. Full stop. Before this court, learned senior counsel Shri Amit Kumar Deshpande, appearing for the petitioner, submitted that the said provision which carves out an exception for transfer will not by itself permit transfer of a government servant without assigning proper reasons full stop. It was submitted that the minimum period of stay at a place which is assured in terms of clause 6 of the transfer guidelines invests in the government servant a right to contend that he or she cannot be disturbed from posting at a place for the minimum period of tenure as contemplated in the said provision. Full stop. Learned senior counsel submitted that even if the respondent state, and more particularly the Honorable Chief Minister's approval is taken, such orders should necessarily contain the reason that would permit the disturbance of the petitioner contrary to clause 6 of the transfer guidelines. Full stop. Next para. Learned Additional Advocate General submits that the statement made in the objections filed at the hands of the respondent state, more particularly in paragraph number 6, that the second respondent was given a posting as Assistant Secretary in the Ministry of Micro, Small and Medium Enterprises, Government of India in New Delhi. Is not a posting in the sense, in the ordinary sense. Full stop. While drawing the attention of this court to the official memorandum dated 23/4/2024, by virtue of which the IAS officer trainees of 2022 batch were posted as assistant secretaries in various departments of the Government of India. It was pointed out that at two places in the official memorandum, the word attached is used and not posted. Full stop. The learned AG would therefore submit that it's a misnomer or a wrong usage of the word posting in paragraph number 6 of the statement of objections filed at the hands of the respondent state government. Full stop. However, the petitioner cannot take advantage of the same for the reason that such a statement has been made in the statement of objections. Full stop. Moreover, it is submitted that a person who is selected as an IAS officer, is necessarily given a cadre. Full stop. The second respondent is assigned Karnataka cadre. Full stop. Therefore, the question of appointing second respondent in some cadre at New Delhi would not arise. Full stop. It is therefore clarified that the second respondent, after completion of the training, reported to the state government for posting on 5/9/2024, and for the first time, the second respondent is given a posting as a direct recruit. Full stop. Learned AAG would therefore submit that there is compliance of the requirement of the transfer guidelines, which makes provision that when a direct recruit is to be posted on his or her first appointment, it would fall under the exception carved out in clause 5 of the transfer guidelines. Full stop. Learned AAG further submits that Annexure R3, which was produced by the respondent state along with the statement of objections, clearly contained the said reason, that is, the second respondent is being appointed as a direct recruit for the first time, and subclause 2 of clause 5 has been extracted in the said order, while the words when direct recruits are to be posted on their first appointment, close note comma, is very clearly stated in bold in Kannada. Full stop. This satisfies both the conditions that the posting of the second respondent in the place of the petitioner herein, and the reasons assigned would be in compliance of clause 2 of subclause 2 of clause 5 of the transfer guidelines. Full stop. Next para. Learned senior counsel Shri Ashok Harnalli, appearing on behalf of the second respondent.
In the recording of my argument, your lordships have not recorded that it was argued. It's a previous transfer in violation of Rule 7, Clause 7, if it is necessary.
Reiterates the submission made by the learned AAG that in terms of the official memorandum dated 23/4/2024, the second respondent was attached as Assistant Secretary and usage of the word single posted in the statement of objections filed at the hands of the second respondent and the state does not present the correct position. Full stop. The learned senior counsel placed reliance on a judgment of a coordinate bench of this court in the case of C. Manjunath versus State of Karnataka, reported in 2021, bracket 1, AIR, Karnataka, 140. अथवा 2020 bracket 0 Supreme bracket Karnataka 937. Where it was held, having regard to various judgments of the Honorable Supreme Court, including Mohammad Masood Ahmad versus State of UP and another, bracket 2007, close 8 SCC 150, and State of Punjab versus Joginder Singh Dutt, AR 1993 SC 2486, that an order of transfer is a part of the service conditions of an employee which should not be interfered with ordinarily by a court of law in exercise of its discretionary jurisdiction under Article 226, unless the court finds that either the order is mala fide or that the service rules prohibit such transfer, or that the authorities who issued the orders were not competent to pass the orders. Full stop. With these principles in mind, the learned senior counsel would submit that admittedly this is not a case of a mere transfer of one employee to the place of another employee, during mid-year. Full stop. It is submitted that various judgments are rendered by this court as well as the Honorable Supreme Court having regard to the protection offered to government employees of minimum tenure in a place, such cases arise in circumstances where a government servant is transferred and another government servant is posted in such place from another place. Full stop. It was found that in many of such cases, the orders of transfer were passed based on recommendations of the concerned minister and orders were being passed by the Honorable Chief Minister. Full stop. This is not a case where the second respondent was earlier holding a posting and is being posted by transfer. Full stop. The case of the second respondent clearly falls under the exceptional clause carved out in clause 5 of the transfer guidelines. Full stop. This is clearly a case of the first posting of the second respondent after completion of training. Full stop. It was also pointed out from the impugned notification dated 13/9/2024 that two other direct recruits of 2022 batch were given posting. Full stop. Shri Mukul Jain, comma, a batchmate of the second respondent, was posted as Assistant Commissioner, comma, Basava Kalyan, in the place of one Shri Prakash Kudri. Full stop. However, Miss Kumari Sahitya M. Aladakatti was posted as Assistant Commissioner, comma, Kalaburagi Subdivision. ಅಲ್ಲೂ ಇದ್ದಾರೆ ಶ್ರೀಮತಿ ರೂಪಿಂದರ್ ಕೌರ್ ಅಂತ ಇದ್ರು.
ಮೂರು ಜನರು ಟ್ರಾನ್ಸ್ಫರ್
ಅಲ್ಲಿ ಹವರ್ ತೆಗ್ದಾಕ್ಬಿಡಿ, ಆ್ಯಂಡ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. ಓದಿ ಈಗ. And
Serial number 2 is one which your lordships had seen, which shows that there is a promotion given to an who was working there.
Promotion.
And serial number 2 in page 74, Prakash Kudri is appointed as Assistant Commissioner Basav Kalyan in the place of the Shri Dayanand Patil Ravara Vayoniti. Sorry, Vayonivritti.
Auralala. We are talking of the direct recruits.
Yes.
He is not a direct recruit.
Yes, madam.
We are direct recruits are Mukul Jain, Kumari Sahitya, and Gajanan Bale.
True, madam.
Yes. We are referring to those. In a posting which was earlier held by Srimati Rupinder Kaur, comma, IAS. Full stop. Learned Senior Counsel would therefore submit that the posting of the second respondent as Assistant Commissioner, comma, Raichur would not have been questioned by the writ petitioner, comma, since the posting was clearly in compliance of all the requirements of law. And the posting given to the second respondent was not an isolated case. Full stop. Next para. We have heard the learned Senior Counsel for the writ petitioner, comma, learned AAG for the respondent state, comma, learned Senior Counsel Shri Ashok Harnalli for respond number 2 and have perused the petition papers. Full stop. Having regard to the submissions made by the learned senior counsels, we find that a wrong statement made in the statement of objections filed at the hands of the respondent state and the second respondent, stating that a posting was given to the second respondent as assistant secretary, in the Ministry of Micro, Small and Medium Enterprises, Government of India in New Delhi. Is being held against the second respondent and the state. Full stop. Now that the correct position has been clarified before this court, having regard to the official memorandum dated 23/4/2024, where the subject reads as subject : attachment of IAS officer trainees of 2022 batch as assistant secretaries in Government of India dash regarding close inverted commas. And further, that all such IAS officer trainees of 2022 batch were attached to various departments of the Government of India in New Delhi as assistant secretaries, clarifies the position that the said posting was not a regular posting, it was part of the training given to the trainee IAS officers at Mussoorie. Full stop. It is also true that the second respondent was conferred Karnataka cadre, and therefore his appointment as assistant commissioner, Raichur, is the first posting, and it falls under the exception carved out in subclause 2 of clause 5, which clearly empowers the state government to give such a posting to a direct recruit who is being posted for the first appointment. Full stop. The distinction sought to be drawn by the learned senior counsel appearing for the writ petitioner, that the said clause does not state that the appointment is being done for the first time in the state cadre, cannot be accepted, since this court finds that the second respondent is for the first time given a posting, and his posting as assistant secretary in New Delhi in a department in the government of India was not really a posting and it was a mere attachment, which forms part of the training process of the IAS officers. Full stop. We also do not accept the submission of the learned senior counsel appearing for the writ petitioner that if such a posting is sought to be given to the second respondent invoking subclause 2 of clause 5, even then a reasoned order should be passed by the respondent state with prior approval of the Honorable Chief Minister. Full stop. The appointment of a direct recruit, which is carved out as an exception for transfer of a government servant, is itself a reason enough for the transfer of a government servant. Full stop. The invocation of the clause and the fact that the second respondent is being posted for the first time after receiving the training as an IAS officer is the ground enough for transfer of the writ petitioner and posting of the second respondent in the place of the writ petitioner. Full stop. The two are mutually the two form two sides of the same coin. Full stop. The fact that the second respondent is being appointed for the first time as a direct recruit is a sufficient reason for transfer of the writ petitioner, midway, reducing the minimum period of stay, which is guaranteed under clause 6 of the transfer guidelines. Full stop. We also find that the tribunal has held that the transfer has been effected with prior approval of the Honorable Chief Minister and no malafides can be alleged and proved by the writ petitioner having regard to the reasons furnished for posting of the second respondent in the place of the petitioner, as Assistant Commissioner, Raichur. Full stop. We do not find any infirmity in the impugned order passed by the tribunal. Full stop. Next paragraph. Consequently, we proceed to dismiss the writ petition.
Grateful.
My lords, there was an argument with regard to there being a premature displacement of the petitioner. That was not recorded while your lordships recorded my arguments.
That is what I said. The posting invoking subclause 2 of clause 5 is
Yes.
the reason enough
Yes.
for the reduction of the minimum
Yes.
stay, which is guaranteed in clause 6.
Yes.
That is what we are saying.
Grateful, grateful.
Obligement.
Who is on the other side? Huh? We'll pass orders at 2:30. Huh?
Basic liberty, my lord.
Ivagala, let us see at 2:30. We'll see at 2:30, not now.
Court officer.
Your Lordship's kind permission. Item number 3, my lords, which is passed over. That's what I noticed, my lords, in item number 3.1, filed by the husband whom I represent. Lord, there's a delay of 75 days, my lord, that application is still pending consideration. And lords, my learned friend appears for the respondent wife. Subject to, my lords, what they say, you must kindly consider condoning the delay, and then the trial court records are not secured, my lords, in the connected matter. But in the first matter, my lords, the trial court records have come. I think for final submissions, trial court records may be necessary, my lords, from the family court.
Huh?
I have no objection to condone the delay. My lord,
Records for the, in the other matter also is necessary.
yes, 3.1, my lord, that is the certificate copy.
What is it?
In the morning, I didn't notice, my lords, otherwise.
Huh?
In the morning, I did not notice the.
Purple. Order on IA number 1 of 2023 in MFA 202852 of 2023. There is a delay of 75 days in filing the appeal. Learned counsel for the respondent fairly submits that the delay may be condoned. Full stop. Accordingly, delay is condoned. Full stop. Next para. However, learned counsel for the appellant submits that the trial court records pertaining to this matter is yet to be received. Full stop. Next para. Call for trial court records. In MC number 54 of 2010.
20, my lord.
Huh?
54 to 20, my lord.
20 na 2010 anta agide. 2020.
From family court, Bijapur.
Released these matters on 9th of December. Yes.
Put up, sir. Put up, sir. You take it, my lord.
Number 32, my lord.
correct.
ಅವ್ರು ಮಾತಾಡ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಹೌದೇ defective. ಸರ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರ್ ತಾವು ಮಾತಾಡೋದು. ಸರ್ ಲಾಗಿನ್ ಆಗಿ ಸರ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
All right.
I'll communicate.
Yes.
Seal number 32, my lord. Seal number 32, parties were tied.
Mediation ಕಳಿಸ್ಬೋದಾ?
Kalisbodu.
Huh? Both are present before the court. Both the parties are present before the court. The parties are.
May I request, my lord, since both of them are today present, any mediator, my lord, if they can start at least
Today
my lord, by
itself, the
today.
session could be started. Today itself.
ಅಲ್ಲಿ ಇರ್ಬೇಕಲ್ಲಮ್ಮ.
Sir, I have even asked from Deshmukh sir is there.
Deshmukh sir, my lord.
He said he is available at 3 o'clock.
Banda.
Mediators are there, they are available.
Had, my lord, talk to him. And he said,
Deshmukh.
ಹೌದು.
Yes.
SV Deshmukh.
SV Deshmukh.
The parties are directed to appear before the mediation center. Stop. Learned Counsel Shri SV Deshmukh. Is requested to do the mediation between the parties. Date fix ಮಾಡ್ಬೇಕಾ?
ಇವತ್ತೇ
ಇವತ್ತೇ
3:00, 3:30 ಹೇಳ್ಬಿಟ್ರು.
3:30.
Next date ಇಲ್ಲಿ.
ಇಲ್ಲಿ ಡೇಟ್ ಫಿಕ್ಸ್.
Till date.
First week of December.
Release this matter on 2nd of December. Please.
6th.
Huh?
6th.
ಇವಾಗ ಹೋಗ್ತಾರ ಅವ್ರು. Both
Now
of
it's
them are here. They'll go. Yes.
Great.
My lord, sir, serial number 36, on behalf of Hulappa Herur, sir, my lord, they gone for sudden demise of their relatives. He went for funeral, my lords. Therefore, short accommodation maybe.
Also, this is there is no urgency, my lord, in this matter, my lord. Respondents is already appointed, but they are working also, my lord. There's no urgency.
Serial number 36 at the request of learned counsel for the
Respondent.
David respondent. Release this matter on 2nd of December.
Obliged.
Yes.
But serial number 33, my lord.
Hmm.
This matter in lordship is directed the Tahsildar to file the report, my lord, regarding this Akkupatra issued by the municipal corporation Bidar. Akkupatra is, there is a encroachment and also margin case, my lord. This is margin case. Such a mal. But see, my lord, requested the ADLR, my lord, to submit the report. But your lordship is specifically directed, my lord, 7/11/2024. Certain, my lord, of
Yes.
conditions. Those documents is with the Karanja, my lord. She is written letter to them, my lord. Documents is not yet received. That's why, my lord, she will file the, my lord, report, my lord. After 2 weeks, my lord, any date may be fixed, my lord. After getting those documents, my lord, she will file the report, my lord.
ಆಯ್ತು
ಅವ್ರು ಹೇಳಿದ್ರು.
I am for.
You are from Mr. Mahajan.
No, my lord, I am
Huh?
for respondent number 6, my
No,
lord.
Mr. Sachin Mahajan office ಯಾರನ್ನ ಕರ್ಸ್ರಿ.
Inform to the margin also. Inform to the margin also. Because the report has to.
ಅವ್ರು?
ಹೌದು ಹೇಳಿದ್ದಾರೆ. ನಮ್ಮ colleague ಹೇಳಿದ್ರು.
I have informed my lord.
ಅಲ್ಲ ಇನ್ಫಾರ್ಮ್ಡ್ ಅಲ್ಲ ಅವ್ರು ಇದಾರಲ್ಲಿ.
ಇಲ್ಲ 10 ನಿಮಿಷ ಬಿಟ್ಟು ಬರ್ತೀನಿ ನಾನು.
ಆಯ್ತು ಬರ್ಲಿ ಅವರು. She did not wait. She can go.
Please.
I will pass order. Sir.
Great.
Yes.
CL number 6, Deepak V. Barad. CL number 6, Deepak V. Barad, Shukmar Tengli.
Shivkumar Tengli is out of station, Manoj.
Huh?
Taken on Wednesday.
Huh?
Shivkumar Tengli is out of station. Maybe taken on Wednesday. I have informed
that.
others.
Learned counsel for respond number 1, release this matter on 2nd of December.
CL number 3, Mahesh Patil.
The exclusion of the
Stepdaughter.
Page number 8, Manoj, para 18.
Stepdaughter.
Para page 8, my lord, para 18. The apex court, my lord, reiterating, my lord, on their
Facts it bunny. Where to get the facts?
Para 3, my lord.
Huh?
Para 3, second page.
Para 3 of?
My lord, the second page. Second page, para 3 of the judgment.
Para 3
Facts,
of?
no, facts of the present case, my lord.
Huh?
Facts of the present case.
ಹೌದು.
May I take, my lord?
ಯಾವ್ದು? ಹಾ. ರಿಟ್ ಅಪೀಲ್ ಗೌರ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿರೋದಾ?
Yes.
ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲಿ ಇದಾರೆ ಇದರಲ್ಲಿ?
16/2/2021, my lord. She made the, my lord,
Where
representation.
do we get the facts?
Oh, sorry.
ಅಲ್ಲ ನಿಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲಿ
Appeal
ಎಲ್ಲಿದೆ?
facts. Lord, page number 4, my lord.
ಪೇಜ್ ನಂಬರ್ 4.
Please,
ಹ್ಮ್.
please, sir.
Mother of respondent.
Kundamma died in arrestness on A6.
ನಾಗಮ್ಮ, her mother Kundamma died in harness on 6/8/2020 while working as Anganwadi worker. Respondent made a representation endorsement stating the respondent is stepdaughter of late Sri Gundamma.
Yes.
That it is an admitted fact?
Yes, ma'am.
Admitted fact.
Yes, ma'am.
Andre, she was not born to this
Kundamma.
Gundamma.
Yes, ma'am. Yes, ma'am.
But she was born to her husband.
Yes, ma'am. Yes, yes, ma'am.
Correct, ah?
That is admitted fact. Yes.
Yes. What is the judgment?
Lord, the second last page, Lord, para 18. The Supreme Court, my lord, reiterating, my lord, their earlier stand, my lord, para 18, my lord, the High Court has proceeded on the basis of the recognition of legitimacy in section 16. Is restricted only to the property of the deceased and for no other purpose. The High Court has missed the principle that section 16(1) treats a child born from a marriage which is null and void as legitimate. Section 16(3), however, restricts the right of the child in respect of property only to the property of parents. Section 16(3), however, does not in any manner affect the principles declared in subsection 1 of section 16 in regard to the legitimacy of the child. Our attention has also been drawn to a judgment of the learned single judge of the Madras High Court in M. Uttaraj versus Deputy General of Police, Tamil Nadu, adopting the same position. In the view which we have taken, we have arrived at the conclusion that the exclusion of a child born from a second marriage from seeking compassionate appointment order under the terms of the circular of the railway is ultra virus. A division bench of the Madras High Court followed the view of the Calcutta High Court in Namita Goldar in Union of India versus Karumbaya. A special new petition filed against the judgment of the division bench was dismissed by the court on 18 September 2017. We may, however, clarify that the issue as to whether in a particular case the applicant meets all the stipulations of the scheme, including financial need and other requirements, are matter which will be decided on the facts of the individual case. Finally, it would be necessary
So
to.
it's the same principles.
Yes, ma'am.
As we have rightly understood. Insofar as the declaration of the rights of an illegitimate child towards property rights.
Yes, ma'am. Yes.
Has been declared by the Honorable Supreme Court as having all the rights equal to the naturally born children.
Yes.
Isn't it?
Yes, ma'am.
The same principles are to be
Applied,
followed
applied
here.
even for the appointment for compensate grounds also.
And which is the provision now? Which is the provision that is governing?
My lord, the 1996, my lord, the compensate ground, appointment of compensate ground rules 1996.
Anganwadi workers here. How do you say that
Yes.
these rules are adopted?
Even idralli, there is a provision even in.
Government orders, my lord, that is. As per this government order, my lord, she is not eligible.
Huh?
Government order, my lord, there is a guidelines, my lord, by the government.
ಇಲ್ಲಿ ಹಾಕಿದಾರಲ್ಲ ಇದರಲ್ಲಿ
ಅದರಲ್ಲಿ provision statement.
ಅದು ಅನಕ್ಷರ H ಅಂತ ಯಾವ್ದೋ ಒಂದು ಸುತ್ತೋಲೆ ಒಂದಿದೆ.
ಅದೇ ಅನಕ್ಷರ R6.
34/2022.
Yes.
ಇದ್ಯಾವ್ದು ಇದು?
Yes, 13/12/2022, 3/12/2022, my lord.
ಹಾ, ಇವರದೇ ಸೆಪರೇಟ್ ಆಗಿದೆ.
Yes, there, my lord, I 8 clause, my lord, 8, my lord.
ಹಾ.
8(1).
ಆ ಕುಟುಂಬದ ಸದಸ್ಯರಿಂದ ನಿರಾಕ್ಷೇಪಣ ಸೇವೆಯಲ್ಲಿರುವಾಗಲೇ ಮರಣ ಹೊಂದಿರುವ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಸಹಾಯಕಿಯರ ಮಗಳು ಅಥವಾ ಸೊಸೆಯನ್ನು ಅರ್ಹತೆಯ ಮೇಲೆ ಅವರ ತಾಯಿ ಅತ್ತೆಯು ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಸಹಾಯಕಿಯ ಹುದ್ದೆಗೆ ಅನುಕಂಪದ ಆಧಾರದಲ್ಲಿ ಆ ಕುಟುಂಬದ ಸದಸ್ಯರಿಂದ ನಿರಾಕ್ಷೇಪಣ. So provision is made even for a daughter-in-law.
Daughter-in-law is also there. Daughter and daughter-in-law.
Correct.
Not a stepdaughter.
ಬರೋದಿಲ್ಲ. That is what Supreme Court is saying. The judgment that is reading is of the Supreme Court. That is also pertaining to compassionate appointment. See, that is what we were discussing. In the law, while analyzing the provision for succession, the Supreme Court has held, though a person who is illegally married another person, andre that lady who has married a married person, that marriage though illegal, however, in respect of illegitimate children, the law declared is that they will have equal rights as that of the natural children.
It is recording, my lord, partition also.
On the same analogy, here the Supreme Court is saying, in the view which we have taken, we have arrived at the conclusion that the exclusion of a child born from a second marriage from seeking compassionate appointment under the terms of the circular of the railway board is ultra vires. Alli a provision they had said no, we are not going to give appointment. That provision has been held ultra vires. Illi there is no express provision. You are only trying to interpret the word daughter.
Yes.
Will, according to it, does not include a stepdaughter.
Yes.
You are trying to give an interpretation. Supreme Court has gone to an extent of saying, if you have that kind of a provision, it will be declared ultra vires. Kotra, the copy kotra judgment.
Yes, sir.
Nodi, paragraph number 18. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಆ ಪೇಜ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 8
ಪ್ಲೀಸ್
ಕೆಳಗಡೆ ಪೇಜ್ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ 8 ಕೆಳಗಡೆ ಇದೆ ನೋಡಿ
ಪ್ಲೀಸ್
ಪೇಜ್ ನಂಬರ್ 8 ಅಲ್ಲಿ
yes
ಮೇಲ್ಗಡೆ ನೋಡಿ ಫಸ್ಟ್ section 16(1) of the aforesaid act creates a legal fiction whereby a child born out of void marriage shall be held to be illegitimate. So there was an express provision there.
16(3).
That provision is held to be ultra vires. So therefore, your interpretations ought to be given now. A daughter will not include a stepdaughter. That cannot be accepted. This is regarding married daughter. Idu illegitimate child. Recently. VR Triparty. I have cited this in one judgment.
Please.
One of these judgments I have cited this. Union of India versus VR Triparty. This is in writ petition number 28,676 of 2018, Lohit Gowda versus State of Karnataka and another. This I had decided in April 2019.
Please.
Adralli, I have made use of this judgment. In the light of the above, this court deems it fit to quash the impugned order and directing the response number 2 to reconsider the application in the light of the judgment of the Supreme Court.
Your Lordship, direct the authorities to reconsider.
ಇದು ಯಾವ್ದೋ ಇನ್ನು ರೀಸೆಂಟ್ ಇದೆ ಅಂತ ನೋಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. Of course, idrallu VR Tripathi has been noticed. This is Mukesh Kumar and another versus Union of India and others, 2022 live law, SC 205. Railway Board circular that compassionate appointment cannot be granted to children born from the second wife of a deceased employee. Same. Rules of compassionate appointment cannot violate the mandate of Article 14 of the Constitution. Once Section 16 of the Hindu Marriage Act regards a child born from a marriage entered into while the earlier marriage is subsisting to be legitimate, it would violate Article 14 if the policy or rule excludes such a child from seeking the benefit of compassionate appointment. Purple.
If that candidate is, my lord, otherwise eligible, my lord, that will be.
All other, no, of course, fulfilling all other requirements is essential.
Please.
ಯಾಕ್ರಿ ಇವೆಲ್ಲ ನೀವು ಸಿಂಗಲ್ ಜಡ್ಜ್ ಇಂದ ಸೈಟ್ ಮಾಡಿಲ್ಲ? ಸೈಟ್ ಮಾಡಿದ್ರೆ ಅಪ್ಪ ಅವರು ಇದೇ ಆರ್ಡರ್ ಬರೀತಾ ಇದ್ರು. ನಾವು ಸೈಟ್ ಮಾಡ್ಲಿಲ್ಲ, ಈ ತರ ಆರ್ಡರ್. Why did you not cite?
Lord, the learned, my lord, single judge was, my lord, he was convinced, my lord, at the outset, my lord, that the petition, my lord, should be allowed.
Huh? You convinced?
My lord, the court was, my lord, was of the opinion, my lord, that, my lord, the petition should be allowed at the outset.
Allowed?
Allowed.
We challenge that one.
They have challenged, I have filed contempt. They have challenged.
ಹೌದಾ? ನಿಮ್ದು ರಿಟ್ ಅಪೀಲ್? So it has been allowed.
Yes.
But without
violation of section Article 14 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Article 14 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Not to cite
So your contention was other than saying it violates Article 14, there is nothing else said on. ಇದರಲ್ಲಿ ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಹೌದು ರಿಟ್ ಅಪೀಲ್ the state of Karnataka through its principal secretary, Department of Women and Child Welfare Department of Women and Child Welfare has filed this appeal, intra-court appeal, calling in question order passed by the learned single judge in WP number 2000084 of 2023, dated 3rd of August 2023. Full stop. Next para. The respondent herein had filed the writ petition, aggrieved of the rejection of her application for appointment on compassionate grounds, as an Anganwadi worker, consequent to death of her mother, Srimati Gundamma, who admittedly died in harness on 6/8/2020. Full stop. Srimati Gundamma was admittedly working as Anganwadi worker at the Duttargaon, Anganwadi Center, Aland Taluk, Kalaburagi district. Full stop. The reasons for rejection of the application was that the writ petitioner is not the naturally born daughter of Srimati Gundamma. Stop. The writ petitioner is admittedly the stepdaughter of Srimati Gundamma, and that she was born to Srimati Gundamma's husband through another lady. Full stop. The authorities therefore held that a stepdaughter is not entitled for appointment on compassionate grounds. Full stop. However, learned single judge allowed the writ petition on the ground that such an opinion of the authorities debarring a stepdaughter from seeking compassionate appointment would be per se illegal and contrary to Article 14 of the Constitution of India. Full stop. The contention of the appellant state, however, is that a judgment cannot be passed by a court of law contrary to a provision of law. Full stop. Full stop. Learned government advocate submits that in terms of the guidelines issued by the state government by government order dated 3/12/2022. Huh?
13:1, Roman 13:1.
Sorry. Clause 13 provides 13(1) provides that whenever an Anganwadi worker or assistant dies during the course of her employment, her daughter or daughter-in-law are entitled for appointment on compassionate grounds, subject to the other members of the family giving no objection certificate. Full stop. Learned government advocate submits the authorities have rightly interpreted the word single commercially daughter to mean a naturally born daughter, and it cannot include a stepdaughter who was not born to the Anganwadi worker bar assistant. Full stop. Next para. However, learned counsel for the respondent places reliance on two judgments of the Honorable Supreme Court, namely Union of India and another versus B.R. Tripathi. Comma 2019 bracket ಅಲ್ಲಿ 14 SCC 646 and Mukesh Kumar and another versus Union of India and others. Comma 2022 live law bracket SC 205 and submits. That the Honorable Supreme Court has declared that once Section 16 of the Hindu Marriage Act regards a child born from a marriage entered into while the earlier marriage is subsisting, comma, to be legitimate, comma, it would violate Article 14 if the policy or a rule excludes such a child from seeking the benefit of compassionate appointment. Full stop. It was held that the circular issued by the Railway Department creates two categories between one class and it has no nexus to the objects sought to be achieved. Full stop. Once the law has deemed them legitimate, comma, it would be impermissible to exclude them from being considered under the policy. Full stop. Exclusion of one class of legitimate children would fail to meet the test of nexus with the object, comma, and it would defeat the purpose of ensuring the dignity of the family of the deceased employee. Full stop. Next para. Having regard to the law declared by the Honorable Supreme Court, comma, we are of the considered opinion that the appellant authorities are required to reconsider the application filed by the respondent. Full stop. It goes without saying that the respondent would be entitled for a appointment on compassionate grounds, comma, if the respondent fulfills all the other conditions. Full stop. Next part. The outer limit of 4 weeks as directed by the learned single judge would recommence from today. Stop.
The date of the order. From the date of the order,
ಯಾಕ್ರಿ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ರಿ ನೀವು.
because that has to be sent to them, my lord, along with the order only, my lord, then.
From the date of receipt of a copy of this order. Full stop. Next para. Contempt petition ಅಲ್ಲಿ the light of the dismissal of the writ appeal filed at the hands of the respondent state by an order of even date, this contempt petition is also disposed of in terms of the directions issued by this court in the writ appeal, that the orders passed by the learned single judge shall be complied within a period of 4 weeks from the date of receipt of a copy of this order. Copy of the order of this court passed in the writ appeal.
Please.
The complainant is also permitted to file a seek revival of the contempt petition, if there is non-compliance of the orders passed by the learned single judge.
We can file the, my lord, contempt against the passing by your lordship's order only, because your lordship is granted, my lord, 4 weeks time.
ಅದಕ್ಕೆ
Need not
ಅದನ್ನ
to
extend
revise the
ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿದೀವಿ.
Can
But the
file
original order is of the learned single judge only. It's the time starts counting from the day when you receive the order. Yes.
Seal number 18, passed over matter. Kumar Amargundappa.
In this case, senior counsel is appearing, my lord, and
ಯಾವುದು?
in this matter pertaining to, my lord, OTS scheme.
ಏನು?
Last occasion, they filed memo. May I request, my lord, 1 more week time, because it involves, my lord, some auditing and all. Therefore, I'll file written objections to the memo filed by
Learned counsel for the appellant submits that the memo of calculation filed at the hands of the respondent bank requires to be scrutinized by an auditor before any submission could be made on behalf of the appellant. Full stop. Therefore, the learned counsel seeks for 1 more week's time. Full stop. Release this matter on 2nd of December.
please.
Seal number 27. Admission matters, Venkatesi Mallabadi.
Here, ಬರ್ತಾನೆ last time ಬಂದಿಲ್ಲ.
No, according to my client has been married now, she is not living.
Matter is called out. There is no representation for the appellant. Your client is a lady.
Yes, ma'am. Divorce has been,
He had filed,
no, husband has filed a divorce, it has been rejected. Against that, they are. It's good.
your client has remarried.
No, no. The appellant has filed a divorce petition before Bijapur court.
Correct.
It has been rejected.
ಹೌದು.
Again, therefore, they filed MFA here, my lord.
ಹಾ.
So I contacted my client through somebody, but she's not lifting. It is heard that she has married.
She has married.
Yes. Consolation ಬಹಳ ಆಯ್ತು ಇಲ್ಲಿ ಆಗ್ಲಿಲ್ಲ.
ಅಲ್ಲ, the husband is also asking for divorce.
Yes, husband is asking divorce.
ಇದ್ಯಾಂಗಾದ್ರೆ you should have, ಅಲ್ಲ, you should have agreed for the divorce.
I agreed ಅಲ್ಲಿ ಏನು ಅಲ್ಲಿ ಆಂಧ್ರದಾಗ ಏನೋ ಪ್ರೊಸೀಡಿಂಗ್ ಅದು ಕನ್ಜುಗಲ್ ರೈಟ್ಸ್ ಹಾಕಿದ್ರು ಏನೋ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ ನಡೆದಿದ್ದು.
How did you proceed to remarry now?
Now ಅದು.
Allah, it was very easy for you to have come before this court and said, okay, allow the.
No, I was calling like anything, she's ನಂದು ಫೋನೇ ಇದು ಮಾಡ್ಬಿಟ್ಟ. Once she lifted, then nobody is lifting my call. Probably ಅವ್ರದ್ದು ಹಾಗೆ కదా, they are not at all showing interest.
So, even on the previous date of hearing, there was no representation for the appellant. ಅವರು ಬೇರೆ ಮದುವೆ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ
ಅನಿಸ್ತದ ಸರ್, ಅದಕ್ಕೆ ಅವ್ರು ಬರ್ತಾರೆ.
ಹಂಗಿದ್ರೆ at least both of you can come before the court and.
I am regularly coming, my lord, they are not at all coming to the court. ಅವ್ರನ್ನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ.
Already, but it will also be in the interest of.
ನನಗೆ ಆಗ್ತದ, ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅವ್ರಿಗೆ, but no response, my lord. Every time I am calling for this. ಅವ್ರು ಬಂದ್ರೆ ಆಗ್ತದ.
If there is no representation for the appellant of the next date of hearing, this appeal will be dismissed for non-process. Full stop. Release this matter on 2nd of December.
Seal number 28, Hanmantraj Sindhu.
My lord, I am appearing for appellant. It is filed for the enhancement of the quantum of the compensation. The future prospectus is not added, my lord. It is a case of death, my lord.
Where is this Sanjay Joshi? Sanjay Joshi. ಅವ್ರನ್ನ ನೋಡೇ ಇಲ್ವಲ್ರಿ ನಾವು ಬಂದ್ಮೇಲೆ.
Sanjay M. Joshi.
Sanjay M. Joshi is there. Preeti Patil, Melkundi is there.
Page 23.
ಇಲ್ಲ, ಅವ್ರಿಬ್ರಲ್ಲಿ ಯಾರೋ ಒಬ್ರು. ಯಾರ್ದು ರೀಸೆಂಟ್ ವಕಾಲತ್ತು? ಹಂಗಾದ್ರೆ ಇವ್ರದ್ದು ಪ್ರೀತಿ ಪಾಟೀಲ್ ಅವ್ರನ್ನ ಹೆಸರು ತೆಗ್ದಾಕ್ಬೋದು. ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್. Matter is called out. There is no representation for the respondents. Stop. Office is directed to remove the name of learned counsel Srimati Preeti Patil Melkundi, since learned counsel Sri Sanjay M. Joshi is appearing for respondent number 2. Release this matter on 2nd of December.
Seal number 29, Ravindra Reddy.
Lord, in this case, my lord, in this case, I appear for respondent number 4. Shri Shivanand Patil sir has filed wakalat along with me on behalf of respondent number 5 to 10, my lord, on 22nd 11/2024 itself. His name is not shown, and also, my lord, he is not in station today. His name is not shown in the cause list, and also, my lord, he is not in station. Yes, request.
Both of you are appearing.
Along with, I appear for respondent number 4, my lord, and 5 to 10, along with Shivanand Patil.
ಅದೇನ್ರಿ ಅದು?
Along with, my lord, along with me.
ಇಲ್ಲ, along with ಅಲ್ಲ, ಏನು ಇಬ್ಬಿಬ್ರ ಹೆಸರಲ್ಲಿ ಹಾಕಲ್ಲ ನಾವು.
ಅಲ್ಲ, ಒಂದು 5 to 10, my lord, Shivanand Patil sir is appearing. This matter was heard for some time, my lord. This is in regard to, my lord, change of rules during the, once the process is commenced, in regard to selection is concerned. In view of recent judgment, my lord, constitution bench judgment, lordships heard, and university who has to reply. We have made our arguments. Wherein
You are appealing for the university.
Please, I will get the records, my lord, short accommodation. I will get the records, my lords. The
entire records there.
the university has to establish that, my lords, in the middle of recruitment, there are certain administrative orders, my lords, with reference to certain provisions, my lords. I need to file it. I will file the memo, my lords.
Already, you are in writ appeal, isn't it?
Yes.
All this was not considered before the learned single judge?
ಕೆಲವೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿರಲಿ, ಕೆಲವೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್
So
ಹಾಕಿ.
in view of judgment, they want to cover the, whatever the principles have been laid down.
Applicable to the
Not
present case,
rules.
Serial number 30, I am appearing for the respondent.
30?
Yes.
Same, my lord, 30 also same. They are also
Identical.
the change of rules. during the process of selection. The selection process was completed. At that time, they changed the scorecard. The scorecard model which was prevailing as on the date of notification, is Annexure A.
Why the learned single judge has not accepted your contention?
Lords, the writ petition was partly allowed, my lords.
It has been allowed, my lord, but while considering the
4/9/2017 was set
scorecard, my
aside.
lord, the learned single judges should have considered Annexure A, the scorecard to be considered for the purpose of
Selection
selection.
criteria held pursuant to notification date 9/4/2016 are changed after conducting the examinations. The respondents are directed to prepare a fresh list of selected candidates in terms of eligibility criteria prescribed under the notification dated so on. Since the criteria for the post of typist, computer operator are partially modified in terms of notification dated 15/3/2017, the selection list of typist, computer operator is to be prepared as per the eligibility criteria prescribed under notification dated so and so on. How are you agreed?
Not I am agreed, my lord, because as on the date of notification, not Annexure A, scorecard was 29/2010.
Respondent.
I am the appellant, I am the petitioner, my lord, because I am, in regard to scorecard, which was prevailing as on the date of notification was not Annexure A, that is dated 29/2010. That should have been considered in regard to the process of selection is concerned. But single judge, my lord, instead of that, directed to consider scorecard wide Annexure C, my lord. C and E. I'm sorry, C and F. C is 9/4/2016 and F is 15/3/2017.
9/4/2016.
And 15/3/2017. F.
When was the notification issued?
Annexure B, my lord, 4/11/2015.
4/11/2015. 2015.
Yes, ma'am. And last date for filing application was 3/12/2015.
3/12/2015. Examination was conducted on?
Examinations, it was conducted, the syllabus was issued by the Annexure H, my lord, 25/4/2017.
25/4/2017. So therefore, these two notifications were issued before the examination was conducted.
Yes, ma'am.
Yes, that is the reasoning.
That is the reasoning, my lord. But in view of Constitution bench judgment, my lord, the selection process commences immediately after invitation of issuing of recruitment notification.
Yes.
And as well as the last date for filing application. This is a post for a typist and computer operator, my lord. The first notification rightly not prescribed practical test, that is typing speed test was prescribed by providing 50 marks.
Annexure A.
Annexure A, my lord.
That was actually issued in the year 2010.
10. As per the notification, note, that was the notification which said that as on the date of notification, the prevailing
In
score.
the notification?
Annexure B, my lord. In page 84.
84.
80.
Eli, where is that reference to that
yes,
notification dated 29/2010? Guidelines for the candidates applying for the posts of service personnel in US Raichur.
Page 91. Guidelines number 28. Practical written tests shall be conducted for the posts of service personnel wherever required for recruitment as per the scorecard already published in US website before oral interview. This is as per the notification, my lord, dated 4/11/2015. As on this date, my lord, this was the scorecard, my lord, which was existing, which was published in the website.
Practical written tests shall be conducted for the post of service personnel.
Yes.
Wherever record for recruitment.
Yes.
As per the scorecard.
As per the scorecard.
What was the difference?
No, difference is not, the first scorecard not very notified, mentioning like, not the requirements were on annexure B, page 82. But first is merit in prescribed qualification for the post. Next is additional qualification, experience in the concerned field, and next is the practical test suitable for the post. Not 50 marks. And in regard to practical test, there was a note. Next, after box note, out of 50 marks, earmark for PT, a candidate must score 35 marks to be eligible for interview. This was the requirement. But to cover up this requirement, they brought written test, subsequent scorecard, to see that some of the candidates who were getting eliminated in view of this prescription, not brought written test and gave more marks in the written test and covered by giving 100 marks as eligibility. But if this,
Where is that?
yes, ma'am. If this marks is considered, Lord, the respondents who were selected, not
So all these contentions were upheld.
all these contentions
But,
were upheld, but while considering in
that,
regard to which notification has to be considered in regard to scorecard is concerned, Lord, learned single is not failed to consider whether the scorecard which was prevailing as on the date of notification to be considered, that has not been accepted.
ಎಲ್ಲಿ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಅದು ಬೇರೆ ತರ ಬಂದಿರೋದು?
Para 38, page 46.
Para 55
38, page 46.
38 ಇಲ್ಲಿ what is this paragraph number 55? Admittedly, in the instant case, there is no binding law that would come to the rescue of the petitioners to say that the examination to be held as per the law. In the absence of law relating to criteria for selection of employees, the board of the university has evolved certain eligibility criteria, and the eligibility criteria are modified on the ground that the modified eligibility criteria will be in tune with the eligibility criteria fixed by other universities in the state. Other significant factor to be noticed is that in this case, the corrigendum 2 dated 11/4/2016 under notification dated 9/4/2016. This corrigendum reveals that the decision to follow the selection criteria prescribed in Amendment Rule 2015 is taken by the university in the 26th meeting of the board. The board's decision is preceded by the 27th meeting of the coordinate committee. This Manjushri was what had fallen for consideration in the recent judgment.
Yes, Manjushri's judgment was considered to be right law which was laid down. But at the same time, Lord, the Constitution bench held that in regard to process of selection is concerned, it is a date of notification. Judgment is there. My lord, may I make one request? My lord, may I make one request? Apart from, my lord, papers produced along with writ appeal, my lord, there are some documents which are missing. In fact, my lord, petitioners themselves have, my lord, requested the respondent university to, my lord, to conduct exams as per the changed criteria, my lord. They accepted the changed criteria, my lord. Issued by the.
No question of some candidates.
No, not some candidates, my lord, very same petitioner.
Madak baradilla.
Those records are also.
Even at their instance, it cannot be done.
My request would be, my lord, any date, my lord, next, because there are a lot of factual aspects, my lord, involved. After 2 days, my lord, or Friday, that is my request. Para 42 only, last page 42.
Conclusion.
Yes, conclusion.
Page 100. Page 100.
The first one, 42-1. Yes. Recruitment process commences from the issuance of the advertisement calling for applications and ends with the filling up of vacancies.
Once notification is called for, my lord, process commences. And in regard to practical test, my lord, all these selected candidates secured very less marks in typing speed, my lord. For that reason, my lord, at the initial stage, they were placed in non-eligible list.
In the light of the discussions made above, the findings are the decision of the university to drop the scorecard method after conducting the examination in terms of notification dated 9/4/2016 and 15 is contrary. But how is it that this
Later,
9/4/2016 and 15/3/2017 was accepted?
not only because, my lord, still these examinations and interviews were not conducted. For that reason, my lord, before, only because, my lord, the examinations and written test and interviews were not conducted. For that reason, till that stage, it can be modified. That was the finding of the Lansing judge.
They participated.
And even your lordship may kindly see, in this case, 3 times they modify the scorecard. That is, one is 9/4/2016 and another is, my lord, 15/3/2017, and then at the after written test and after interview, but they change again the scorecard by annexure L. That was set aside by Lansing judge.
Petitioners number 4 and 5 in WP number so and so, petitioner number 1 in WP number so and so have applied to the post after the notification dated 4/9/2016.
Yes, ma'am. Of course, in regard to petitioner 1, 2, 3, my lord, they applied as per the 2015 notification. But only in regard to petitioner 4 and 5, they applied 2016 notification.
Even that one
Yes,
will not be in terms of the direction now the decision of the Supreme Court. It doesn't depend on when you file the application.
Yes, ma'am.
It all starts from the date when the advertisement is issued.
Yes. And even 2016 notification, it is not a fresh notification. It is a continuation of 2015 notification.
Correct. Yes.
Friday, my lord.
Records bekilla.
Yes, Friday, my lord, it may be taken. On that day, I undertake to trust out.
You will have to make your submission in the light of the judgment of the recent judgment of the Supreme Court.
Apart from, my lord, changes, changing, my lord, rules.
There are certain
Principle of based on the principle of estoppel, my lord, they having participated consciously.
Estoppel baradilla.
In that regard,
Service law baradilla.
there is,
Because it doesn't depend on the petitioner or some person who comes to the court. It's not like that. Estoppel barala.
acquiescence ಬರುತ್ತೆ.
Huh?
Acquiescence ಬರುತ್ತೆ. Estoppel ಬರೋದಿಲ್ಲ, acquiescence ಬರುತ್ತೆ.
No.
But in K Manjushri case, my lords, after selection list, lords notified, Thereafter, my lords, full court taken a decision to change scale down the marks which are earlier introduced. Lords, in the instant case, my lords, in each and every stage, my lords, university notified the petitioners regarding change in the scorecard. My lords. And there is no much difference in the change in the scorecard, my lords. Since in the K. Manjushri case, my lords, the rule was changed without notifying the petitioners therein.
It's not because of that, sir.
Lords,
My lord, in fact, I have instructions, even petitioners have applied for some other job and they are working in some other department also. And whereas in
let
case
them
of
point out, let them point out.
respondents, they are
Only
totally
petitioner.
work ಮಾಡ್ತಾ ಇದ್ರಂತೆ.
Now we are,
They are
if
appointed as
any
FA
subsequent
in
changes are there,
some court.
what we have challenged, it is the date of notification and the process. Initial stage, not in the first round of round of writ petition.
Seventeen, 16, 17, 18 ನಮ್ಮೂರು. ನಾವು ಡ್ರೈವರ್ ಕಡೆಗೆ ನಾನು ಅಪ್ಪಿರಲ್ಲ. 16, 17 ಡೇಟ್ ಚೇಂಜ್ ಮಾಡಿ. ನೇಮಕಾತಿ ಆದೇಶ ಬರೋದು.
Para number 39. This is the paragraph where the law is laid down. Please read it out.
Yes. There can therefore be no doubt that there are no rules are silent on the subject. Administrative instructions may be
There
issued.
can therefore be no doubt that where there are no rules or the rules are silent on the subject, administrative instruction may be issued to supplement and fill the gaps in the rules. In that event, administrative instructions would govern the field provided they are not otherwise the provisions of the rules or the statute or the constitution. But where the rules expressly or impliedly cover the field, the recruiting body would have to abide by the rules.
Yes.
This is the law.
Yes.
ನಮ್ಗೆ ಅಪ್ಲೈ ಆಗ್ತದೆ
Friday. Friday.
You are appearing for the candidates.
Yes, ma'am. 2017, my lord,
they are
they are-
working.
since 2017, they are working. At the instance of my lord, 3
working.
petitioners,
Yes,
yes, they are working. Well.
27.
They are given
27.
promotion. And now, my lord, they are.
We have challenged, Lord, of course, the selection is itself, in terms of the order, Lord, the selection itself has been set aside. The learned single judge has directed to redo the list. Even while redoing the list, Lord,
ನೀವು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ನನಗೆ
ಮಾಡಿಲ್ಲ.
in so far as.
ಮಾಡಿಲ್ಲ, ಅದನ್ನ ಮಾಡಿಲ್ಲ. That has become attained finality.
ಯಾರ್ದು typist ಗೆ ಏನು ಹೇಳಿಲ್ಲ.
Oh, typist.
ಅನಕ್ಷರಲ್ಲಿ ಹೋಗಿ
Selection has been set aside.
ಮಾಡಿಲ್ಲ.
Direction has been issued to redo the list in terms of the notification.
You have not challenged it.
Yes, yes. In fact, we have not challenged.
ಮತ್ತೆ
ಇದು 49 annexural. Quashing of annexural is not challenged by the selected candidate.
ಮತ್ತೆ what are you doing then?
Notice itself is not 9th September 2024. We have filed.
So even if this appeal is dismissed, still your job will be in peril.
If they are meritorious.
Because it
then-
is being directed to redo the list.
In fact, I am told, my lord, I am told that that is not going to affect the.
Already, the direction is to redo the list.
Correct, my lords.
Then,
Redo in terms of annexure L.
huh?
Only in case, my lords, if they find in meritorious list, then they are again accommodated, otherwise no. There is a direction to
First of all,
redo.
they have to.
The, what is the operative portion?
Each case, there are
Yes.
separate operative portion note. This
Each
serial
case.
number 29 is WP 208.
Notification dated 4/9/2017 is quashed. 4/9/2017 is quashed. Prior to quash, the selection list
Selection list is also.
is rejected. Prior to quash, the selection list is rejected. Prior to issue mandamus to direct the respondents to proceed with the selection on the basis of notification date 29/2010 and 2015 is rejected.
Para 69 is the operative portion directions.
Huh?
Page 58, my lord, 69, my lords, page last. Since the selection criteria held and started.
Ade.
Pursuant to notification dated 9/4/2016 are changed after conducting the examination. The respondents are directed to prepare the fresh list of selected candidates in terms of eligibility criteria prescribed under the notification dated 9/4/2016. Since the criteria for the post of typist computer operator are partially modified in terms of notification dated 15/3/2017, the selection list of typist computer operator is to be prepared as per the eligibility criteria prescribed under the notification dated 9/4/2016 and 15/3/2016.
ಎಲ್ಲ change ಆಗಿ ಆಗುತ್ತೆ.
In respect of computer and till today it is not done.
ಏನ?
It is not done. It is because it is no way going to affect, my lord, the. ಇಲ್ಲ, ಇವ್ರಿಗೆ
ಆಗುತ್ತೆ, fresh ಅಂದ್ರೆ ಆಗುತ್ತೆ.
Page 66 note in direction. Page 66/440. The notification dated 4/9/2017 annexure L is quashed. The notification annexure M dated 10/11/2017 is quashed insofar as it relates to typists and computer operators. Insofar as annexure M, you'll also may kind of peruse in page 107. This is a selection result, eligibility list which was issued in regard to typist. ಅರ್ಹ ಅಭ್ಯರ್ಥಿಗಳ ನೋಂದಣಿ ಸಂಖ್ಯೆಗಳ ಪಟ್ಟಿ ಇದರ ಎರಡನೇ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಕೆಳಗಡೆ ನೋಂದಣಿ ಪಟ್ಟಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಟೈಪಿಸ್ಟ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟ್ ಒಟ್ಟು ಹುದ್ದೆಗಳ 47, ನೇರ ನೇಮಕಾತಿ 20 ಹಾಗೂ ಆಂತರಿಕ ನೇಮಕಾತಿ 22. ಅರ್ಹ ಅಭ್ಯರ್ಥಿಗಳ ನೋಂದಣಿ ಸಂಖ್ಯೆಗಳ
ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ಸ್
typist computer operator.
ಟೈಪಿಸ್ಟ್ ಟೈಪಿಸ್ಟ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ಸ್.
This has been set
ಅದು ಆಗಿದೆಯಲ್ರಿ ಡೈರೆಕ್ಷನ್.
This has been set aside.
But in view of even if it is, my lord, if we if university go by with the directions issued by the learned single judge, it is going to affect it is not going to affect the rights of, my lord, typists. Ultimately, they will be the eligible candidates, meritorious and eligible candidates.
Annexure M has been quashed, my lord. At the same time, consequently, even selection list should have been quashed, but that has been challenged, my lord, because of non-quashing. Because once the eligibility list has been quashed.
I don't think there is there is need to look into the records now. We can proceed.
Friday, my lord. Maybe take
Please.
Friday.
We had only asked you to go through this judgment and make
Yes, yes.
submission.
Please.
ಯಾವತ್ತು?
Friday.
Friday ಇಲ್ಲ.
Please, Monday, 27. Wednesday.
ನಾಡಿದ್ದು.
Yes.
ನಾಡಿದ್ದು.
Next week ಅಲ್ಲಿ
Next week.
Finally, at the request of learned counsel for the respondents, release this matter on 2nd of December.
Please.
Yes. Huh?
Yes.
Please.
No further adjournment.
Yes, yes.
No
Please.
further adjournment will be granted.
Great.
29 and 30 ಎರಡು.
30 is also same, my lord, but post is driver, not stenographer. Further direction.
CL number 31, Veerangoda Mali Patil.
This is a beneficiary appeal, my lord. Connected matters, lordship has passed
Same orders have to be.
same orders have been followed. Office objections have been overruled.
The same orders as in MFA 202721 of 2022, dated 14/10/2024, same order.
Please.
Notice.
ಇದೆ ಅದ್ರಲ್ಲೆಲ್ಲ ಇದೆ.
ಅದೇ.
Same.
CL number 33, Sachin M. Mahajan.
This matter, my lord. Tahsildar has to file the report, my lord. On 7/11/2024, your lordship is directed the Tahsildar to submit the report. There is certain conditions are there, my lord. That's why, my lord, we require some documents, my lord, by all the authorities. This some of the documents with the Karanjam or some of the department.
Government advocate submits on instructions from the Tahsildar who is present in the court.
Please.
That the original documents pertaining to allotment of the
Akkupatra and also other documents.
allotment of sites,
House, allotment of site and Akkupatra.
allotment of sites and Allah, ಈ ಹಕ್ಕುಪತ್ರ was issued by whom?
Allotment of site, no. Allotted site and also
Allotment of
my lord,
site
layout plan.
are available with the ಯಾರ ಹತ್ರ ಇದೆ?
Karanjam.
ಹಾ?
Karanjam. It is.
ಯಾರು?
My lord, Hakupatra will be issued by the Tahsildar only.
ಹಕ್ಕುಪತ್ರ ಅಲ್ಲ. ಹಕ್ಕುಪತ್ರ ಅಲ್ಲ. See who are the displaced persons ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ those documents will be with the ಯಾರು?
ಯಾರು ಬೇರೆ authorities ಅಂತ lordship.
Of Karanja project
Karanja project.
are available with the rehabilitation officer of the Karanja project.
Please.
And those documents are not available with the Tahsildar. Full stop. Therefore, the Tahsildar has made a communication to the concerned officer, rehabilitation officer of Karanja project. Full stop. Learned government advocate therefore seeks for some more time.
Please.
To conduct the survey as directed by this court. ಏನೋ ಒಟ್ನಲ್ಲಿ ಯಾವ by 9th of December.
Please.
Please. Release this matter on 9th of December.
I may add, my lord, one submission, my request would be, let them furnish all the documents, my lord, which they are relying upon, my lord, to prepare the report. Everything will be clear, my lord.
Of course, it has to be shown to you at the time of survey.
Lord, while submitting the report before our lordship, let them produce all the documents which they have relied to prepare the report. There will be absolute clarity.
This is the, my lord, observation by the second para, my lord, for a moment. But that is the reason, my lord, we are not able to get the survey. That is written by the, my lord, surveyor.
My lord, I make submission. My lord, since the matter only related to the
site allotted to the appellant is the site number 4, my lord. The respondent number 6 is allotted commercial site. They only regarding the encroachment, since from the 2004, the dispute is going on, my lord. For every notice.
ಅದನ್ನ ಕಂಡಿಡಿಯೋದಕ್ಕೇನೆ ನಾವು ಇಷ್ಟೆಲ್ಲ ಸರ್ಕಸ್
There is
ಮಾಡ್ತೀವಿ.
a several direction is issued.
How do you find out what was allotted to them, what was allotted to you? They'll have to identify that place, and then thereafter they have to decide whether this person has encroached. And if he encroached, whether the other property is yours or is it allotted to some other person. All that information can come out only after the survey. Yes, 9th of December.
Please.
9th of December.
Seal number 34,
My
government.
lord,
advocate.
my submission was, my lord, that let them be, there be a direction to produce all the records which they rely upon for preparing the report, my lord.
Yes, but your lordship is also directed the authorities, my lord, to produce those documents also to the Tesla. But we request, my lord, they'll say that this old document is not available, that it will be problem.
It is in this regard, my lord, I'm making the submission. It should not be some unfounded report once again. If they rely upon, my lord, some material, let the material before be your lordship.
Perkal innondu sentence. The report shall also contain information as to the documents verified by the authorities, and copy of the same shall also be furnished along with the report.
Valuable.
With matters, seal number 34, government advocate.
But in this matter, my lord, your lordship is directed me to get the, my lord, instruction regarding complaints of the earlier order passed by this honorable court. Earlier, my lord, tribunal passed the order, my lord.
Who is on the other side?
Respondent.
Anand V. Ture, Pritam Deolgankar. Silpa S. Gogi.
Matter is called out. There is no representation for the respondents. Release this matter on 2nd of December.
Please.
Seal number 35. EYM Chinko.
Appeal for petitioner challenging the annexure B, which is KT order, lordship. It's a matter of DE. The petitioner is delinquent of officer of in the check post of Dhulke. Lordship, in the inquiry report, he is the delinquent government official number 2, lordship. Lordship, to the extent of first DGO, the charges have been levied against, which is against the DGO, which has been exonerated, lordship. The demand has been made by the DGO, lordship, in this. The entire complete proceedings has been exonerated against the DGO, lordship. Now, on the parity ground, lordship, simultaneously, I'm seeking parity ground also, lordship. Because when there is no demand, the acceptance is admittedly not in proceedings has been established, lordship. The first, the facts being thus, lordship, the complainant has taken the contention that, lordship, he was brought a brandly new concrete mixture machine, lordship, from the Nanded to his native place, lordship. While taking to Nanded to his native place, he was subjected his vehicle to check, Lordship, in the check post, which is comes under the Vijaypura, Lordship. When the DGO 1 has asked for the pay the penalty, when sale tax has been not paid, then the DGO 1 has been asked for the penalty for rupees 20,000, Lordship. As per the complaint, Lordship, he says that 40,000 has been asked for due to his poverty. He could not able to pay the 40,000. So he tried to pay the 20,000, Lordship. The DGO 1 duty timing is, Lordship, 7 a.m. to 7 p.m. to 8 a.m. Lordship. It comes to 2/3/2008, 7 p.m. to 8 a.m. Lordship. At the early morning. 2008, Lordship. It's a matter of 2008. In the early morning, Lordship, the vehicle was subjected to the check. It was found that, Lordship, the sale tax has been not found. So, Lordship, he was imposed to penalty for the pay of the 20,000 sale tax, Lordship. Thereafter, the DGO 2 comes in the picture that, Lordship, after DGO 1, the duty has been completed at 8 a.m. After 8 a.m., Lordship, the DGO 2 has come into the picture as he joined his duty timing, Lordship. He grabbed all the papers, Lordship. Due to that, Lordship, for the his conduct of the DGO 2, he forced to file the complaint before the Lokaयुक्त, Lordship. For that, Lordship, a single evidence of peace.
For DGO 1.
DGO 2, Lordship. DGO 1 has been exonerated, Lordship. DGO 1 has been exonerated. As per the entire complaint and the proceedings, it comes as established that, Lordship, the DGO 1 has made the demand, Lordship. After that, Lordship, the complainant was asked to come to some hotel that is concerned to allegation to the extent of DGO 2, Lordship. The complainant asked to DGO 2, where he has to come. Then, Lordship, the DGO 2 has asked for to come to some kind of hotel, which is the named as Deepika Hotel. The bribe amount was thrusted to his pocket, Lordship. Later on, Lordship, the complainant was turned into hostile. The Sessions Court have been passed the order of acquittal order. The Lokaयुक्त has preferred the appeal. The acquittal order has been confirmed. Then, Lordship, in the KAT, the inquiry report was upheld only on the ground that, Lordship, the the amount was recovered, Lordship.
Chemical analysis test.
That has been done, Lordship. That has
Failed,
So my lord,
color turned.
Color
turn.
my lords,
Here, Lordship, the only question is that, Lordship, there is no demand, Lordship. There is no demand at all, Lordship, by the DGO 2. Who is demanded, DGO 1, he has exonerated from the charges levied against him, Lordship. When there is no demand, the acceptance of the demand amount could not be arise, Lordship.
In the recommendation, in the report of the inquiry officer.
Yes, Lord.
It is held that it is not proved as against DGO 1.
DGO 1 has been proved, Lordship. In the Sessions Court and the criminal cases, he has been acquitted, Lordship. The B final.
DGO 1 has been acquitted.
DGO 2 has been acquitted. The DGO 1 has B final report has been filed, Lordship.
B report.
B report has been filed. Thereafter, in the proceedings, Lordship, the proceedings in the inquiry report, the complainant turns hostile, Lordship. He has no any allegation against the DGO 1, only to the extent of he asked for the 20,000 to pay the as an penalty of the sale tax, Lordship. There is no any demand. They turned into the statement as that, Lordship, the imposed penalty was in a demand of bribe. So the question is that, Lordship, there is no any evidence. An entire only the shadow witnesses are there, Lordship, a single person. He turned into, like, Lordship, his contradictory evidence, which is not corroborate with the Sessions Court judgment, Sessions Court evidence, and as well as it's yes, Lordship, I am retired.
Compulsory return.
Yes, Lordship, I am retired.
Compulsory return.
And the Karnataka Administrative Tribunal has also, Lordship, dropped the inquiry proceedings against the DGO one, Lordship. This is the judgment, which is the
ಅಲ್ಲ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರು ಅಲ್ಲಿ
inquiry report.
Huh?
Inquiry proceedings.
Enquiry was conducted against both of them.
Both of them,
and
Lordship,
both
both of
were-
them. Simultaneously, the inquiry was conducted.
What is the finding of the enquiry officer?
And that is what, Lordship, only the witness, shadow witness, they have held that
As against DGO one.
DGO one. The charge against DGO one, Shri Yellappa Birappa Maddikera, page 58, Lordship.
Proved ಅಂತಾನೆ ಯಾಕಂದ್ರೆ he also filed an application
Yes, Lord.
for the KAT.
Yes,
He also filed an application.
yes, Lord.
ಏನಾಯ್ತು ಅದು?
That is was, the proceedings was dropped against the DGO one, Lordship. May I take to Lordship, page 58, annexure A3, the inquiry report, Lordship.
Page?
Page 58, annexure A3, Lordship, inquiry report. The charge against DGO one, Shri Yellappa Pirappa Maddikera. May I, Lordship?
Is proved.
Yes, Lord.
ಇಬ್ಬರ ಮೇಲೂ proved ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಬ್ಬರು ಮೇಲೂ ಕೂಡ ಅಂತ.
Penalty was imposed, my lords, and thereafter
The charge
Because
against DGO
the-
one, Shri Yellappa Pirappa Maddikera, and charge against DGO two, Shri Subhash Rudrappa Biradar, that at 7 AM on 3/3/2008, Dhulkhed Commercial Tax Checkpost of Vijaypur District, DGO one and two called upon the complainant to pay a sum of rupees 40,000 towards tax in respect machinery, and ultimately insisted to pay a sum of rupees 20,000, and thereafter on the same day between 6:50 PM and 7 PM, DGO two for himself and on behalf of DGO one demanded and accepted illegal gratification of rupees 20,000 from the complainant in Deepika restaurant near the bus stand at Vijaypura, and during investigation, DGO one and two failed to offer satisfactory explanation for the possession of tainted cash of rupees 20,000, which was possessed by DGO two in the said hotel, and thereby DGO one and two are guilty of misconduct within the purview of Rule 3, Clause 1.
So it was in your possession,
Yes,
in your
Lordship.
pocket.
Yes, Lordship. The trap was conducted in favor of me, and the tainted amount has been recovered. Only the recovery, Lordship. In this matter, only the recovery. But the DGO one has filed his, in the Sessions Court, Lordship, the Sessions Court has observed that for the 20,000, Lordship, for the sale tax, he has been initially issued a notice to the complainant driver, Lordship. The complainant and the complainant driver refused to take the such kind of notice and said to the DGO two that, Lordship, leaving the vehicle there only, they'll bring the money at 20,000 up to 6 o'clock or 5 o'clock. They have said that, Lordship. The thing is that the exhibit P23 in the Sessions Court judgment, Sessions Court proceedings, they have furnished the notice and as well as, Lordship, the sale tax amount, Lordship, the receipt of the sale tax amount, which is already has been recorded in the office of the check post, Lordship. That has been observed by this in the Sessions Court as well as in a criminal appeal, Lordship, which is filed by the local. The court has been observed, Lordship.
What are the learned magistrate held?
Yes, Lord.
Insofar as possession of this 20,000 in
Yes.
your pocket.
In Sessions Court, Lordship. Right.
Time code. Evidence.
Even the appeal was filed by the state Manors against the order of acquittal. Even that has been dismissed.
ಅಲ್ಲ, ಆಯ್ತು, that's all right. We want to know how that has been treated. If 20,000 was recovered from his pocket.
Yes, Manors.
And the color test
Yes, it was,
is
it was
positive.
done. Yes, it was
How
positive.
the criminal court has treated that sessions court?
Manors, here the.
Spite of that,
No, the.
how is it that
Yes, Manors.
he is?
Manors, what has happened was, the demand was initially made by the DGO number 1, Manors.
The demand was made by DGO.
DGO number 1.
Yeah.
Thereafter, Manors, as per his direction, DGO number 2 collected the amount. Manors. By somehow he got B report. DGO 1 managed to get a B report, and this person was tried, Manors. This is the case. On tapaskonda, that benefit of doubt has been given to this person. And he was made PW5 in the criminal case.
Yaro?
DGO 1. They took him as a witness instead of being accused. Manors. The complaint was initially lodged against the DGO number 1.
Both of them.
DGO number 1, Manors. On the direction, this fellow came into the picture by collecting the amount.
ಹೌದ್ರಿ.
ಅಲ್ಲ, first.
All this incident happened on the same day.
Yes, ma'am.
It happened on the same day.
Yes.
Commencing from the night.
Night, DGO 1.
Night.
ಇಷ್ಟು ದುಡ್ಡು ಕೊಡು, next day morning.
Trap was laid on the next day.
Yes, ma'am.
Yes, Lord.
Next day morning.
So both of them are together.
No.
No, Lord.
He was not there. DGO 1 was not in the picture.
He just directed to collect the, whatever the amount, which is a sale tax. He directed to the DGO 2, Lordship.
The petitioner herein is
DGO
sitting
2 was in his
near the bus
duty.
stop. So hand over
That
the
Lordship,
amount.
the complainant says that Lordship, the DGO 1 has directed me to pay whatever the amount, which has entirely comes into the picture, that Lordship, that is the sale tax amount. Later on, that statement converted into Lordship, that is the bribe amount, Lordship. The DGO 1 has directed to pay whatever the sale tax amount to the DGO 2, Lordship, because the DGO 1's duty timing is there, Lordship. It is completed at the morning at 8 AM, Lordship. In fact, Lordship, it is not the case that Lordship, either the DGO 2 has demanded or accepted, Lordship. The only money has been recovered from the DGO 2, Lordship. That is the case, Lordship. In the no evidence and the perversity, Lordship's judgment is there. If Lordship, I dare to. In fact, Lordship, in the inquiry proceedings, the inquiry officer has been not given his evidence, Lordship. Only the complainant and the shadow witness has given the evidence. And the complainant witness completely turns into hostile, Lordship. He again and again said that the DGO 1 and 2 has asked for the sale tax amount, not the bribe amount, Lord. And the shadow witness is there, Lordship, but it is completely ambiguous in nature. The statement has been not corroborated with the Sessions Court evidence and in the inquiry proceedings.
Paragraph number 18.
Yes, Lord.
Apex Court in the case of B. Jairaj versus State of AP has held that insofar as the offense under section 7 is concerned.
Yes.
It is a settled question in law that demand of illegal gratification is sine qua non to constitute the said offense, and mere recovery of currency notes cannot constitute offense.
Yes.
Under section 7.
Yes.
Unless it is proved beyond all reasonable doubt that the accused voluntarily accepted the money, knowing it to be a bribe.
Yes. But in
what you are trying to rely
yes,
upon.
Lordship. In present case, Lordship, the complainant says that, Lordship, even it is in a sale tax amount, he thirsted the amount in the pocket when the DGO2 has refused to take the money, Lordship. In fact, the DGO2 has said to pay the amount, sale tax amount in the check post, Lordship. That has been clearly come into the evidence, Lordship, of the complainant as well as in a shadow.
lords, what the complainant has supported, my lords, the inquiry officer. The evidence is at page number 62.
In fact, Lordship has elaborately taken into para number 16 of the judgment, Lordship, which are 16. It is absolutely, this para is binding to my case, Lordship. The learned, may I, Lordship, para number 16? The learned single judge has also relied on the judgment of the Honorable Supreme Court in the case of State Bank of India and another versus case Vishwanath, reported in 2022 SEC online SC 667. In paragraph number 7.3 to 9, it was held that the judicial review and a power of the High Court in a departmental inquiry and interference with the findings recorded in the departmental inquiry, the High Court is not a court of appeal over the decision of authorities holding a departmental inquiry against a public servant. However, in the said judgment, the Honorable Apex Court in referring the judgment passed in the case of State Bank of Bikaner and Jaipur versus Nemichand Nalvaya, reported in 2014 4 SEC 584, held that courts will not interfere with the findings of a fact recorded in a departmental inquiry except where such findings are based on no evidence or where they are clearly perverse logic. The test to find out perversity is to see whether a tribunal acting reasonably could have arrived at such conclusion or a finding based on the material available on record. The courts will, however, interfere with the findings in disciplinary matters if a principles of natural justice or a statutory regulations have been violated, or if the order is found to be arbitrary, capricious, malified, or based on extraneous considerations. By perusal of the above dictum laid down by the Honorable Apex Court, it is clear that the judicial review can be exercised when the findings of the disciplinary authority suffers from perversity, as discussed supra. In the case on hand, the findings of the disciplinary authority totally suffers from perversity, since the inquiry authority failed to appreciate the evidence adduced by the witness to prove the charges against the appellant, since there is no evidence placed before the inquiry authority in respect of demand and acceptance of the illegal gratification by the appellant. The inquiry authority ought not to have passed such an order and could not have submitted a report to the second respondent to pass an order of penalty. Even otherwise, in the judgment relied by the appellant in the case of Praveen Kumar versus Union of India, reported 2029 SEC 471, which was also relied by the learned single judge, it was held that the power of the judicial review meant to ensure that the individual receives fair treatment and not to ensure that conclusion which the authority reaches is necessarily correct in the eye of court. When an inquiry is conducted on charges of misconduct by a public servant, the court tribunal is required to determine whether the inquiry was held by a competent officer or whether rules of natural justice are complied with. It is further held that the findings of the disciplinary authority must be based on some evidence. The court tribunal may interfere in the said findings where the authority holds the proceedings against the delinquent officer in a manner inconsistent with the rules of natural justice or in violation of the statutory rules prescribing the mode of inquiry, or where the conclusion of or findings reached by the disciplinary authority is based on no evidence. If the conclusion or a finding is such as no reasonable person would have ever reached, the court tribunal may interfere with the conclusion or the findings and mount the relief so as to make it appropriate to the facts of each case. Hence, the perusal of the evidence and the material available on record, the dictum laid down in the said judgment is squarely applicable to the case on hand, since the findings reached by the disciplinary authority is based on no evidence.
ಅದೇ criminal case, the team and, this is that. But that again, after he filed the application, the Oracle application, the DGO one, that has been allowed.
Only on the ground, my lords, B report was filed on against him. Whereas in the inquiry, my lords, the complainant and the shadow witness have supported the case of the inquiry officer. It is at page number
No, Lordship.
65 and 70.
The
69.
complainant completely turns into hostile, Lordship.
Page number
ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
ಇರೋದು ನಾನು. ಅದು it is before Belgaum, my lords. Term jurisdiction.
ಬೆಳಗಾವಿ ಇದು
ಇದು ಇವನು ಇಲ್ಲಿ ಗುಲ್ಬರ್ಗ.
ಕಲಬುರ್ಗಿ ಅದು ಬೆಳಗಾವಿ. ಆಗ್ಲಿ ಅದಕ್ಕೇನಂತ ನಿಮ್ಮ ಆಫೀಸ್ ಎಲ್ಲಾ ಕಡೆ ಇದೆ.
I have not.
ಮಾಡಿಲ್ಲ ಅವರು.
But the only difference is, my lords, here he has been tried in a criminal case. Here he has been tried in a criminal case. There there was no trial at all. The police themselves, after investigation, having found no material against him, had given B report, whereas this person has been tried for the offense.
No, but even as per the complainant, everything started
with that fellow.
when DGO was functioning there.
Yes.
It was he who demanded one. That was observed by the honorable court.
Correct.
In the
That is
criminal
the allegation made
the
by the
criminal
complainant.
appeal, in the criminal appeal.
It is also possible that he thrust the amount into this person's pocket to pay to him.
But in the evidence before the inquiry officer, the shadow witness has supported, he asked the money and he took. It is at page number 65, 69, my lord. Even though
Shadow witness
and complainant both supported the inquiry officer
Lordship.
in the inquiry, even against.
I'll take to
Inquiry
Lordship
of-
page 64.
ಅದಕ್ಕೆ my lords,
I'll take to page 64.
the tribunal, my lords, has come hardly on him. Hard on.
Para 4, Lordship. Page 64, Lordship. It's a complainant crossing. During the cross-examination,
65. At page number 65, my lords,
page 64.
para 5.
May I, Lordship? ಮೊದಲ ಬಾರಿಗೆ ಲಾರಿಯನ್ನು ನಿಲ್ಲಿಸಿದಾಗ ತೆರಿಗೆ ರೂಪಾಯಿ 40,000 ಆಗುತ್ತದೆ ಎಂಬುದಾಗಿ ಹೇಳಿದರು ಎಂಬುದು ನಿಜ. ಅಷ್ಟು ತೆರಿಗೆಯನ್ನು ಕಟ್ಟಲು ಸಾಧ್ಯವಿಲ್ಲೆಂಬುದಾಗಿ ಮತ್ತು ನಾನು ಬಡವನಾದ ಕಾರಣ ತೆರಿಗೆ ಮನ್ನಾ ಮಾಡಲು ಕೋರಿದೆನು ಎಂಬುದು ನಿಜ. ಆಗ ಅಲ್ಲಿ 1ನೇ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಸಹ ಇದ್ದರು ಎಂಬುದು ಸರಿಯಲ್ಲ. 70,000 ದಂಡ ಕೊಡಬೇಕೆಂದು 2ನೇ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಹೇಳಿದರು. 20,000 ಲಂಚವನ್ನು 2ನೇ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಕೇಳಿದರು ಎಂಬ ಸೂಚನೆಗೆ ಆ ಹಣ ದಂಡವೆಂದು ಸಾಕ್ಷಿಯು ಉತ್ತರಿಸುತ್ತಾರೆ. 2ನೇ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಅವರು ಮೊಬೈಲ್ ಸಂಖ್ಯೆಯನ್ನು ನನಗೆ ಕೊಟ್ಟರು. ಹಣ ತರುವ ಮುನ್ನ ಮೊಬೈಲ್ ಮುಖಾಂತರ ಸಂಪರ್ಕಿಸಿ ತರುವಂತೆ 2ನೇ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಹೇಳಿದರು. ನಾನು ಬಾಗಲಕೋಟೆಗೆ ಬಂದು 20,000ಗಳನ್ನು ಹೊಂದಿಸಿಕೊಂಡು ನಾನು ಬಿಜಾಪುರದ ಬಸ್ ನಿಲ್ದಾಣಕ್ಕೆ ಬಂದು ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಕಾಲ್ನಡಿಗೆಯಲ್ಲಿ ಹೋದನು. ನನ್ನ ಜೊತೆಗೆ ಬೇರೆ ಯಾರೂ ಇರಲಿಲ್ಲ. ನಿಶಾನೆ 3 ದಾಖಲೆಯನ್ನು ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಇದ್ದವರ ಪೈಕಿ ಯಾರೋ ಒಬ್ಬರು ಬರೆದರು.
100% ಅಂತೆಲ್ಲ.
Repeatedly he says that, Lordship, that is not the bribe amount, that is the sale tax amount which has been asked for the pay by the DGO 1 and the DGO 2, Lordship.
Kindly see para 65, para 5, my lord.
Page 60.
Page 65. ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸ್ ಠಾಣೆಯಿಂದ ನಾನು ಮೊಬೈಲ್ ಮುಖಾಂತರ 2ನೇ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರನ್ನು ಸಂಪರ್ಕಿಸಿದಾಗ ದೀಪಿಕಾ ರೆಸ್ಟೋರೆಂಟ್ ಎಂಬಲ್ಲಿಗೆ ಬರುವಂತೆ 2ನೇ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಹೇಳಿದರು ಎಂಬುದು ನಿಜ. ನಂತರ ನಾನು ವೀರೇಶ ತಮ್ಮಣ್ಣ ಮತ್ತು ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರು ಬಿಜಾಪುರದ ಬಸ್ ನಿಲ್ದಾಣಕ್ಕೆ ಬಂದೆವು ಎಂಬುದು ನಿಜ. ನಂತರ ನಾನು ಮತ್ತು ವೀರೇಶ್ ದೀಪಿಕಾ ರೆಸ್ಟೋರೆಂಟ್ ಎಂಬಲ್ಲಿಗೆ ಹೋದೆವು ಎಂಬುದು ನಿಜ. ನಾನು ಮತ್ತು ವೀರೇಶ್ ಚಾ ಕುಡಿಯುತ್ತಿರಬೇಕಾದರೆ ಎರಡನೇ ಅಪರಾಧಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಅಲ್ಲಿಗೆ ಬಂದರು. ಹಣ ಕೊಡಬೇಕೆಂದು ಎರಡನೇ ಅಪರಾಧಿತ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಕೇಳಿದರು ಮತ್ತು ನಂತರ ನಾ ಹಣವನ್ನು ಅವರಿಗೆ ಕೊಟ್ಟೆನೆ ಎಂಬುದು ನಿಜ.
During the cross examination, Lordship, in the same.
ಆ ಹಣವನ್ನು ಎರಡನೇ ಅಪರಾಧಿತ ಸರ್ಕಾರಿ ನೌಕರರು ತಮ್ಮ ಶರ್ಟಿನ ಎಡಭಾಗದ ಜೇಬಿನಲ್ಲಿ ಇಟ್ಟುಕೊಂಡರು. ಪೊಲೀಸರು ಮೊದಲೇ ನನಗೆ ಹೇಳಿದಂತೆ ನಾನು ನನ್ನ ಪಂಚೆಯ ಒಂದು ತುದಿ ನಮ್ಮಕ ಒರೆಸಿಕೊಂಡನು ಮತ್ತು ಅದನ್ನು ನೋಡಿ ಅಲ್ಲಿಗೆ ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರು ಬಂದರು ಎಂಬುದು ನಿಜ. ನಂತರ ಎರಡನೇ ಅಪರಾಧಿತ ಸರ್ಕಾರಿ ನೌಕರರು ತಮ್ಮ ಕೈ ಬೆರಳುಗಳು ತೊಳೆದಾಗ ಆ ದ್ರಾವಣವು ಗುಲಾಬಿ ಬಣ್ಣಕ್ಕೆ ತಿರುಗಿತು ಎಂಬುದು ನಿಜ. ದ್ರಾವಣವನ್ನು ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರು ವಶಪಡಿಸಿಕೊಂಡರು ಎಂಬುದು ನಿಜ. ಕಂಪ್ಲೇಂಟ್ ಮೈಲಾಡಿ. ಎರಡನೇ ಅಪರಾಧಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಕೈಗಳನ್ನು ತೊಳೆದ ನಂತರ ಆ ಹಣವು ಏನಾಯ್ತು ಎಂಬುದು ಗೊತ್ತಿಲ್ಲ. He has demanded and received money, my lord.
In continuation of the para number 6, Lordship, in the cross examination, ನಾನು ಶಾಲೆಯಲ್ಲಿ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿಲ್ಲ, ನನಗೆ ಓದಲು ಬರುವುದಿಲ್ಲ, ಆಂಗ್ಲ ಭಾಷೆಯಲ್ಲಿ 3 ಅಕ್ಷರ ಸಹಿ ಮಾಡುವುದು ಬಿಟ್ಟರೆ ನನಗೆ ಬೇರೆ ಗೊತ್ತಿಲ್ಲ. ನಾಂದೇಡ್ ಎಂಬಲ್ಲಿಗೆ ನಾನು ಲಾರಿಯಲ್ಲಿ ಯಂತ್ರವನ್ನು ರಿಪೇರಿಗೆಂದು ಧೂಳಖೇಡ್ ಚೆಕ್ ಪೋಸ್ಟ್ ಹಾದು ಹೋದೆನು. ಆ ಚೆಕ್ ಪೋಸ್ಟ್ ಹೊರತು ಪಡಿಸಿ ನಾಂದೇಡ್ ಎಂಬಲ್ಲಿಗೆ ವಿಜಯಪುರದಿಂದ ಹೋಗಲು ಬೇರೆ ದಾರಿ ಇಲ್ಲ. ಆ ಚೆಕ್ ಪೋಸ್ಟ್ ಕರ್ನಾಟಕ ಮತ್ತು ಮಹಾರಾಷ್ಟ್ರ ರಾಜ್ಯದ ಗಡಿಯಲ್ಲಿದೆ. ನಾನು ನಾಂದೇಡ್ ಎಂಬಲ್ಲಿಗೆ ಹೋಗುವ ಮುನ್ನ ಮೇಲ್ಕಂಡ ಚೆಕ್ ಪೋಸ್ಟ್ ನಲ್ಲಿ ನಮೂದು ಮಾಡಿ ಹೋಗಿರಲಿಲ್ಲ. ಕರ್ನಾಟಕದಿಂದ ಬೇರೆ ರಾಜ್ಯ ಮಾರಾಟ ತೆರಿಗೆ ಸಲ್ಲಿಸಬೇಕಾದ ಸರಕು ಹೋದರೆ ಮತ್ತು ಬೇರೆ ರಾಜ್ಯದಿಂದ ಸರಕು ಬಂದರೆ ಮಾರಾಟ ತೆರಿಗೆ ಪಾವತಿಸಬೇಕು ಎಂಬುದು ನನಗೆ ಗೊತ್ತಿತ್ತು. ಆ ಚೆಕ್ ಪೋಸ್ಟ್ ನಲ್ಲಿ ಕಾಗದ ಪತ್ರಗಳನ್ನು ಅಲ್ಲಿದ್ದ ಸರ್ಕಾರಿ ನೌಕರರು ಕೇಳಿದರು. ಈಗ ತೋರಿಸಲಾದ 6 ಜೆರಾಕ್ಸ್ ದಾಖಲೆಗಳನ್ನು ನಾನು ಗುರುತಿಸುತ್ತೇನೆ. ಈ ದಾಖಲೆಗಳನ್ನು ನ್ಯಾಯವಾದಿ ಶ್ರೀ ಸೋಯನ್ಸು ಕಡತದಿಂದ ತೆಗೆದು ತೋರಿಸುತ್ತಾರೆ. ಆ ಪೈಕಿ ಒಂದು ಬಿಲ್ ಜೆರಾಕ್ಸ್ ನಕಲು ನಿಶಾನೆ D1, ಜೆರಾಕ್ಸ್ ಹೆಂಬರ ನಿಶಾನೆ D2, ಒಂದು ಜೆರಾಕ್ಸ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ನಿಶಾನೆ 3, ನಿಶಾನೆ D3 2 ಹಾಳೆಗಳಿದೆ. ಒಂದು ಜೆರಾಕ್ಸ್ ಅರ್ಜಿ ನಿಶಾನೆ D4, ಒಂದು ಜೆರಾಕ್ಸ್ ಅರ್ಜಿ ಬಿಡುಗಡೆ ಪತ್ರ ನಿಶಾನೆ 5, ಒಂದು ಜೆರಾಕ್ಸ್ ಬಿಲ್ ನಿಶಾನೆ 6. ಮೇಲ್ಕಂಡ ನಿಶಾನೆ 1ರಿಂದ 6 ಮೂಲ ದಾಖಲೆಗಳನ್ನು ಆ ಚೆಕ್ ಪೋಸ್ಟ್ ನಲ್ಲಿ ವಶಪಡಿಸಿಕೊಳ್ಳಲಾಗಿತ್ತು. ಮೇಲ್ಕಂಡ ಯಂತ್ರವು ಹೊಸ ಯಂತ್ರವೆಂದು ಹೇಳಿ ಅದಕ್ಕೆ ದಂಡ ಕಟ್ಟಬೇಕೆಂದು ಹೇಳಿ ಎರಡನೆಯ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಹೇಳಿದರು ಎಂಬುದು ನಿಜ. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನಾನು ವಿಜಯಪುರ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಾಕ್ಷಿ ನುಡಿದಿರುತ್ತೇನೆ. ಸದರಿ ಪ್ರಕರಣ ಎಂದರೆ ಲೋಕಾಯುಕ್ತ ಸ್ಪೆಷಲ್ ಕೇಸ್ ನಂಬರ್ ಸಂಖ್ಯೆ ರಲ್ಲಿ ನಾನು ನುಡಿದ ನನ್ನ ಸಾಕ್ಷ್ಯದ ದೃಢೀಕೃತ ಪ್ರತಿಯು 4 ಹಾಳೆಗಳಲ್ಲಿದ್ದು ಒಟ್ಟಾಗಿ ನಿಶಾನೆ D7. ನಿಶಾನೆ D7 ಅನ್ನು ಎರಡನೇ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ನ್ಯಾಯವಾದಿಯವರು ತಮ್ಮ ಕಡತದಿಂದ ಹಾಜರು ಮಾಡಿರುತ್ತಾರೆ. ಎರಡನೇ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಆ ಪ್ರಕರಣದಲ್ಲಿ ದೋಷ ಮುಕ್ತರಾಗಿದ್ದರೆಂಬುದು ನಿಜ. ರೂಪಾಯಿ 20,000 ದಂಡದ ಹಣವಾಗಿ ಕೊಡಬೇಕೆಂದು ನಾನು ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದೇನು. ಲಾರ್ಡ್ಶಿಪ್, I'll repeat the sentence. ಎರಡನೇ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಆ ಪ್ರಕರಣದಲ್ಲಿ ದೋಷ ಮುಕ್ತವಾಗಿದ್ದರೆಂಬುದು ನಿಜ. ರೂಪಾಯಿ 20,000 ದಂಡದ ಹಣವಾಗಿ ಆಸ್ ಅನ್ ಪೆನಾಲ್ಟಿ ದಂಡದ ಹಣವಾಗಿ ಕೊಡಬೇಕೆಂದು ನಾನು ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದೇನು ಎಂಬುದು ನಿಜ. ದಂಡವನ್ನು ಕಡಿಮೆ ಮಾಡಲು ನಾನು ಕೇಳಿಕೊಂಡಿದ್ದೇನು ಎಂಬುದು ನಿಜ. ಆ ಬಗ್ಗೆ ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರು ಏನು ಬರೆಸಿದರು ಎಂಬುದು ನೆನಪಿಲ್ಲ. ನಿಶಾನೆ P3 ಮೂಲ ದಾಖಲೆಯ ಒಕ್ಕಣೆಯನ್ನು ನಾನು ಹೇಳಿ ಬರೆಸಿಲ್ಲ. ನಿಶಾನೆ P3 ಮೂಲ ದಾಖಲೆಯನ್ನು ನನ್ನ ಮುಂದೆ ಓದಿ ಹೇಳಲಾಗಿತ್ತೆ ಅಥವಾ ಇಲ್ಲವೇ ಎಂಬುದು ನನಗೆ ನೆನಪಿಲ್ಲ. ಎರಡನೆಯ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಲಂಚ ಕೇಳಿದರು ಎಂಬುದಾಗಿ ನಾನು ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರಿಗೆ ಹೇಳಿಲ್ಲ. ಎರಡನೆಯ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಎಲ್ಲಿ ಇರುತ್ತಿದ್ದರು ಎಂಬುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಮತ್ತು ನನ್ನ ಸ್ನೇಹಿತರು ಹೋಟೆಲ್ಗೆ ಹೋಗಿ ಚಹಾ ಕುಡಿದೆವು. ಎರಡನೆಯ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರನ್ನು ನಾನು ಮೊಬೈಲ್ ಮುಖಾಂತರ ಸಂಪರ್ಕಿಸಿ ನಂತರ ಮೇಲ್ಕಂಡ ಹೋಟೆಲ್ಗೆ ಹೋದೆನು. ಎರಡನೆಯ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರ ಜೊತೆಗೆ ಸ್ನೇಹಿತರು ಇದ್ದರು ಎಂಬುದು ಸರಿಯಲ್ಲ. ದಂಡ ಕಡಿಮೆ ಮಾಡುವಂತೆ ನಾನು ಕೇಳಿಕೊಂಡೆನು ಎಂಬುದು ನಿಜ. ಈ ಮೇಲ್ಕಂಡ ಚೆಕ್ ಪೋಸ್ಟ್ ಗೆ ಹೋಗಿ ಹಣ ಪಾವತಿ ಮಾಡಿ ಬರುವಂತೆ ಎರಡನೆಯ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ನನಗೂ ಹೇಳಿದ್ದರು ಎಂಬುದು ನಿಜ. ಲಾರಿಯನ್ನು ಸರಕು ಸಮೇತ ವಶಪಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ ಎಂಬುದಾಗಿ ನಾನು ಅಲ್ಲಿ ಹೇಳಿದೆನು ಎಂಬುದು ನಿಜ. ನಾನು ಒತ್ತಾಯಪೂರ್ವಕವಾಗಿ ಹಣವನ್ನು ಎರಡನೆಯ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರ ಶರ್ಟಿನ ಎಡಭಾಗದ ಜೇಬಿನಲ್ಲಿಟ್ಟೆನು ಎಂಬುದು ನಿಜ. ಅದನ್ನು ಬೇಡವೆಂದು ಎರಡನೆಯ ಅಪಾದಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಹೇಳಿದರು. ಮತ್ತು ಆ ಸಮಯಕ್ಕೆ ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರು ಅಲ್ಲಿಗೆ ಬಂದು ಎರಡನೇ ಅಪರಾಧಿತ ಸರ್ಕಾರಿ ನೌಕರನ್ನು ಹಿಡಿದುಕೊಂಡರು ಎಂಬುದು ನಿಜ. ಆ ಗಲಾಟೆಯಲ್ಲಿ ಮುಂದೆ ಏನಾಯಿತು ಎಂಬುದು ನನಗೆ ತಿಳಿಯಲಿಲ್ಲ ಎಂಬುದು ನಿಜ. ಎರಡನೇ ಅಪರಾಧಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಲಂಚವಾಗಿ ಹಣವನ್ನು ಕೇಳಿಲ್ಲ ಮತ್ತು ಯಾರದೋ ಮಾತು ಕೇಳಿ ನಾನು ಫಿರ್ಯಾದನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂಬುದು ನಿಜ. ಒಂದನೇ ಅಪರಾಧಿತ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಮತ್ತು ಪ್ರಕರಣಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ ಎಂಬುದು ನಿಜ. ಎರಡನೇ ಅಪರಾಧಿತ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಪಾಠ ಕಲಿಸಬೇಕೆಂದು ನಾನು ಪ್ರಕರಣ ದಾಖಲು ಮಾಡಿಸಿದ್ದೇನೆ ಎಂಬುದು ನಿಜ. ನಾನು ಸಹಿ ಮಾಡಿದ ದಾಖಲೆಯನ್ನು ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರು ಓದಿ ಹೇಳಿದ್ದಾರೆ, ಆದರೆ ಅವುಗಳ ಅಂಶಗಳು ನೆನಪಿಲ್ಲ. ಚೆಕ್ ಪೋಸ್ಟ್ ಹಾದು ಹೋಗುವ ಮುನ್ನ ಘೋಷಣಾ ಪತ್ರಕ್ಕೆ ಸಹಿ ಮಾಡಿಸಬೇಕಾಗಿತ್ತು, ಆದರೆ ಅದನ್ನು ಮಾಡಲಾಗಿದೆಯೇ ಅಥವಾ ಇಲ್ಲವೇ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
Bill number 37, additional government advocate. 37.
Testing respondent in two matters.
ಬೆಳಿಗ್ಗೆ ಅವ್ರು ಯಾರೋ ಕೇಳ್ತಾರೆ, ನೀವು oppose ಮಾಡ್ತೀರಾ? ನೀವು ಕೇಳಿದ್ದ ಟೈಮ್
ನಾನೇ ಕೇಳಿ.
ಹಾ ಏನ್ ಮ್ಯಾಟರ್?
It's a small matter, my lord. As per the 2012 Karnataka Daily Wages Welfare Act, those whose services is not regularized as per the Umadevi case, they have brought this act mail to give the those who put up 15 years, 20 years, 25.
ಯಾವ್ದು?
Karnataka Daily Wages Welfare Act 2012. ಅದ್ರ ಪ್ರಕಾರ those who completed 10 years by 2006, they have given the government gave the some benefit, minimum scale ಕೊಟ್ಬಿಟ್ಟು ಬೆನಿಫಿಟ್ಸ್ ಎಲ್ಲ ಬೇರೆ ಕೊಡಿ ಅಂತ. ಅದು KT ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ, ಬೆಳಗಾಂ ಅಲ್ಲಿ ಆಗಿದೆ, ಇಲ್ಲಿ ಆಗಿದೆ. ಅಗೇನ್ಸ್ಟ್ ದಟ್ ದೇ ಹ್ಯಾವ್ ಕಮ್
ಓನ್ಲಿ ಟು ಗಿವ್ ದಟ್ ಬೆನಿಫಿಟ್ ಅಷ್ಟೇ.
90% ಕೊಟ್ಟಿದ್ದಾರೆ, 10% ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ದಾರೆ ಆಕ್ಟ್ KT ಅವರು. ಸೊ ಅಗೇನ್ಸ್ಟ್ ದಟ್ ದೇ ಹ್ಯಾವ್ ಕಮ್ and they are not giving some of the benefits ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನಮ್ಮ ಎರಡು ಕೇಸಸ್.
My case is little different.
ಮತ್ತೆ ನಿಮ್ದೇನು ಅಪೀಲು?
My appeal is a little different, my lord. What has happened is the act is not being, was not properly interpreted by the government. These authorities, when they are implementing, first thing the act, it says that it shall commence at once. Instead of giving the benefits from the date on which the act commenced, they have made several government orders on the basis of which each department has sent out a list saying that from this date onwards, the benefit will be extended. Instead of giving it from the commencement, they start giving it from, some people get in the forest department itself. Somebody gets it in January, somebody gets it in September, third person gets it in next year's January. So that inequality is there. That has not been taken care of, or it is not, there is no order to that effect by the learned single judge. So on that point, I am before the court. Second thing is the basic and DA and HRA were in question. What we have said was whatever DA and HRA is payable to a government employee, that's how the act was framed. But they started giving only 75% initially, and by later notification, they have brought it to 90%. So
ಒಂದ್ ಸೆಟ್ KT ಇಂದ ಬಂದಿದೆಯಾ?
ಇವರು
KT.
I have directly filed a writ petition.
Writ petition?
Yes, why I filed a writ petition was because the act says, I'll just come to that.
ಇವ್ರದೊಂದು ಗವರ್ಮೆಂಟ್ ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ, ಇವರು ಒಂದು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
I'll come to the provisions of the act. KC, these Karnataka service rules don't apply and third ಕೂಡಲೇ
Who is going to argue the matter?
Vijay Kumar, he's held up in another matter in Bangalore.
ಅಲ್ರಿ ಬೆಳಿಗ್ಗೆನೆ ಟೈಮ್ ಕೇಳ್ಬಿಟ್ರಲ್ರಿ ನೀವು?
ಇಲ್ಲ, ತಾವು ಇಲ್ಲ ಅಂದಿರಿ, ನಾವು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೆ ಮಧ್ಯಾಹ್ನ ಬರ್ತೀನಿ ಅಂದಿದ್ರು. ಒಂದ್ ಮ್ಯಾಟ್ರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆ, ಮುಗಿದ್ಮೇಲೆ ಬರ್ತೀನಿ ನಾನು.
When do you want the matter? When do you want the matter to be listed?
He's requested next week Honorable Court may date, fix any date.
Date given.
May be taken as parted and it may be taken as parted and
Before time also asked.
I'm willing to conduct.
ಅಂತಂದು ಲಾರ್ಡ್ಶಿಪ್ ರಿಜೆಕ್ಟೆಡ್ ಟೈಮ್ ಕೊಡ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಮುಂಚೆ ಯಾವ್ದೋ ಸಾಹೇಬ್ರ ಮುಂದೆನೋ 2 ಸಲ ಹಿಂಗೆ ಆಯ್ತು. Then this time thinking that it is
Finally, at the request of learned government advocate, release this matter on 2nd of December.
Yes.
Next Monday.
Yes, sir.
All right.
My lord, I have sought certain amendments to my appeal that may be kindly allowed. They have been filed today. My father was not well and my mother also was not well earlier. So I could not
Application?
for amending the film.
Ah,
So I filed it today.
Ah.
It will come up by the next statement. But the
but it will be put up. We can't pass orders today.
no, I know. I just submitted that. I given a copy to them.
Ah, what do you know? That will also be put up.
Yes, ma'am.
Yes.
CL number 39, GS Biradar,
38.
38 or
Huh?
CL number 14,
Ah, sorry.
connected.
Yes.
CL number 39, GS Biradar,
Final hearing ಅಲ್ಲಿ ಯಾವ್ದು ಆಗಲ್ಲ.
serial number 49, 47, 40 are present. 49 my lords.
ಏನದು?
For compromise.
47.
49. Submitting the compromise.
Partition suit.
Partition suit, my lords, it was decreed, against which an appeal was filed, my lords, by the defendant.
fourteen.
49.
Filed a compromise petition, my lords, wherein it is said that properties have been divided between the parties, my lords.
Property?
Have been divided between these parties,
Ah.
co-sharers.
ಏನು ಬ್ಯಾಂಕ್ ಎಲ್ಲ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ?
Yes, my lords, against them I have sought for dismissal. I filed a memo, my lords, in regard to that. The appeal may be dismissed as withdrawal. For the trial court also, suit against them was dismissed.
ಹೇಳ್ಬಿಡಿ. ಎಲ್ಲ ಪಾರ್ಟ್ ಏನು?
ಎಲ್ಲ parties ಅದರ.
Mother, sir.
Respond 1 to 6.
Lakshmi ಇಲ್ಲ sir. She died with the pendency suit. ಇಲ್ಲ. ಇಲ್ಲ, she died with the pendency of suit. Her name is not of. You know, all already on record, sir. Daughters. ಬಸಮ್ಮ. ಇವರು ಸಿದ್ದಮ್ಮಯ್ಯರು. ಆಮೇಲೆ ಮಹಾನಂದ. I am appealing for 1 to 3, sir.
ಇದು ಪ್ರಕರಣ. ಜ್ಯೋತಿ, ಶಾಂತಿಬಾಯಿ, ಶಾಂತಾಬಾಯಿ, ಬಸಮ್ಮ,
Respond.
ಸಾಯಿದಮ್ಮ, ಸಿದ್ದಮ್ಮ,
Siddhamma.
ಸಿದ್ದಮ್ಮ, ಸಿದ್ದಮ್ಮ, ಸಿದ್ದಮ್ಮ. ಹಾ, CIL, ಸಿದ್ದಮ್ಮ, ಇಲ್ಲಿ ಮಹಾನಂದ, ಜಗದೇವಿ, ಪುಟ್ಲಾಬಾಯಿ, ಜಯಶ್ರೀ, ಮ್ಯಾನೇಜರ್
Against the servant.
ಮ್ಯಾನೇಜರು ಗ್ರಾಮೀಣ ಬ್ಯಾಂಕ್ ಮತ್ತೆ ಲೈಫ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಾರ್ಪೊರೇಷನ್ ಇಲ್ಲ.
Against.
ಹಾ?
No.
Suit will be dismissed as against those.
Yes, yes.
They were added pro forma parties and memo is filed for dismissal of suit against 7 to 10.
ಜ್ಯೋತಿ ಅವ್ರಿಗೆ ಏನೇನು ನಿಮ್ಗೆ ಏನ್ ಭಾಗ ಕೊಟ್ಟದ್ರಮ್ಮ?
ಹೌದಾದ್ರಿ
ಸರ್ವೆ ನಂಬರ್ ಇದೆ.
ನಂಬರ್ 3
ಹಾ
1
ಎಕರೆ ಕೊಟ್ಟದ್ರ ಅದರಲ್ಲಿ 104 ಅಲ್ಲಿ
ಅಲ್ಲ 104/2 ಅಲ್ವಾ? 104/2.
2 ಸರ್. ಓಕೆ
ಹಾ ಎಷ್ಟು? ಹಾ
ಮತ್ತೇನ್ ಕೊಟ್ಟಾರೆ?
ಮತ್ತೊಂದು ಪ್ಲಾಟ್ ಸರ್ 47 ಬಡೇಪುರ್.
ಮತ್ತೆ
in supermarket and all the FDs, LIC policy standing in my name and my husband's name, late husband.
ಇವರೇ ಲೆಸ್ಸಿನಾ? ಹೂ ಇಸ್ ಲೆಸ್ಸಿ?
Me.
ಲೆಸ್ಸಿ.
Lessee sir.
ವೆಹಿಕಲ್
ಹೌಸ್.
Yes sir. All the vehicles standing in my name and my husband's name.
ಲೆಸ್ಸಿ ಕಾರ್ಪೊರೇಷನ್ ಲೀಸ್ ಬಾಡಿ ಅಂತ ಇವರು ಲೆಸ್ಸಿ, ಕಾರ್ಪೊರೇಷನ್ ಇಸ್ ಲೆಸ್. ಲೀಸ್ ಅಂತ ಲೀಸ್ ಲೀಸ್ ಶಾಪ್ ಅಂತ
ಅದು ವೆಜಿಟೇಬಲ್ ಮಾರ್ಕೆಟ್ ಅಲ್ಲಿ ಸರ್.
ಕೇಳಿದ್ ಯಾರು? ಅದು ಇನ್ನೊಬ್ರು
ಇಲ್ಲ ಇಲ್ಲ ಸರ್. ಹೌದು ಯಾಕಂದ್ರೆ
ಓನ್ಲಿ ಲೀಸೋಲ್ಡ್ ರೈಟ್ಸ್ ಅಷ್ಟೇ.
ಅಷ್ಟೇ
ಅಷ್ಟೇ
ಲೀಸೋಲ್ಡ್ ರೈಟ್ಸ್
ಅಷ್ಟೇ.
ಶಾಂತಬಾಯಿ ಅವ್ರು ನಿಮ್ಗೆ ಏನ್ ಬಂದೈತಮ್ಮ?
ಅವ್ರು ನಮ್ಮ ಮಗ.
ನಿಮ್ಗೆ ಏನ್ ಬಂದಿದೆ ಭಾಗ?
ನಿಮ್ ತಾಯಿಯವ್ರು ಯಾರು?
ನೀವು ಹೇಳಿ.
ನಿಮ್ಗೆ ಎಷ್ಟು ಭಾಗ ಕೊಟ್ಟದಾರಮ್ಮ?
Sir 104 ನಾಗ 1/1 ನಾಗ ಅವರಿಗೆ 11.26 acres.
11 ಎಕರೆ 25 ಗುಂಟೆ ಕೊಟ್ಟದಾರ ನಿಮ್ಗೆ, ಹೌದೇನಮ್ಮ?
ಹಾ ಸರ್.
ಯಾರ ಅವ್ರಿಗೆ ಅಪೇರ್
ಇಲ್ಲ, ಐ ಅಪಿಯರ್
11 ಎಕರೆ 25 ಗುಂಟೆ. ಮತ್ತೆ ಸದರನ್ ಪೋರ್ಷನ್ ಸರ್ವೆ ನಂಬರ್ 96 ಫಾರ್
ಸುಲ್ತಾನ್ಪುರ್
ಎಷ್ಟು ಎಕರೆ?
15 ಗುಂಟ.
ಪ್ಲಾಟ್
ನಂಬರ್ 35 ಮುನಿಂಗ್ ಬಕ್ಕಲ್ಗಿರಿ.
ಬಸಮ್ಮ ನಿಮ್ಗೇನ್ ಕೊಟ್ಟದ ಹೇಳಿ? ಸರ್ವೆ ನಂಬರ್ 11/A 11/2 ಹೊಸ ಸರ್ವೆ ನಂಬರ್. ಈ ದಕ್ಷಿಣ ಭಾಗದ್ದು 3 ಎಕರೆ 13 ಗುಂಟೆ. ಒಪ್ತೀರಾ ನೀವು? ಮತ್ತೆ ಇನ್ನೊಂದು ಸರ್ವೆ ನಂಬರ್ ಎಷ್ಟು ಯಾವ್ದು?
ಸರ್ವೆ ನಂಬರ್ ಗೊತ್ತಿಲ್ಲ. 1 ಎಕರೆ 20 ಗುಂಟೆ ಇದೆ.
ಇದ್ರ 4 ಎಕರೆ 7 ಗುಂಟೆ ಕೊಟ್ಟ ನೋಡ್ರಿ.
4 ಎಕರೆ 7 ಗುಂಟೆ.
76/2.
ಮತ್ತೆ ಎನೆ ಲ್ಯಾಂಡ್ 1 ಎಕರೆ 20 ಗುಂಟೆ. ಎನೆ ಲ್ಯಾಂಡ್ ಒಳಗೆ 1 ಎಕರೆ 20 ಗುಂಟೆ.
ಇನ್ನೊಂದ್ರಲ್ಲಿ 1 ಎಕರೆ 20 ಗುಂಟೆ.
35 ಗುಂಟಾಸ್.
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಅದರಲ್ಲೂ 1 ಎಕರೆ
20 ಗುಂಟೆ.
12/A ಸರ್ವೆ ನಂಬರ್.
ಒಂದು ಪ್ಲಾಟ್.
ಮತ್ತೆ ಒಂದು ಪ್ಲಾಟ್ ನಂಬರ್ 62 40 ಸಿದ್ದಮ್ಮ.
All maps are also produced along with compromise.
26/1 5 ಎಕರೆ 12 ಗುಂಟೆ. ಮತ್ತೆ ಯಾವ್ದು ಕೊಟ್ಟಾರ? ಇನ್ನೊಂದು ಸರ್ವೆ ನಂಬರ್ ಕೊಟ್ಟಾರ. ಮತ್ತೊಂದು ಸರ್ವೆ ನಂಬರ್ ಎಷ್ಟು ಎಕರೆ ಕೊಟ್ಟಾರ ಹೇಳಿ ಹೋಗ್ಲಿ.
1 ಎಕರೆ ಅದು ಗೊತ್ತಿಲ್ರಿ. ಐರ್ವಾಡಿ ಮನಿ ಅರ್ಧ ಅದ ರೀ. ಒಂದ್ ಪ್ಲಾಟ್ ಅದ ಡೆಂಟಲ್ ಕಾಲೇಜ್ ಬಳಿ 188 ನಂಬರ್ ಸರ್ವೆ ಪ್ಲಾಟ್.
ಸರ್ವೆ ನಂಬರ್ 160/2 3 ಎಕರೆ 3 ಗುಂಟೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕಪ್ಪನೂರು ವಿಲೇಜ್
ಕಣಿವಲ.
ಮತ್ತೊಂದ್ರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 76/2
10 ಗುಂಟೆ
10 ಗುಂಟೆ ಕೊಟ್ಟಾರೆ. ಸರ್ವೆ ನಂಬರ್ 46/6 2 ಎಕರೆ 35 ಗುಂಟೆ ಕಪ್ಪನೂರು. ಪ್ಲಾಟ್ ನಂಬರ್ 188. ಇನ್ನೊಂದು ಮನೆ
ಅರ್ಧ ಸರ್.
ಅರ್ಧ
ಭಾಗ.
ಇದೇನು 8,980 8.980.
ಅಲ್ಲ, house number is 8-980. Size is 2006 square feet.
2006 square feet.
2,600 ಚದರಡಿ ಇರೋ ಮನೆ. ಮತ್ತೆ ಮಹಾನಂದ ಏನ್ ಕೊಟ್ಟಾರ ನಿಮ್ಗೆ?
ಸರ್ ಒಂದು 53 ಪ್ಲಾಟ್ ಬಂದದ್ರಿ ಜಯನಗರ
ಜಮೀನು
ಜಮೀನಲ್ಲಿ
ಸರ್ವೆ ನಂಬರ್ 11/2ರಲ್ಲಿ 3 ಎಕರೆ 33 ಗುಂಟೆ ಅಲ್ಲ, ಅದರಲ್ಲಿ 7 ಎಕರೆ ಇದೇನು ಹಿಂಗ್ ಬರ್ತದೆ?
3 ಎಕರೆ 33 ಗುಂಟೆ ಕರೆಕ್ಟ್ ಸರ್.
3 acre 33
7 acres.
out of 7 acres.
ಆಮೇಲೆ ಪೂರ್ವ ಭಾಗದ್ದು ಸರ್ವೆ ನಂಬರ್ 76/2ರಲ್ಲಿ 4 ಎಕರೆ 8 ಗುಂಟೆ. ಆಮೇಲೆ
ಎನಿ ಲ್ಯಾಂಡ್
71/1ರಲ್ಲಿ 1 ಎಕರೆ 20 ಗುಂಟೆ ಪೈಕಿ 25 ಗುಂಟೆ
25.
ಇನ್ನೊಂದು ಸರ್ವೆ ನಂಬರ್ 12/2ರಲ್ಲಿ 1 ಎಕರೆ 20 ಗುಂಟೆ.
ಮತ್ತೊಂದು ಪ್ಲಾಟ್
ಇದರ 30 ಅಡಿ ರಸ್ತೆ ಬಿಡಕ್ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ? ಇದು ಉತ್ತರ ಭಾಗಕ್ಕೆ
ಹಾ ರೀ.
ಇದರ ಪ್ಲಾಟ್ ಇಂದ ಯಾವ್ದು ಹೇಳಿದ್ರು? 53 ಪ್ಲಾಟ್ ನಂಬರ್.
ಹೌದು.
ಜಗದೇವಿ ನಿಮಗೆ ಎಷ್ಟು ಕೊಟ್ಟಾರಮ್ಮ ಜಮೀನು?
ಜಮತಿ ಹೊಲ್ದಾಗ್ರಿ 6 ಎಕರೆ 15 ಗುಂಟೆ ಅದರಿ.
ಇಲ್ಲ 6 ಎಕರೆ ಬರ್ದಿಲ್ಲ ಇದು.
ಇಲ್ಲ ಸೆಕೆಂಡ್ ಅದು ಸರ್.
ಇಲ್ಲ, ಮೊದಲು 2 ಎಕರೆ ಕೊಟ್ಟದ್ರಿ ಇದು.
ಹಾ.
11/3ರಲ್ಲಿ 2 ಎಕರೆ.
ಹಾ.
ಜಮಾತಿ ಹೊಲ್ದಾಗ 6 ಎಕರೆ 15 ಗುಂಟೆ.
ಅದರಲ್ಲಿ 6 ಎಕರೆ 15 ಗುಂಟೆ.
ಹಾ ರೀ.
ಉಪಾಲ್ಗಾಂವ್ ಗ್ರಾಮ.
ಹಾ.
ಮತ್ತೆ ಉತ್ತರ ಭಾಗದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 12/2ರಲ್ಲಿ 12/A ನಲ್ಲಿ 2 ಎಕರೆ 37 ಗುಂಟೆ.
ಹಾ ರೀ.
37 ಗುಂಟೆ.
ಇದರಲ್ಲೂ 30 ಅಡಿ ಜಾಗ ಬಿಟ್ಟದಿರಿ ಓಡಾಡಕ್ಕೆ.
ಹಾ ರೀ.
ಮತ್ತೆ ಪ್ಲಾಟ್ ಎಷ್ಟು ಕೊಟ್ಟಾರೆ?
ಲಾಸ್ಟ್ ಇಲ್ಲ.
ಪ್ಲಾಟ್
ಪ್ಲಾಟ್ 42.
ಒಂದು ಬಿಲ್ಡಿಂಗ್ ಆಡ ರೆಡಿ.
ಪ್ಲಾಟ್ ನಂಬರ್ 42.
ಅದೇ
ಅದೇ ಸರ್.
ಕಂಪ್ರೈಸಿಂಗ್ ಬಿಲ್ಡಿಂಗ್ ವಿತ್ ಓಪನ್ ಸ್ಪೇಸ್.
ಅದೇ ಎಣ್ಣಿಗೆ ಹಣ ಇದೆ.
ಕಾಣುತ್ತೆ ಆಯಿಲ್ ಬಿಲ್ಡಿಂಗ್ ಅದೇ.
ಪುಟ್ಟಲಬಾಯಿ ಎಷ್ಟು ಕೊಟ್ಟದಾರಮ್ಮ ಜಮೀನು?
ಎಲ್ಲ ಎಷ್ಟು ಕೊಟ್ರ ಅಂತ ಕೇಳ್ತಾರೆ.
3 ಎಕರೆ.
ಅಲ್ಲ ಸೆಕೆಂಡ್ ಒನ್ ಸರ್ 3 ಎಕರೆ 12 ಗುಂಟೆ ಸರ್.
11ರಲ್ಲಿ 3 ಎಕರೆ. ಬೇಲೂರಾಗಿರೋ ಜಮೀನಲ್ಲಿ 3 ಎಕರೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮತ್ತೆ ಒಂದು ಸೈಟ್ 40-60.
ಆಮೇಲೆ ಇನ್ನೊಂದು 3300.
ಮತ್ತೊಂದು ಕಪ್ನೂರ್ ಗ್ರಾಮದ್ದು 3300 ಅಡಿ ಮನೆ.
ಇನ್ನೊಂದು 2600 ಸ್ಕ್ವೇರ್ ಫೀಟ್.
ಇನ್ನೊಂದು 2600 ಚದರಡಿ ಅಯ್ಯರ್ವಾಡಿ
ಅರ್ಧ ಮನೆ.
ಮನೆ
ಒಂದು ಮನೆ. ಇನ್ನೊಂದು
ಊರಂದು
830 ಚದರಡಿ ಇರೋದು ಒಂದು ಮನೆ.
ಗಂಜದು ಗಂಜ
ನೆಹರು ಗುಂಜ್ ಕಲಬುರಗಿನಾಗಿರೋದು ಇದು. ಮತ್ತೆ ಜಯಶ್ರೀ ನಿಮ್ಗೆ ಎಷ್ಟು ಕೊಟ್ಟಾರಮ್ಮ? 1 ಎಕರೆ ಸರ್ವೆ ನಂಬರ್ 11A/1. ಮತ್ತೆ 12/A ನಲ್ಲಿ ಎಷ್ಟು ಬಂದಿದೆ? 6 ಎಕರೆ 12. ಸರ್ವೆ ನಂಬರ್ 55/2ರಲ್ಲಿ 2 ಎಕರೆ 36 ಗುಂಟೆ. ಸರ್ವೆ ನಂಬರ್ 96ರಲ್ಲಿ 25 ಗುಂಟೆ. ಸರ್ವೆ ನಂಬರ್ 51/2
ಇಲ್ಲ ಸರ್.
2 ಎಕರೆ.
ಇಲ್ಲ ಅದು ಇಲ್ಲ ಸರ್. ಆಯ್ತು ಸರ್.
2 ಎಕರೆ.
ಇಲ್ಲ ಅದು ಇಲ್ಲ ಸರ್.
ಅಲ್ಲ ಅದು ಇಟ್ ಇಸ್ ಕ್ಲಾರಿಫೈಡ್.
ಅದು not traceable sir.
Not traceable. Hence it is not included in this compromise petition.
Please sir. Yes. Though it was suit property my lord subjected, but it is not traceable my lord at spot.
ಇದೆಲ್ಲ 11 sketch ಮಾಡಿಸ್ಬಿಡ್ಬೇಕ್ರಿ
ಹೌದು
ಜೊತೆಗೆ.
ಸರ್. Therefore we have mentioned sir.
That's what,
10,
you have got a map, my lords, after this decree.
map we have produced my lord along with agricultural lands and
Get it 11.
many ಬಗ್ಗೆ we have produced maps sir as per TPD map. And it is also mentioned in the recitals of compromise, the parties are
ಅಲ್ಲ
measurement ಮಾಡ್ಕೊಂಡು
ಒಂದೊಂದು ಪ್ರಾಪರ್ಟಿನ ಬೇರೆ ಬೇರೆ ಭಾಗ ಮಾಡ್ತಾ ಇದ್ರೆ ಅದನ್ನ ಯಾವ ರೀತಿ ಮಾಡಿದೀರ ಅಂದ್ರೆ 11 ಸ್ಕೆಚ್ ಒಂದು ತಯಾರು ಮಾಡ್ಬೇಕು.
that is correct, sir, my lord. That is required for registration, my lord. ಈಗ ಇಲ್ಲಿ ಇದ್ರಲ್ಲಿ ನಾವೇನ್
That is
ಬರ್ತೀವಿ?
a very important
I agree,
document.
ma'am.
Please do not ignore it.
Please, sir.
Some of your
Correct.
brother advocates had filed a petition. ಇಲ್ಲ they're not necessary hanging.
No, it is must.
I said no, it is necessary. It's very important. ನಾಳೆ ದಿವಸ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಆಗೋದ್ ಬೇಡ ಅಂತಾನೆ ಅದನ್ನ ಮಾಡಿರೋದು.
Even there is also government notification.
ಜಾಗದಲ್ಲಿ ನೀವು 3-4 ಭಾಗ ಮಾಡ್ಕೊಂಡ್ರೆ ಯಾವ್ಯಾವ ತರ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ, ಯಾರ್ಯಾರು ಯಾವ್ಯಾವ ಕಡೆ ಬಂದಿದೆ ಅದನ್ನ ಕ್ಲೀನ್ ಆಗಿ ತೋರಿಸ್ಬಿಟ್ರೆ ನಾಳೆ ದಿವಸ ಡಿಸ್ಪ್ಯೂಟ್ ಇರಲ್ಲ. So 11 sketch is very important. ಮಾಡಿಸ್ಬೇಕು ನೀವು ಇದಕ್ಕೆ.
ಅಲ್ಲಿ ಇದರಲ್ಲಿ ನಾವು we have mentioned, sir, in the terms of compromise, as per this settlement, the parties have agreed to file application, get issued 10 maps, sir, form number 10. They have agreed.
Number 11 sketch.
ಇಲ್ಲ ಅದು correct, sir. Form number 10 ಮಾಡಿದ್ರು it will be 11 ಇದ್ದಂಗೆ, sir, ಅದು ಅವ್ರ ಕಾಂಪ್ರಮೈಸ್
ರಿಜಿಸ್ಟ್ರೇಷನ್ ಹೋದ್ರೆ
Compulsory, sir.
do it without 11
Yes, I agree, sir. That is must.
ಇದೆಲ್ಲ RTCಗಳು ಹಾಕಿದ್ರಲ್ಲ
Case ಅಲ್ಲಿ suit, it is already exhibited.
RTC
Yes, ma'am.
Exhibit ಆಗಿದೆ, sir.
Part of.
ಬೇರೆ ಹೆಸರು ಇರೋದು ನೀವು ಮಾಡಿ
ಇಲ್ಲ, sir. No.
ಕೋರ್ಟ್ ಅನ್ನೋದು ಆಗುತ್ತೆ.
No, my lords, already it was verified and decree has already passed by time.
ಇನ್ನೊಂದು ಕೇಸ್ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿ ಬಂದು ಎಕ್ಸ್ಪರ್ಟ್ ಡಿಗ್ರಿ ತಗೊಂಡು ಅವ್ರಿಗೆ ಯಾವ್ದು ಅಪಿಯರ್ ಎಲ್ಲ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಮಾಡಿ ಮತ್ತೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್
ಇದು ಎಲ್ಲಿ ಇಲ್ಲಿದ್ರೆ ಕೇಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಅದರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಅಂತ.
Memo is filed.
Memo is filed. Withdraw.
The memo of withdrawal. Both counts, ಎಲ್ಲ ಅದಲ್ಲ.
Yes, ma'am.
Both counts.
Vanguntikar. Uday P. Vanguntikar.
Respond number 1 to 6 present.
Yes, ma'am.
Memo for withdrawal is filed. Stating that appellants and respondent number 1 to 6 have amicably settled their dispute in respect of suit seeking properties. Therefore, the appeal filed against respondent number 7 to 10 may be dismissed as withdrawn. The memo for withdrawal is placed on record. Same is accepted. Appeal is dismissed against respondent number 7 to 10. Dismissed as the withdrawn.
ಹಾಕಿರಿ.
ಹಾಕಿರಿ. I filed ವಕಾಲತ್.
ಅವ್ರು ವಕಾಲತ್ ಹಾಕಿದ್ರು.
ಹಾಕಿದ್ದೀನಿ ಇವತ್ತು.
ಸಿಗ್ನೇಚರ್ ಹಾಕಿದ್ರು.
ಆಗಿದೆ, sir.
ಹಾಕಿದ್ದೀನಿ. ಅಲ್ಲ withdrawal ಅಲ್ಲ. I am representing 4 to 6. ಹಾಕಿದ್ದೀನಿ ಇವತ್ತು.
ಅಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಗೆ
ಮಾಡಿದ್ದೀನಿ ಸರ್, ಸೈ ಮಾಡಿದ್ದೀನಿ.
ವಕಾಲತ್ ಕೊಡಿ.
ಇಲ್ಲ ಅಲ್ಲಿ ಕೌಂಟರ್
ಅಲ್ಲ ಫೈಲಿಂಗ್ ದಾಗ ಹಾಕಿದ್ದೀನಿ.
ಆಗಿದಾರಂತ ಆಗ್ಲೇ.
Already filed.
ಕೆಳಗಡೆ ಕೌನ್ಸಿಲ್
5-6 already filed. Today I filed only for this.
I am representing 1 to 3, sir. Uptake.
ಇಲ್ಲಿ 6 ಜನ ಅದಾರ, ಇಲ್ಲಿ 8 ಜನ ಅದಾರ.
ಇಲ್ಲ.
ಸರಿ. ಇನ್ನೊಬ್ರು appellant number 1 to respondent number 1 to 6 are present before this court. On behalf of both parties, the compromise petition is filed under Order 23 CPC. Along with ಇದೇ ಪ್ಲಾನ್ ಇದೆ.
ಅವು ಹೊಲದ್ದು ಪ್ಲಾನ್ ಸರ್. ನಾವೇನ್ ಹೇಳಿದ್ರೆ ಸರ್ ಹೀಗೆ 11 ಬಗ್ಗೆ ಅಂದ್ರಲ್ಲ ಸರ್, ಅವು 11 ಬಗ್ಗೆ ಟು ಅವಾಯ್ಡ್ ಅಂಬಿಗ್ಯೂಟಿ ಸರ್, ದಟ್ ಮ್ಯಾಪ್ ವಿ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್.
ಅಲ್ಲ ಬಟ್ ಇದನ್ನ ಯಾರು ಮಾಡಿರೋದು, ಯಾರು ತಯಾರು ಮಾಡಿರೋದು ಇದನ್ನ?
ಇದು 11 ಟಿಪ್ಪಣಿ ಪ್ರಕಾರ ನಾವು ಮಾಡ್ಕೊಂಡಿವಿ ಸರ್.
ನೀವು ಮಾಡ್ಕೊಂಡಿರೋದು?
ಟೋಚ್ ಮ್ಯಾಪ್ ಪ್ರಕಾರ.
But it has to be done by
I agree, I agree, my
licensed surveyor.
Your lordship is right.
Prepared by the appellants.
Parties.
Partition. Pertaining to house property. 8-980.
ಅಲ್ಲ ಹಂಗ್ ಬೇಡ.
ಅದೇ ಬೇಡ.
Plots showing the manner of division of each item of the social property.
Copies of Aadhaar card.
ಹೌದು ಸರ್.
ಎಲ್ಲರೂ ಆಯ್ತು.
ಎಲ್ಲ ಸರ್. Total item.
The contents of compromise petition. Read over and explained to the parties. In the language known to him, that is in Kannada language. ಇದ್ರಲ್ಲಿ ಅದೊಂದು ಸೆಂಟೆನ್ಸ್ ಬರುತ್ತೆ.
ಅದಕ್ಕೆ ನಾವು ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ಸರಿ. Explained by read over. The contents of the compromise petition. Has to be partition effected between the parties. As per the compromise petition are accepted on their own volition. Then same is accepted. Accordingly, proceed to pass the following order. Compromise petition filed under Art 23 CPC is allowed. Compromise recorded. This compromise petition shall be part of the decree.
Compromise petition malad including maps and madam. Compromise petition including maps.
Including the
ಬಂತಲ್ಲ
maps.
Shall be part of.
Parties are sign ನೀವು identify ಮಾಡಿ.
One more submission. Serial number 42. Parties are directed to appear before the court. Last time you given the
Margin is this,
proposal you have given. But you ನಮ್ಮ parties
The last time.
Margin is this.
respondents daughters present before the court. ಅವ್ರು ಬಂದಿಲ್ಲ ಏನೋ ಹೇಳ್ತಾ ಇಲ್ಲ. Not coming forward.
Our total extent ಅಲ್ಲಿ sir, we want to retain.
ಆಯ್ತು ಇವ್ರನ್ನ ಕಳ್ಸ್ಬಿಡಿ ಇದಾಯ್ತಲ್ಲ.
ಆಯ್ತು. ನೀವು
ಇದಾಯ್ತಾನೆ ಇದು.
ಸಹಿ ಮಾಡ್ಬೇಕು.
ಪಕ್ಕ ಕೂತ್ಕೊಳ್ಳಿ. ಇನ್ನೊಂದು ಯಾವ್ದು ಹೇಳಿದ್ರಿ ನೀವು?
42 sir. Last date now compromise is a total 36 and odd acres of land. Out of that, we want to retain 17 acres, sir.
Yes.
I mean, 16 acres all guntas, we want to give to the share of the appellant, sir. And though they are born from the second wedlock, sir. And apart from that, there is one tractor and one car is there. One house property is constructed double story. These are all properties also there that are not the subject matter of this suit, sir. But, other side.
ಎಲ್ಲಿ ಇವರು ಸಚಿನ್
ನಾವು ಲಾಸ್ಟ್ ಡೇಟ್ ಹೇಳಿದ್ರೆ ಸರ್ ಮಾಡ್ಕೊರಿ ಅಂತ.
ಏನಾಯ್ತಮ್ಮ?
One date may be fixed.
ಅದಕ್ಕೆ ನಾವು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು ಹೋದ್ವಾರ ಬಂದಿದ್ ಮ್ಯಾಟ್ರ್. ಏನಂತ ಕೊಳ್ಳಿದ್ವಿ?
Legally, they are entitled for very less of the property, sir. Or if one second wife in view of Siddhappa case, sir. Second wife children.
ಎಲ್ಲಿ ನಿಮ್ಮ ಪಾರ್ಟಿಯಲ್ಲಿ?
Party with band. ಬಂದಿಲ್ಲ.
ಅಲ್ಲಮ್ಮ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ರಾ? ಅದಾದ್ಮೇಲೆ
ನಮ್ಗೇನು ಹೇಳಿಲ್ಲ ಸರ್. ನಮ್ಗೇನು ಹೇಳಿಲ್ಲ. ಲಾಸ್ಟ್ ಡೇಟ್ ಅವ್ರ ಎದುರೇ ತಾವು ಹೇಳಿದ್ದು ಸರ್ ಹಿಂಗೆ.
Next week any.
ಇವೆಲ್ಲ ಬೇಗ ಸೆಟಲ್ ಮಾಡ್ಕೊಡ್ಬೇಕಮ್ಮ. ಡಿಲೇ ಆದ್ರೆ ಮತ್ತೆ ಯಾವಾಗ ಯಾರು ಬರ್ತಾರ ಯಾವಾಗ ಏನ್ ಮಾಡ್ತಾರೋ ಸುಮ್ಮನೆ ಅನ್ನೆಸರಿ.
Thursday.
First week, any date may be given, sir.
Thursday,
First week, sir.
Third, fourth.
week,
Third,
2nd of December.
Second, third, any date, sir.
Second or
Second, third.
third.
Second should be.
At the request of learned counsel for the appellant,
Second,
release this matter on 3rd of December.
please, sir. Appellants, respondents, sir.
ಇದು the respondent daughters
Yes, sir.
are present before the court. However, ಅಂತ ಹಾಕಿ at the request of ಅಂತ ಹಾಕಿ.
Much obliged.
My lord, on submission, my lord, sir. Serial number 34, my lord, I am the respond number 3, my lord. Some internet connection, some problems, my lord. What? Respond number 3, my lord, serial number 34, my lord, sir. I am the R3, my lord, sir. Proceedings.
ಏನಾಗ್ಬೇಕಪ್ಪ?
Adjournment ಬೇಕು sir.
ಆಗಿದೆಪ್ಪ ಆಗ್ಲೇ.
Please, grateful, my lord. Court officer, sir. Court officer, sir.
Sir, 2nd December ಅಂತ ಆಗಿದೆ ಸರ್.
Sir.
2nd December.
Okay, thank you, sir. Thank you very much.
Yes, sir. Yes, sir. Yes, yes, yes. Yes, sir.